Welcome to the fourth hearing of Portfolio Committee number 5, Justice and Communities, for the additional round of inquiry into Budget Estimates 2023-24. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the lands on which we are meeting today. I pay my respects to elders past and present and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today. My name is Robert Borsak and I am the Chair of the Committee. I welcome Attorney General Daley and accompanying officials to this hearing. Today the Committee will examine the proposed expenditure for the portfolio of Attorney General. I've asked everyone in the room to please turn their mobile phones to silent. Parliamentary privilege applies to witnesses in relation to the evidence they give today. However, it does not apply to what witnesses say outside of the hearing. I urge witnesses to be careful about making comments to the media or to others after completing their evidence. In addition, the Legislative Council has adopted rules to provide procedural fairness for inquiry participants. I encourage committee members and witnesses to be mindful of these procedures. Welcome and thank you for making the time today to give evidence. Attorney General, I remind you that you do not need to be sworn, as you have already sworn an oath to your office as a Member of Parliament. Most witnesses do not need to be sworn as they have appeared at an earlier budget estimates hearing before this committee. For those witnesses who need to be sworn, as I call your name, could you please state your name and position title and swear either an oath or an affirmation? First we'll start with Mr. Chris Daith.
Chris Daith, Acting Deputy Secretary, Courts and Tribunals and Service Delivery. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Dr. James Cockayne.
Dr. James Cockayne, New South Wales Anti-Slavery Commissioner. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Ms. Sally Dowling.
Sally Dowling, Director of Public Prosecutions. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Today's hearing will be conducted from 9:15 till 5:30 p.m. We are joined by the Attorney General for the morning session from 9:15 till 1 p.m. with a 15-minute break at 11 a.m. In the afternoon we will hear from departmental witnesses from 2 p.m. till 5:30 with a 15-minute break at 3:30. During these sessions there will be questions from the opposition and crossbench members only, and then 15 minutes allocated for government questions at 10:45, 12:45 and 5:15 p.m. We'll begin now with questions from the opposition.
Morning, Minister.
Morning, Ms Carter, how are you?
Good. Your colleague, the Honourable Penny Sharp, answered a question from the Honourable Mark Banasiak in February this year in relation to the North East Foreign Alliance and Commonwealth of Australia case, and she noted that even though she was on actual leave, she had participated in a number of meetings with other ministers planning for the outcome of this case as, quote, "It was a significant court case and governments need to be prepared for all outcomes related to that." Do you agree that an important role of government is to monitor legal changes and be prepared for all outcomes?
Oh, yes, I agree with that.
And as Attorney General, you have a role in assisting your government to monitor important matters before the courts?
I do.
And are you aware of the High Court decision in NZYQ and the Minister for Immigration, Citizenship and Multicultural Affairs?
I am.
And were you and other senior members of the government also watching this case?
Watching in what sense?
Well, were you preparing for the outcome of this case and possible impact on community safety?
I'm not sure what your question goes to. Could you elaborate a little bit for me, Ms Carter,
Well,
please?
Minister, you would be aware that the applicant in that case, Mr NZYQ, is a convicted child sex offender in New South Wales, likely to make his home in New South Wales upon release. So how did you monitor and plan for the outcome of this case to protect community safety?
Well, I'm not sure that your question is well founded in that regard. This was a case that involved the Commonwealth in relation to the Commonwealth's powers. No state in Australia intervened in that matter under Section 78B, and that's all I can
So
really
Minister,
tell you.
the East Forest Alliance case concerned trees in New South Wales whereas the NZYQ case concerned the possible release of a convicted child sex offender, and one concerns your government and the other does not?
I'm not sure you can make a correlation between those two cases, except for the statement of Ms. Sharp and my agreement today that it's, my role generally to oversee matters that are before
Well, Minister,
courts and
were
there.
you aware that NZYQ, after pleading guilty in the district court to sexual offence against a child, was sentenced to 5 years imprisonment, non-parole period of 3 years, 4 months? Upon completion of his custodial sentence and released to parole, he was taken into immigration detention. Are you aware of what conditions were placed on parole for NZYQ?
No, the Attorney-General does not get briefed on the many hundreds of parole conditions that
I would understand that.
No,
Would
no,
you-
just sorry, let me
Yeah.
answer the question. I won't fluff, I won't waste your time, so don't interrupt me, please. The Attorney-General does not get briefed on parole conditions in relation to the many people upon whom parole conditions are imposed, and you know that, Ms. Carter.
Would you believe it would be a usual condition, given the nature of his offending, that he was to continue with some psychological counselling or treatment in relation to those sex offences?
You're asking me what would that be a usual condition? I'm not
Yes.
sure I can answer that question. What's a usual condition?
What I'm asking you is, if he was on parole when he was taken into immigration detention, and if, as would be entirely usual, there were conditions placed upon that parole, conditions that would not be able to be met because he was in immigration detention, would it not be then that his parole could be revoked? And if you had a watching brief on this matter, is it not true that he could have been picked up immediately upon release from immigration detention and taken into custody because of the breach of parole? Were you watching this, Minister?
No, your presumption that I should have a watching brief on people in immigration detention or in prison with a view to their parole conditions is not well founded. I do not do that. Attorneys General do not do that.
Minister, we've discussed that your government had a watching brief on a case about what was happening in forests. Is it not also appropriate that your government has a watching brief on community safety?
That wasn't the question you asked me. The question
Well,
you
I'm
asked
asking
me
you that
was-
question now.
The question you asked me, Ms.
I'm
Carter, was
asking you
whether-
that question
was
now,
whether
Minister.
I
Can I
had a
redirect
watching
to that
brief.
question?
Okay, and so I didn't have a watching brief. People who do have watching briefs on parolees is the Department of Corrections.
And as the lead minister in the DCJ cluster, were you working with the Corrections Minister and others for a whole of government response to this
There
case?
are no lead ministers in the in DCJ anymore in terms of hierarchy of ministers. Each minister is responsible for their own statutory responsibilities, and the statutory responsibility for parole does not fall with me. You know who it falls with.
And do you work with your colleagues for a combined whole of government response?
What does that mean?
Well, does it mean that if there is a very significant case which would permit the release into the community of a convicted child sex offender who had yet to complete his parole conditions, does this mean it is an appropriate role for government to monitor this and then to be able to detain that offender till an appropriate solution for community safety can be found?
If there are parole conditions imposed upon someone and they are released into the community, the Department of Corrections does, in your words, keep a watching brief on those people, and they do supervise them when they come out into the community, yes.
And was NZYQ subject to parole supervision when he was released from immigration detention?
I can't talk about individual cases, and I don't know the answer to that because I'm not the Minister for Corrections.
I would suggest, Minister, that there's no evidence that that happened at all. And in fact, what I'm
Then
putting
why
to
ask
you...
me the question?
Because what I put to you was not that he was going to be supervised on parole. I put to you that he was in breach of his conditions and therefore could have been immediately picked up and placed in detention again to protect community safety. And I put to you, who's watching for community safety in your government?
It depends on the status of the person. If they are on the Child Protection Register, for example, when they're released into the community, they're watched by the police. If they are a parolee, they are monitored by the Department of Corrections. If they are the cohort of people who were in immigration detention and they are released into the community. Australian Border Force has a responsibility for them. If they are on extended supervision orders, there's a regime for them. So it depends. You're asking me a general question about a general species of people that are released into the community. There's no such thing. It depends on what orders the individual person is subject to.
I was asking you a general question about community safety, but thank you, Minister.
Community safety, when it comes to parolees, is guarded by the Department of Corrections, who do a very good job of monitoring those people.
Thank you, Attorney General, and also to everyone here today. Attorney General, you'd be familiar with the decision of Cavaldi versus the State of New South Wales?
Not off the top of my head.
In Cavaldi, the court considered the validity of Section 214A of the Crimes Act. In the second reading debate about this provision, you observed on the 30th of March 2022 that this was legislation for the common good and for the majority of the people, and that, and I quote, "The only question before us tonight is whether the limitations in this section are justified." That is the overarching question. As is always the case when a parliament seeks to extend or deprive the liberties of citizens, the bill is about striking the right balance. And given that you and all your Labor colleagues voted in favour of this legislation, you clearly took the view that Section 214A struck the right balance between allowing peaceful protest and protecting freedoms of movement of non-protesters. Were you surprised then that the court did not consider the right balance had been struck and declared that so far as Section 214A(1)(c) criminalised closure of part of a major facility, that it was in permissible burden on political communication?
I'm sorry, I'm aware of that case. I just thought it was pronounced differently, so that's what threw me. I
apologise for that.
Case. So, sorry, that was a long question. Can you just be...
My question pertains to Section 214A and whether or not there has been the right balance has been struck, considering the court did not consider that was the case.
Whether the right balance has been struck by the court?
Yes, in relation to this section, which was amended, the court declared that the right interpreted that the right balance had not been struck.
In the drafting of the legislation, in the passage of the... Okay, yeah. Look, why don't I just answer it this way, Ms McLaren-Jones. We supported that legislation because we saw some of the behaviour that Extinction Rebellion and other, mainly climate protesters, but not all, were bringing upon the city, and the promise that Extinction Rebellion had made to shut the city down. So we saw outrageous behaviour, like people stopping vans in the Harbour Tunnel and blocking traffic. We saw that replicated again this week in Melbourne. We saw people gluing themselves to Stony Creek Road, chaining themselves to portainers in Port Botany and shutting all or part of that facility down. And we agreed with your government, the government of the day, that a balance should be struck between allowing citizens the right to peaceful protest and assembly, and not allowing them to go so far as to shut the city down and burden other citizens. So we supported that legislation. Justice Walton in the Supreme Court heard the appeal against both Section 214A of the Crimes Act and against Regulation 48A of the Roads Regulation. He completely dismissed the challenge to the road regulation. So I did hear yesterday that that judgment now made it okay for people to block 7 or 8 lanes of the Harbour Bridge, block the Harbour Tunnel, and now because of Justice Walton's decision they're able to do that. Can I just say for the record, that is not the case. The application of the new laws so far as they relate to a main road, a highway, a freeway, a tollway, a bridge or tunnel that adjoins any of them, or entering on, remaining on, climbing, jumping from or trespassing on any part of the Harbour Bridge or any major bridge, tunnel or road, that all completely survives. None of that was impugned. The only thing that the judgment went to was sub-clauses 1C and 1D of section 214A of the Crimes Act, which deals with the disruption to major facilities. So the lion's share, the overwhelming content of the laws as a whole that were passed by Parliament survived that challenge, and that's a good outcome.
The decision of this case was a single judge decision of the Supreme Court handed down on the 13th of December 2023. The decision struck down two aspects of the almost unanimous legislation, namely the conduct is not unlawful if part of a major facility is caused to be closed, which you refer to, or if the conduct causes a person's attempting to use the major facility to be redirected. That means that 6 of the 7 lanes on the Harbour Bridge is seen to be okay.
No, it's not. That's not
It
true.
also means that if the Harbour Bridge access is blocked and people can be redirected to the Harbour Tunnel, then that it's not
That's
a criminal
not true.
offence.
That is not
Do you
true.
agree with it?
That is not true. No. The Harbour Bridge is specifically mentioned in section 144G of the Roads Act. It does not come into the purview of section 214A of the Crimes Act.
So it's not seen as a major facility?
No, it's got its own specific legislative treatment in the Roads Act and the Roads Regulation. Any accusation or assumption that the Harbour Bridge and the Harbour Tunnel or any main roads or highways or bridges or any of those species of infrastructure, main road, highway, freeway, tollway, bridge or tunnel in the Greater Sydney region or the City of Newcastle or the City of Wollongong. For example, it says in the legislation, the Spit Bridge across Middle Harbour or the Harbour Bridge, any suggestion that they are now more prone to be attacked, if you like, by protesters is completely and utterly untrue.
Yeah. But if this decision is left to stand, then there is significant impacts for the community for allowing these protesters to continue without any criminal sanctions.
That's not true. The absolute majority of section 214 capital A survives. So a person must not, so in subsection 1, a person must not enter, remain on or near, climb, jump or otherwise trespass on or block entry to any part of a major facility if that conduct causes damage to the major facility or seriously disrupts or obstructs persons attempting to use the major facility. All that survives. It just relates to the closure of parts of facilities, and we have to wait and see how that pans out in the future in relation to how that judgment affects protests going forward. But so I'm satisfied that the legislation in its original intent to prevent the behaviour that I've described today still does the job.
So the 28-day period is now over for appeal. Did you appeal the decision?
No, I did not.
Why not?
Because, as I said, I'm satisfied. What we wanted to do was to make sure that the behaviour that Attorney General Speakman outlined in his second reading speech, the behaviour that we all witnessed, the outrageous and unacceptable behaviour of blocking the Harbour Tunnel, gluing yourselves to Stony Creek Road, all these ridiculous things, these threats to close down the entire city, they were the behaviours that this legislation was crafted to prevent. It survived, firstly, including, as I said, all of the roads, aspects of it. There's a review of the legislation coming up. I think, from memory, that was supposed to begin about 2 years from the passage of the legislation, which won't be very long now. So there's a review coming up.
Do you have a date for that review?
No, I don't. The statutory review is due to start on the 24th of April.
And how long would the review take?
6 months.
6 months?
6 months.
Okay. Thirdly, after looking at the judgment carefully, and it's a long judgment, I have to say, and not all that easy to understand. I have to read passages of it a few times to understand what His Honour meant. Having taken the necessary briefings on this important matter, as you expect me to have done, I was also alive to the possibility that if I appealed, it would have reopened the contest, the question, if you like, in the court of not only the Section 214 of the Crimes Act, but the roads regulation as well. So to put it in simple vernacular, we might have lost the roads regulation as well. And that's not to say that that might not happen at a future date. There's still anyone can still appeal this. So the risk if I appealed was that we ended up with far less than what we've got now. And given all of those things I've just said to you about what the legislation still does, in its overwhelming majority, I decided not to appeal. There is a possibility at a later date, given what might be said coming out of the review, that we could legislate to improve it further. We can't, of course, reinsert the provisions that were impugned by the Supreme Court.
Minister, could I just jump in?
No, just let me, I'm nearly finished, Ms Carter. So it was the most prudent thing to do was to not appeal.
Minister, I'm just uncertain because the appeal essentially struck provisions down as unconstitutional. So how does a statutory review deal with a declaration that matters are unconstitutional?
It doesn't. I didn't say that.
But, sorry, what I heard you say was that you were going to review and possibly amend the Act, especially if there were
No, I didn't
problems
say I
going
would
forward.
review and amend the Act. I said it would be
Well,
open.
what's the purpose of the
It would be
statutory
open.
review if there's no amendments flowing?
Well, ask Mr Speakman.
Well, I'm
He's the
asking
one that-
you
no,
with respect to Attorney
the
General.
Parliament.
It's your statutory review.
No, it's not. It's the Parliament's statutory review, and it was put in by the Parliament because it was a new and controversial legislation, and so the Parliament had a view that it should be reviewed after 2 years.
But it cannot address the constitutional issues which could have been addressed on appeal.
I've just told you why it didn't
I
appeal.
understand, and I'm asking you about the
So
constitutional issues
the
which remain
statutory review
unresolved.
considers the policy intent of the legislation and how it's working, and it'll enable us to consider how the provisions are working and what, if any, amendments are or may be required.
But it still leaves citizens in your electorate vulnerable to a blockade of Port Botany.
I wouldn't say that at all.
Partial closure of a facility like Port Botany.
I'm satisfied that the legislation survives and can still do what it was designed to do. And we've seen since then a blockade of a part of Port Botany, and the police used other powers that they have under the Summary Offences Act to break up that gathering, which was unlawful. So this is not the only string in the bow of the police. There are other measures that they can use as well. And they did, in fact, break up and move on a gathering at Port Botany that was not sanctioned under Part 4 of the Summary Offences Act.
Thank you.
Good morning, Attorney, and everybody else. Thank
Hello,
you
Ms.
for being
Higginson.
here. I just wanted to clear one thing up on that, if it's all right with you,
You
Attorney.
can clear
and
anything up you like.
that is one that clearly when the Supreme Court of New South Wales declares something unconstitutional, it would be almost absurd for a government to then go and appeal that finding. So, I think that at this point in time, I commend you on the action today.
I'll take support anywhere I can get it in this room, Ms. Higgins.
That's
Thank
right.
you.
That's right. And the other thing I wanted to point out, Attorney, is the case that was referred to, the North East Forest Alliance versus the Commonwealth in the state of New South Wales. That was not a case simply about trees. It was about the arrangements between the Commonwealth and the state governments. So whilst the subject matter did involve trees, it was a case that Minister Sharp, rightly, was very cognisant of, because it could have literally changed the arrangements between the Commonwealth and state government in how we manage the environment. But, the Attorney, what I wanted to talk to you about briefly is about young people and the age of criminal responsibility.
Yep.
And I'm sure that's no surprise to you. But, Attorney, I note your comments today in the Daily Telegraph. Begrudgingly to myself, I read it, and I note that you have made a clear statement that the current systems aren't working when we're looking at young people, crime, and the assertions that young people, that the court system is failing, that police are getting it right, the court's failing. But I just wanted to bring you to the fact that when we last met, we talked about the Attorney General's the Standing Council of Attorney Generals. I note that in the December meeting, it's very clear to everyone, Attorney, there's no journey of nationalisation or harmonisation. Everybody's gone their own way now. What are you doing, Attorney?
Well, to be completely honest with you, we are a long way from raising the age of criminal responsibility in New South Wales.
Why is that,
So-
when you look at the evidence, Attorney? Why?
I did. So if you go back, Ms Higginson, and have a look at all the comments I made in this room in November, was it November or October? Well, anyway, the last estimates, those comments still stand in their entirety. And I did point out to you at the time that raising the age that's the easy bit. I could do that tomorrow. Tasmania have declared, as I understand it, that they're going to do it in 2029. Now, that's easy. We can have Parliament pass a law tomorrow to raise the age of criminal responsibility. But what will that mean? That will mean that a young person, 13 years of age, that is arrested by the police for some wrongdoing, can't be brought before the courts, but should be sent to some other diversionary program. And I hope one day we'll get there in New South Wales in terms of having the diversionary programs.
How many young people, Attorney General, are in custody at the moment under the age of 16?
I can get you that.
Well, I just wonder if you know what we're talking about, basically.
Well,
that's
I do,
my question.
Because we went through this on the last occasion, and I pointed out to you that raising the age is the easy part. It's the diversionary treatments that are the hard part. And in New South Wales, they don't exist. And I don't want to get political here, but the former government made a decision.
So, Attorney, is it your proposition then that because you don't have currently, in your view, the right support systems in the community, that we should just keep locking up kids under the age of 16, under the age of 14?
What I've asked the department to do is to go and work with other departments in government to look at...
Attorney, how much does it cost each year?
Just hold on. It's okay.
Point of order.
I'm just reading.
Point of order.
Point of order has been taken.
It's with great reluctance I take the point of order, but the member is talking over the attorney in the answer that he's provided.
To the point of
No,
order.
I haven't
Hang on.
finished.
Hang on,
If
let
you
him
wish
finish.
to redirect,
It's my time.
well, if you wish to redirect,
What's it cost?
you're entitled to do so, but you need to indicate that. If you haven't indicated that, the attorney is entitled to assume it's the question presented to him that he's answered, and he's entitled to be provided with respect and the opportunity to answer it.
To the point of order.
To the point of order, I will redirect. I will state I'm redirecting when I'm clearly redirecting.
The opportunity to redirect should be available to a member, but not before
come on.
the attorney has been afforded even an opportunity to answer the first question that was asked. You asked a question, he barely got 2 words out of his mouth, and then you redirected. It just seems that that's clearly contrary to the procedural fairness ruling of this committee.
Well, I think the member should redirect if she want to, but please give the attorney a chance to answer the question. If he desires that he actually wants to answer the question, because he can answer the question any way he likes or not answer.
Thank you, Chair.
I forgot what the question was now.
So have I now. So if we could go back to the fact that... Oh, I know what the question was. And the question was, Attorney, do you know how much it currently costs?
No, the question before that, which I was answering, which is really important, what was the gist of that question?
I was referring to how many young people are currently under the age of 14 incarcerated in New South Wales.
Before
and
that,
and
I
are you aware of the
before
cost?
That I was talking about the work that I had asked my department to do in this regard. Would you like to know about that or not?
Certainly.
So what I've asked the department to do is to go away and work with other departments to see, to come back and tell me and other ministers the sorts of measures that could be and should be put in place to deal with these children. what that would require government to do, how many people we would need to work in those facilities, what type of people, the construction of buildings that would be required, transport, all of those things across the state to address these issues in communities across the state.
Thank
So
you. And
I'm
how long
asking-
will that take? What's your time frame?
I haven't given them any particular time frame, but I expected it would be back within a year, and I asked them if mid-year, so probably mid-2024 or a little bit after.
And is that what your response is referring to in the Daily Telly today, where you say things aren't working and you're doing things about it? Is that what you're doing?
That's one of the things, yes.
And so in the meantime, we'll just carry on locking young people under the age of 14 into correction centres when we know all of the evidence is, not only is it not working, it's hurting young people, it's hurting families and it's hurting communities. And let's be real, the overwhelming representation of those young people is they are young people who are First Nations.
That's right. But in all of these considerations, there is one paramount consideration, Ms Higginson, and that is community safety, above all else. And the government will make no apologies for, in this sphere of discussion and subject matter.
Attorney, can I just redirect you to that point?
Community safety is our number one consideration.
And so, Attorney, how is 80% recidivism rate community safety? This is just not in earnest, Attorney. It's not.
Well, so your contention is that we should raise the age of criminal responsibility and let the children back out onto the street. There's a discussion in the Telegraph.
They're back
today.
out on the streets, Attorney, and they are reoffending.
Yep.
The rates are 80%. The evidence is clear to raise the age to be the primary driver to change the system.
No, the primary driver.
How can you
primary
continue
driver,
in the face of the evidence, Attorney?
The primary driver to change the system is to make sure that there are programs on the ground that stop the intergenerational hopelessness and destruction. Some of these kids are born into completely dysfunctional families and they have absolutely no chance from the day they're born.
So your answer is to keep locking them up and criminalising them?
Well, community safety is paramount, and sometimes there are occasions, many occasions, where for the sake of the young person and the community, given that there's no treatment facilities to send them to, that it is better that they are incarcerated for their own safety and the safety of the community. But I'm hoping in time there will be facilities to take these children to so they can get drug and alcohol treatment, counselling, that they can deal with the fetal alcohol syndrome that they're born with, and all the raft of very deep-seated issues that have caused them to offend in the first place. Until we get governments to be serious about early intervention and addressing the social drivers of crime, all that's happening is that government after government kicks this can down the road.
So,
and
Attorney, can I just interrupt,
for
please?
future generations.
So your plan, correct me if I'm wrong, your plan is to spend 12 months looking at all the things that most people already know, and then you will raise the age in 12 months' time? Is that your plan?
No, I'm making no warranties at all about any plans this government has to raise the age.
So your government will not be raising the age?
I will do the work, but we're a long, long way from having any serious discussions about raising the age in New South Wales. A long way.
No, it's Mr. Sorry, Ms.
Mahale?
Tanya. Yep.
Yep.
And in the meantime, I'll get you the figures for how many children are incarcerated. Or
I think it's 228, Attorney. Thank you.
Minister, there wouldn't be anyone incarcerated under the age of 12 in any event.
Yes, there are.
We'll ask for those. Ms Higginson's asked for those.
We'll get the exact figures. Look, can I just ask you just a couple of quick questions? Minister, there's been, I'm just wanting to reference, if I can reference you to some reports recently in the Australian in relation to what seems to be an ongoing situation between the ODPP and a number of judges that are raising concerns about the credibility of some of the evidence that's being presented before courts in relation to a number of sexual assault cases. Have you had any briefings in relation to this? Particularly I'm referring to the Martinez case. your office?
Yes, I am watching these discussions.
I mean, it seems at the moment, Minister, that there's actually, at the moment, Minister, it appears that there's some very vocal and public discourse between a number of judges in New South Wales and the ODPP, the DPP herself. I know she's present here, but I'll forward her some questions later. But and it's resulted in the DPP actually issuing a statement back in December in response to a comment that a particular judge made in relation to a case. I'm just wanting to know your view on the matter and whether you've had briefings of the DPP as to what precisely is going on here and why this dispute between a number of judges and her office has now become public warfare.
I don't agree. I don't agree that it's public warfare. There are a small number of cases, a small number of judges who have raised.
Well, there's been 5 in the last
raised
year alone. Is that
raised
right,
these
Minister?
issues.
There's been 5 that have raised concerns about the type of evidence that's been brought.
And I think, correct me if
before
I'm
their
wrong, but there are
courts.
about 3,000. I'll
What,
withdraw that.
3,000 sexual assault cases? Is that what you're saying?
Over 1,000 matters that proceeded to judgment in the district court, so it's a small number.
But it's
Now,
highly
however-
irregular, Minister, wouldn't you agree, Attorney General, wouldn't you agree that you're now having such a public discourse where judges are making very pointed comments to the DPP in their judgments and in return, the DPP then it makes a public statement, and now you've got statements being made to the Australian, anonymous statements of staff being concerned about some of the actions that are taking place within the DPP office. Does that not alarm you that perhaps there needs to be some intervention?
Well, intervention of what type?
Well,
You see
you're
that-
the lead law officer of the state. I would be concerned that there's a very public
Well,
the
all
public,
judgments. All
and it
judgments
is
are
warfare. I
all-
mean, it's
that's-
unheard of for a DPP to make a statement in relation to the credibility of a judge.
Well, you might like to put those questions to the DPP. As I said,
Well, I will in the afternoon.
There's a small number of cases. Judgments, by their nature, are always public, and the DPP is an independent statutory office holder, not subject to my direction.
But you must be hearing a
judges-
lot of concern within the legal fraternity right now.
Can you let me answer the
there
question?
perhaps needs to be some sort of intervention.
Of course, are independent as well. So they have the right to make whatever comments they wish to in respect of matters
I agree,
that are brought
Minister,
before
without fear of any retribution or any further commentary from the DPP. I'm surprised that a statement was issued by the DPP in December in response to a judge's comment after a particular case, and you're not involved in this as the Chief Law Officer of the state. You're not concerned that there's an open public warfare going on between
I don't
judges
consider
and
it to be
the
public
DPP?
I don't consider it to
Well,
be
it is when
public
it's in
warfare.
the public domain, and now you've got people backgrounding the Australian that they've got concerns as well about the office and how what's the commentary meritless cases are being brought before the courts.
Yeah, so you can ask the DPP about whether she considers that the cases were meritless.
Okay,
And
well,
it's open to the DPP when a judge makes a public statement to issue a correction or an explanation or a clarification. It's open to...
well, how often does that
single-
actually happen? How often does that happen?
I don't keep statistics on that. We can...
Well, can you let me know? I'd like to know how many times in the
Well, you
last
might- yeah, you can
5
ask
years.
the-
On
well, you-
notice, I'll put it to you on notice. If you
well,
can give
you
me
can
that
ask the
later.
DPP that either now or this afternoon.
Well, the DPP, the current one's only been there since 21, so I'm just asking, in the last 5 years, if your office can provide me with some information on how many times does a DPP make a public comment in response to a judge's...
If we can, yeah, happy to do that. If we can, we will. Yeah.
Yep, that'll be great.
Sure.
Okay, thank you, Minister. Can I just also ask you a couple of quick questions just about the Equality Bill? Where is that up to now? It's still with you in the office, or this is Alex Greenidge's Equality Bill?
The government's considering our position on it.
Okay. Do you have any time frame on when you think that response will be made publicly available? It's been in the public domain now for about 9-10 months.
Sooner rather than later, but we want to make sure we get it right. It's important.
Well, what do you mean by getting it right,
make
Minister.
sure that we listen to stakeholders and come to an informed position on our view on it and
Okay.
its
Well, a number of
many
parties have already
iterations.
made an informed decision. My party, One Nation, certainly opposing it. I know the opposition is opposing it. So it's been in the public realm now for about 10 months, and it's caused a lot of concerns to a number of stakeholders. I would have thought by now you would have met with the stakeholders and a decision should be forthcoming.
We've met with many stakeholders, and the decision will be forthcoming sooner rather than later.
Okay, but you're not going to let me know what that decision is now?
I can't. I don't know the answer to that question.
Do you agree with any aspects of that legislation?
You'll have to wait and see. It's not our bill. It's a private member's bill.
It is a private member's
and
bill, but it's something that
So-
the
so
Labor
I-
Party has to make a decision on. Are they going to protect religious places of worship and religious institutions? Are they going to protect parental rights? This bill tears everything up. We know that, Minister.
Okay, that's a nice
Social
statement.
engineering.
That's a
That's
statement
worst.
you've done well. You've got that on the public record, Ms. Mahaley.
I'd like to know what your thoughts are on public record.
My thoughts are Cabinet's thoughts, and Cabinet will express its thoughts when I
I
stand
just
up
feel
to
that
lead for
what the
the
Labor
government.
Party does is just pussyfoots around with these type of bits of legislation coming from independents and not make a clear statement right from the get-go that it's not on this type of social engineering.
Okay, you've done well. That's two public statements you've got on the record now.
Yeah.
With no
Okay.
question marks at the end of them.
All right, well, I'll go back to the DPP if you're more comfortable with those questions.
Sure.
Minister, you didn't look very comfortable before, that's why I moved on to a topic that you might be
Oh, no,
ready
you're
for
very
me.
charitable, thanks.
Very charitable. You didn't look very comfortable. I've got a whole series of questions.
No, you asked me
in
the same
relation
question
to that.
5 times. I was getting a bit frustrated, that's all.
Okay. All right. What about the conversion bill? Where's that up to now?
Same answer as to the equality bill.
Another independent social engineering bill, and we're still waiting for the Labor Party to make a decision on where they
That's
stand
3
on that
statements
bill.
now you've got on the public record.
Weren't you
You're
going
doing
to
well.
weren't you going to bring your own legislation forward? We had this discussion back in November,
We
didn't
did.
we?
Yes, we
And you
did.
said it was in a week's
It
time.
was,
I think
and then-
you teased the committee by saying it was going to come up in a week.
No, I was waiting for
Remember?
I was waiting
And
for
there was nothing.
instructions.
Nothing's come up. So you're
That's
waiting
right.
for instructions?
No, I was at the time waiting for instructions about what the timing was.
Who do you get the instructions from? You're the lead chief law officer of the state. Who do you get instructions from?
I'm part of a cabinet, as you
Right.
know.
So you get instructions on the matters of law from your
No, I
cabinet?
get instructions about the queuing of statutes that are coming before the House and the
Okay,
time.
but this is your statute.
Yeah, but I don't have the right to jump over the top of other ministers.
But you've brought
who've
on
got-
other statutes, so you do control what you bring forward. Aren't you going to bring a bill, your own bill?
Yes, we will, shortly.
That's the same answer you gave me in November.
That's right.
Will this be the next answer that you give for the next budget estimates?
I hope not. I don't expect so.
Okay. I'll,
We delayed it because we received requests in writing from some of the faith groups and other stakeholders for more time to consider it and to discuss it further with government, which is what we've been doing,
okay. And so...
which I'm sure you would.
Well, no, I
applaud.
don't. I don't interfere in how you manage your relationships with these stakeholders, Minister. What I want to know is, will we see anything come in March or the next 2 weeks, or we can presume no?
I can't give you a definite timetable, but other than to say it'll be sooner rather than later.
With the equality bill, will you bring your own version of that bill, or you're going to make a decision outrightly on that particular piece of
You'll have
legislation?
to wait to see what we do with the equality bill. I've just answered that question.
Okay. Thank you, Chair. I've only got a few seconds, so...
Thank you. Opposition.
Thank you very much. On the 15th of November 2023, you met with Raise the Age New South Wales lead group, along with Minister Dibb, Minister Jackson and Minister Harris. What was the outcome of that meeting?
I'd have to go back and have a look at the notes, but it would have, the outcome of the meeting was just to hear from them about their views about raising the age and to consult with them as a stakeholder.
Young offenders are reported saying that they feel able to re-offend with impunity because they're not to be found criminally liable due to their age. Are you aware of this?
I'm aware of reports of that.
Are you also aware of the terms being used such as dolly or dolly in capax
Yes.
to describe why they won't be found criminally liable? Do you have concerns that the law of dolly in capax is not working in New South Wales?
Oh, look, that's not. I wouldn't put it that way. Daley and Capax is a rebuttable presumption that strikes to... It's a common law presumption. It's centuries old, and what it does is seek to ascertain the mental capacity of a child that's alleged to have committed a crime. So you'll be aware that in the criminal law there are two aspects to criminal liability. One is called actus reus, that is whether the act that is alleged to have been done was in fact done. And the second is mens rea, which is whether the perpetrator of the act, the alleged perpetrator, has the mental capacity to know the morality and understand right or wrong and what they were doing was wrong. So Daley and Capax recognises that young children develop at different ages, and so it's a test before the courts, if you like, where the prosecution puts forward a proposition that the child, based on evidence, does have the mental capacity at that age to understand the morality of the act that they're doing, and the court then makes up their mind as to whether they do or whether they don't. So,
But you've seen cases, and even today in the media, where a mother was desperately saying she's trying to teach her young person or her child right from wrong. I'm asking whether or not you think it's working, and if not, what are you doing?
So I think the issue with Daley and Capax in New South Wales is problematic in this regard, that for adult offenders, if the court determines that the adult hasn't made out the mens rea aspect of it because they are suffering from a mental impairment or a cognitive impairment or mental health impairment, they get dealt with under alternative pathways. They don't get put through the criminal justice system and found guilty. They go through the provisions of the Mental Health and Forensic Provisions Act. In New South Wales and other jurisdictions in Australia, mind you, for children, where the prosecution, usually the police, fail to rebut the Daley presumption, the children are released back onto the street, which means that they can keep going and going and going again. Now, the Premier has said...
The question is, what is being done to address this?
So what we need to do in New South Wales is to examine an alternative pathway for, in the same way as I was talking to Ms Higginson a minute ago, to keep these children safe. So if they are a danger to themselves and a danger to the community, it's not acceptable that they just keep going through a revolving door of being arrested by the police and finding their way back onto the street. The Premier has made statements in the last week to the effect that he is frustrated by that as well.
I'm familiar with that, Attorney General, and
Yep.
as I said before, we've seen the reports over the previous weeks, more recently, increase of youth crime, particularly in regional parts of New South Wales.
Yep.
Do you concede that youth crime and recidivism in some parts of New South Wales has gotten out of control, and your government is not doing enough to combat it?
I think you need to be very careful with the second part of that question, Ms McLaren-Jones.
But I've asked you what you're doing.
I understand that. But can I just, without lecturing you, just say you need to be very careful with that second half of the question, because I've got media reports here that took me 2 minutes to Google that described from 2014 in the Sydney Morning Herald that country towns in northern New South Wales are in the midst of a tsunami of crime. So can I just...
There are families that are scared to leave their homes. Have you met with the Premier to discuss this issue?
Let's not get all political on this, because
I'm not. I'm asking if you've met with the
You
Premier.
are, when you say what's your government doing about it, and it carries an implication that we should have solved it within 1 year. So
have you met with the Premier to discuss this issue? You've got families that are... Okay.
Yes, I have, many times, and we've spoken about this with other ministers, and we are very concerned about it.
Did you have the conversation with him before he went to Moree?
Yes.
And what was...
On many occasions.
What was covered?
Well, conversations that I have with the Premier are confidential, but you should be aware that there are quite a number of ministers around the cabinet table that have responsibility for these sorts of issues.
Have you met with the police minister?
Whether they are on many occasions, and the Commissioner and the Deputy Commissioner and Assistant Commissioners and the Chief Magistrate and the President of the Children's Court and the Aboriginal Legal Service and Legal Aid and a whole raft of stakeholders, both
Have you
state
met with the
and
Minister
federal.
for Families and Communities?
Yes, I have.
Minister, it was reported in the Daily Telegraph as of yesterday that, and I quote, Premier Chris Minns has launched a fact-finding blitz tasking multiple government agencies to immediately look at the best way to tackle this crime. It later stated, and I quote, the Cabinet Office has been tasked with leading a multi-government response to the Police Department, Youth Justice, Regional New South Wales, the Attorney General's Office and Department of Families and Communities. What conversations has the Premier had with you around this fact-finding blitz?
Many conversations.
And what has your department or you've been tasked with doing to address this issue?
So we have been addressed with finding some solutions in the short term to some issues that are raising their heads now and have been for decades in rural parts of New South Wales, not only with respect to children but also adults. And also to look at longer term solutions that might be brought to address all those issues that I spoke about with Ms Higginson a while ago.
So this fact-finding task that you're working on, what's the time frame? When can people of New South Wales get an indication of what your government will be doing?
Sooner rather than later.
Is that weeks, months?
This has been driven by the Premier. We are doing the work in earnest, and it'll be weeks, not months.
We've heard several stories of multiple communities around kids who've been arrested multiple times and then released back into the street, which you also touched on, which has prompted calls for an overhaul of the state's bail laws. Is this something that you're looking at?
We're looking at everything with Ms McLaren-Jones.
Thank you. Attorney General, can I take you to the Director of Public Prosecutions Act? Have you issued any guidelines under Section 26 of that Act?
I'd have to go back and check, and I'm not sure. Sally?
Well, there's an obligation
No.
for them to be gazetted, and I couldn't see any in the Gazette. So,
No, I don't. Well, no, the answer is no.
and how often do you consult with the DPP in accordance with Section 25 of that Act?
We have a monthly meeting
Okay, and when did that last consultation occur?
a couple of weeks ago, I think.
Great.
I'll check it. I'll give you the date, but it was about a couple of weeks ago.
And are you able to describe, I don't expect detail, but able to describe in broad terms the content of those consultations?
No. Those discussions that I have with the DPP are confidential, but we raise issues of the day. The DPP will write to me on occasion or raise in meetings issues that have arisen from judgments that might require law reform, things like that.
And so you would be discussing with the DPP matters of the day and matters arising in judgments in relation to concerns she may have about conduct of certain matters in the District Court?
Yes, in general terms.
Yes, in general terms?
Sometimes in specific terms, yes.
Yes, and you would be aware that the DPP has publicly stated plans to report a judge to the Judicial Commission?
I am.
And can you tell us what the bases of reporting a judge to the Judicial Commission are?
No, you can talk to the DPP about that or read the statute.
Well, actually, thank you, I have read the statute. I was hoping you might also be familiar with that statute. Is it commonplace for complaints to the Judicial Commission about judges to be made public by the complainant?
I don't know.
Sorry, from your experience as somebody living in New South Wales, is it commonplace for complaints to the Judicial Commission about judges to be made public?
I can't answer that question unless I go back and do an examination of what's happened in the past.
Can I suggest that it is not commonplace for those complaints to be made public? Is it common practice for judges to publicly question decisions by the DPP to commence certain prosecutions?
Is it commonplace?
Yes.
I don't know what the definition of commonplace is. How often makes
Well,
it
in
commonplace?
your experience, how many times a year would you think that you would read a judgment where a judge has publicly questioned decisions by the DPP to commence
I've never done an
proceedings?
examination of the numbers or the frequency, so I can't answer that question.
And would you expect that it's commonplace for the DPP to respond via media statements?
I'll give you the same answer as the one I just gave you.
Okay. I'm intrigued, Attorney General, because as the first law officer, I would think you would have an interest in these matters, yet you seem to have no interest at all or no knowledge at all of what's happening in judgments, what the DPP is doing in media statements.
Well, that's a nice political statement. Thank you very much. Is there a question anywhere in
The question is,
Be nice.
well, it is a statement. It's a statement of surprise that you are not more aware of what's happening in your portfolio. But I'll move on.
I'm surprised that you can't formulate your questions with more accuracy. Is it commonplace?
I'm sorry, well,
Is it
how many
commonplace?
times
According
have
to
you-
what standard?
how many times have you seen a judge criticise a prosecution brought by the DPP in a judgment in the last 2 years?
I'd have to go back and have a look at that. I don't keep statistics, as I told you, on
How many
on
times
comments
since you
that
become
judges
Attorney
make about-
General have you been made aware of situations?
I'd have to go back and I can't answer this question in
So
any
it doesn't
different way.
matter
You
how
can-
it's
you can-
reframed, you still can't answer the question, Attorney General. Thank you
You're
very much.
asking me a question about frequency, and I don't have the statistic at my fingertip. For the sake of accuracy, I'll go back and check.
Thank you. Can I take you to Section 4
And it's
of
not
the
my
DPP
role,
Act?
and it's not my role to provide a rolling public commentary about these issues. Okay?
Can I take you
as
to
much
section-
as you'd like me.
Can I take you to Section 4 of the DPP Act?
You can. I
where-
don't have it in front of me. but-
Well, I do, and I can take you to subsection 3, where it provides that the Director is responsible to the Attorney General for the due exercise of the Director's functions. So isn't it clearly your responsibility to discuss with the DPP matters in relation to the conduct of proceedings in the District Court and the way in which anything is discussed more broadly in the community?
Yes, and I do.
Very good. What's the usual method of objecting to a judgment, to a decision of a court?
By whom?
By a party to proceedings. If a party to proceedings objects, has a problem with a decision, what's the usual method by which any objection is pursued?
I don't know what you mean by usual, but one of the avenues would be that they could appeal it.
Excuse me, I thought that you might be aware of the appeal process. Exactly.
Yeah.
And so were you then surprised that when the DPP seems to have problems with the judgment of Judge Newlands in the Martinez case, that there was no action to appeal, but rather there was a public statement that a complaint would be made to the Judicial Commission? Is that the normal method of complaining about a judgment?
All these questions proceed upon your presupposition that it's my role to, or my desire, to provide a rolling public commentary on these matters. It's not my role, and I'm not going to. We're dealing with an independent statutory office holder and independent judicial officers. So I'm not going to entertain this line of questioning, Ms. Carter, as much as you would like me to.
Minister, are you aware that the press release from the ODPP asserts that criticism of the DPP from judges can undermine public confidence in the administration of justice? Do you agree with that statement?
I'm not here to agree or disagree with the office, with the Director of Public Prosecutions.
I'm asking you about your role in the administration of justice, Attorney General. What is
the Director of Public Prosecutions about that statement? She's sitting right there.
Attorney General, what is your role in the administration of public justice? In the administration of justice.
My role?
As Attorney General.
It's a bit open-ended, isn't it, that question?
Well, can I take you to the words of Justice Kirby, who in an address in 1998 said that the Attorney General is the traditional political guardian of the judiciary. And I further quote, the Attorney General, as the traditional leader of the legal profession, should speak up where judges are unfairly criticised by politicians and others for doing their duty. Do you accept that that is your role as the Attorney General?
It could be. That's the opinion of one of the judges, and a highly regarded judge. And
And do you accept that you have a role to defend the independence of the judiciary?
yes,
And do you agree that the independence of the judiciary is designed to make sure that judges are independent of interference from the legislative or the executive arm, so they are free to fulfil their duty?
absolutely.
And that this is an important part of our guarantee of freedoms in our country?
I agree with that wholeheartedly.
And Do you therefore agree with the statement that when criticisms are made publicly of judges, that can undermine public confidence?
It depends on the circumstance of the criticism and the content of it and all of the context around it.
And have you discussed this risk with the DPP in relation to public statements about complaints to the Judicial Commission about judges?
In what sense? That's pretty open. There's a bit of a vague question there. Be more specific, please.
If the grounds, as I understand it, for a complaint to the Judicial Commission are about the ability or the behaviour of a judge, if a member of your executive, a senior member of your executive, publicly says, I am making a complaint about a judge to the Judicial Commission, that implies that there is an issue either about that judge's ability or behaviour. Does that public...
I'm not going to entertain a rolling public discourse about complaints to the Judicial Commission by the Office of the Director of Public Prosecutions or any other person or body. It's not my role.
Are you going to defend your judges, Minister?
I think you'll need to frame that a little bit more accurately as well.
Are you prepared to accept the responsibility that Justice Kirby outlines and be a defender of our system of justice, be a defender of the independence of the judiciary, and speak up for your judges, Attorney General?
Okay, so I'm going to let you have a little bit of rope here, Ms Carter, and you can explain to me in the time remaining about how you suggest I might do that. Are you suggesting that I should intervene in a complaint to the Judicial Commission, or wander on down there with my wig on and defend the judge, or what? You just, that's...
Minister, you would know it's not my role to tell you how to do your job.
It's not your role, but it is your role to frame questions which aren't
let me take you to the
and
statements.
Are accurate, and that's a silly
Let me
question.
take you to the statements in Parliament that were made by your colleague, Minister Kotsis, and let me take you to the fact that in response to those statements, the Supreme Court themselves felt that they need to issue a press release pointing out that those statements were erroneous. Do you support the statements made by Minister Kotsis?
It's not my role to endorse or otherwise statements made by my ministerial colleagues. She made a statement in the House. The Chief Justice saw fit to issue a public statement on behalf of the Supreme Court. I understand that Ms Kotsis has given evidence before this committee that she has, shortly after that, written to the Chief Justice, and that's the end of the matter. And I'm not going to...
Minister, it is your role, is it not, to defend the independence of the judiciary from attacks by members of the legislative arm and by members of the executive arm. Are you resiling from that responsibility?
Well, it depends on whether you consider that to be an attack, and I don't.
So you think that making statements that the Supreme Court has rebutted in relation to the time taken for matters and the skill level of judges, how would you characterise that other than as an attack?
I'm not here, I'm not an English teacher, I'm not characterising that essay as an essay, and I've just told you that I'm not going to...
Minister, it would be very nice if you would take this discussion seriously. This goes to the whole system of justice.
No,
you are just trying to make snide remarks.
No, you're just trying to be political here, and you've already tried this one out on Minister Kotsis. You didn't get anywhere there the other day, and you're not going to today either.
The Minister can answer the question any way he likes or not like.
Minister, do you respect your judges?
Of course I do.
Do you publicly speak up for them?
I haven't had a requirement to do so, but if I need to, I will.
You haven't had the requirement when there's been criticism from members of your executive to speak up for them?
On what occasion?
On the occasion of public complaints by the DPP and on the statements by Minister Kotsis.
You've asked me that question about 4 or 5 times. I've answered it.
I'm still looking for an answer.
I'm still looking for an accurately drafted question.
Ms Boyd.
Thank you, Chair. Good morning, Attorney
Morning, Ms.
General,
Boyd.
and
How are you?
all of the officials here today. Since before you were appointed as Attorney General, the domestic and family violence sector has been calling out for reform on the coercive control legislation that's due to be
As have you.
implemented, as have I, in line with the entirety of the domestic family violence sector. What have you been doing to address concerns that unless that legislation is redrafted, it will be actively dangerous?
I have been, I don't accept your characterisation. I do accept that you've been a staunch opponent of this legislation from the outset. But the Parliament has overwhelmingly arrived at the view that the legislation as it was presented and passed through the Parliament should proceed.
Yeah,
and
we
that's
had
what's
we had
happening.
chats though, didn't we, at the time when Labor, you know, in the heat of pre-election fervour, decided to back in this.
No, that's not fair, Ms Boyd.
At the time, the
That's
domestic
not
and
fair.
family violence sector was saying to you that this was very
some were.
poorly drafted legislation. No, the entirety of the
No,
domestic and family violence sector were telling you that. And at the time, the only people who were telling you anything else, I believe, was the Bar Association. This has
No,
now
no, that's-
become
no.
a pressing problem. What have you done to turn your mind to redrafting and putting in the amendments being requested?
I think you need to go back and read the answer that I gave to that very question here in the last estimates. I think I explained to you then that there was no intention whatsoever to redraft that legislation. The Parliament had overwhelmingly decided that it was
Well, no,
going to
you
be...
had.
No.
It was. I'm sorry, but
No.
you had. So we
No, the
had.
Parliament.
No, Parliament had decided that a coercive control offence was necessary. The Parliament had not decided that that particular version should be implemented, except that Labor decided to back it in. If Labor had taken a stand at the time and listened, we would have had much better legislation. You're now in government.
In your view...
What have you done?
In your view.
No, in the view of the entire domestic family
No,
violence
well,
sector.
The domestic and family violence sector were not unanimous in the views that they put to me. Some of them wanted it delayed for 5 years.
Who have you met from the domestic family violence sector in relation to coercive control?
I have to have a look at my diary, but I've recently met with DV New South Wales.
Yep, you have met with DV New South Wales, who are staunchly opposed to the legislation in its current
Yes, and when they
format.
sat down and spoke to me a few weeks ago, they were keen to hear about how the training was proceeding,
Yeah.
particularly in relation to the police.
Yeah,
and
terribly.
they did not ask me at the time
They've written you letters,
undo
haven't they?
the legislation. They were
Okay.
wanting to
They've-
talk constructively about how the training was proceeding.
Okay, that's a whole other issue which we've covered in other estimates about how poor that training is. Just looking at your disclosure summary, you started off okay from July to September, actually telling us what your meetings were about. It talks about particular bills. Sometimes it's just discussion on various legal topics, but a lot of the time it's, discussion on surrogacy, discussion on modern slavery, etc. But then we get to October, December, and it's just discussion on portfolio-related matters. You've had less than 2 meetings a week, and it all just says discussion on portfolio-related matters. Do you think that's adequate disclosure?
Well, it
to
just
the
depends
public?
on what the stakeholders are bringing to me.
Just portfolio-related matters. You couldn't put in, for example, I don't know, what was the National Justice Project wanting to talk to you about? Can that not be more specific?
It depends on what they bring to me and what the nature of the discussions are.
When will the New South Wales Government honour the 2023 Labor election commitment for an independent Victim Services Commissioner?
That is one of the election commitments that we made. We intend to honour all of them. I can't give you a time frame on when that will be, but we will honour it.
Okay, that's not very comforting though, is it? You've given that commitment. So do people just have to wait until maybe the next election to see these things happen?
There's a statutory review going on in relation to victim services legislation.
Yeah.
That's happening, and
I understand that legislation was reviewed in July 2022. When can we see the results of that review?
when it's complete.
Okay, but that was almost 2 years ago. Are you saying it's not complete, that review that was due in 2022?
When it's ready to be handed down, we'll hand it down. I'm not the sort of person that wants to sit around on statutory reviews, which is why I moved, for example, on the review of the coronial jurisdiction, which was due in 2014.
When are we going to see it?
I can't give you a time frame, sorry. I'm not trying to obfuscate, I just don't know the answer to that question.
Okay, but you'd admit that that's taking a bit of a long time,
Yeah,
2 years.
it is, because there's a lot of moving parts, and we want to make sure we get it right.
Okay. Following the Disability Royal Commission recommendations, will the New South Wales Government amend its legislative definitions of family and domestic violence to include relationships in which people with disability experience domestic
I'll take
abuse?
that on notice, Ms Boyd. It's not wholly within my own portfolio.
Is that not something that you have been looking at as Attorney General
I'll
in
take
relation
that question on
to,
notice.
for example, the coercive control offence and the fact that it doesn't work in its current drafting?
Mr Tidball can elucidate on that now if you'd like him to.
Yeah.
Just very briefly, the department is, on behalf of all of government, whole of government, coordinating the response to
Yeah.
all the recommendations.
Yeah.
Each of those recommendations is in scope, including the one you've just referred to, and the person managing that process is Deputy Secretary Anne Campbell.
Okay, but it's directly, I might come back to that this afternoon, but it's directly related to the flaws identified with the coercive control legislation as well. I understand that you decided back in opposition that you were going to support that legislation in its current form, but so much has happened since then. We have had, things like the Auditor General and the LEC report in relation to how unprepared the police are. We've had the pulling of the contract that would have allowed police systems to be brought up to speed in order to allow them to adequately record coercive control incidents. We've had a change of definition of domestic family violence at a national level. Now we've had the Disability Royal Commission. What does it take for you to be convinced that we need to actually change this legislation before it's implemented?
Oh, I think that's a bit of an open-ended, vague sort of question. I can't answer that.
I'm sorry, but what does it take in terms of new events to occur for you to reconsider a position you took 2 years ago?
I'm not sure how I can even answer that question, Ms Boyd.
Well, you could just answer it. What do you mean you don't know how to answer
What
it?
would it take? Some catastrophic failure where the legislation for some reason can't be introduced or won't work.
Okay, and so if people are crying out and telling you that this will actively harm women and children and please don't do it, that's not sufficient?
Well, you've been saying that from day one. And
well, no, the experts who've worked in the field for decades are saying this. It's not just me.
And I'll take advice from principally the people who are sitting at this table.
Okay. Can we talk about the review that was conducted in relation to the excellent campaign from Harry James and Jared Grice in relation to the Your Reference Ain't Relevant campaign, which I thank you for meeting with those people and actually listening to them. That was fantastic. But I understand that the DCJ review was not conclusive. What process was undertaken by DCJ, if we're relying on them, to ensure that they were speaking with victim survivors and advocates and not just people who are already embedded in the legal system?
So I might get Mr Tidball and Mr McKnight to take you through some of the details about the consultation. But firstly, I just want to thank Harrison James and his colleagues for raising this important issue. They're certainly passionate and they're busy. They've managed to take the discussion national. They contacted the Attorney General of the Commonwealth and spoke to the Attorney General from the Northern Territory. I had a very, very productive meeting with them and I told them that I was going to refer the question to the Sentencing Council for an expert review. I was grateful that they saw the value in that.
Yep.
And I also promised them that I'd raise it at the next SCAG meeting, which happened to be about a week later, which I did. And I've now got that item officially on the agenda for the next meeting of Attorneys General nationally.
Yep.
In relation to the specific consultations that
I'll come
occurred,
back in the afternoon perhaps,
sure.
but I've only got a short period of time.
No, I think she wants to come back in the
But if you could tell me the basic timeline then for that Sentencing Council
I don't
review?
know. That'd be
Okay.
up to Peter McClellan, who chairs that, and they've got a couple of references in front of them at the moment
Okay.
already. But certainly, Mr. James was did express, and I don't want to verbal him, but did realise that they'd have the opportunity to put a detailed submission before the experts. And when we took Mr. James and his colleague through, it's Mr. Grice, isn't it?
Yep.
Took them through the composition of the Sentencing Council. They were heartened to see that there were victims groups and other
Thank you.
represent,
Just
not
in
just-
the time I've got
not
left,
just
just
legal
one last
heads.
question. In the last budget estimates, you commented that every court location in New South Wales has either a safe room or a safe waiting arrangement for people who have experienced domestic violence. However, I understand that those safe waiting arrangements can include meeting somebody outside at a particular spot in the garden.
Yeah, I think that there are a small number that might have those rooms off-site, perhaps in a police station close by and things like that.
Yeah, not even. So apparently it's just you meet somebody somewhere that's away from the court. What's being done to ensure there's actually a safe waiting room within the court?
You have to take that on notice, but it's a good,
Thank
important
you.
question. Thank you.
Ms Mahaley?
Thank you, Chair. Minister, or Attorney General, sorry. Are you familiar with the Prasad direction?
Not off the top of my head,
Okay.
Ms Mahaley.
The Prasad direction was a practice available in criminal trials whereby a judge could inform a jury that it was open to acquit the accused at any point following the close of the prosecution case if the evidence was considered insufficient to support a conviction.
Yep.
The High Court actually ruled that the issuing of such a direction was unlawful. Would the government be open to making this direction a statutory option for judges where judges are vested with the power at half-time to discontinue a matter where there's clearly insufficient evidence?
I'd have to take that on notice and get some advice on that.
Okay. Can I just go back to, can I also ask you about cost certificates, Attorney General? How many cost certificates have been awarded against the ODPP in relation to sexual assault matters in the last 5 years? Can you, if you can't answer that, could you take that on notice?
To take that on notice.
Yes, okay. And if you could also take on notice for me that when a cost certificate is awarded, where does that come out precisely out of the budget? I'd like to know where the
I
budget
think it just comes out of the global DCJ budget, but if I'm wrong, no,
Yes,
I'm correct.
Okay. And are you then notified? Is your office notified when those sorts of awards?
Usually,
issued?
yes.
Okay. At the end, you're told what the amount is and why. Is that right? I'm just asking. If you can take that on notice,
Yeah,
I don't know
will,
what the process is. I'd like to know.
Well, I'm not sure what the formal process is. I just am aware that I've been notified of a couple in the time I've been Attorney General.
Okay, all right. Okay. So just in relation to this Martinez case, did you actually make yourself familiar with what actually transpired there with
Yes.
that particular case?
I read
Okay.
the judgment.
Are we expecting that this innocent man may potentially now be suing the Crown?
I don't know.
No one's been given any advice on whether that's happening?
I don't know.
Because he was ultimately incarcerated for 8 months.
I don't know, and that's not
On the advice of
something-
the DPP that they had reliable and credible evidence at the time. Okay, Attorney General, what I'd like to ask, given that, and you've had a number of members of this committee now raise with you the concerns that there is a public, very unhelpful public discourse at the moment happening between some of your judges in New South Wales and the DPP.
A small number, yes.
Well, I beg to disagree with you on that, Attorney General, because it's when you're dealing with innocent people's lives being impacted, it doesn't matter what number it is. It's the fact that decisions are being made to prosecute that aren't subject to judicial review, as you know, are then being are turning people's lives upside down on the basis
Well,
of
the
the fact that
decisions are
they're taking
subject to the
decisions
ultimate judicial
that's
review.
not credible, not reliable evidence before these courts. And the judges are trying to use any opportunity they can to send a message that there is something very wrong within the DPP and in their processes. Now, what I want to ask you about is the guidelines, specifically the prosecution guidelines. Do you think it's worth a parliamentary inquiry reviewing those guidelines?
Not at this time, no.
Would you be interested in reviewing them? Have you, you don't think that given that there have been concerns raised by judges now, is it worth having a revisit of those sorts of guidelines?
I have discussions with the DPP about these guidelines and other issues from time to time.
Yes, you discussed with DPP. What about the rest of the legal fraternity that might give you some more insights to some of the concerns? I mean,
Well,
that's why an inquiry
what
could
you've
be
got
worth
to do
it.
is look at each of these cases on their merits and not jump to the conclusion that there's warfare or that there's a shortcoming or that someone's
Attorney
doing
General,
their job
when
or isn't
you've
doing
got
their...
judges being
don't.
ridiculed by a DPP because they're unhappy that they've made a comment in their particular judgment in relation to an innocent man being unfairly and wrongly prosecuted.
That's your characterisation, and you can ask the DPP about that. And I've said on numerous occasions this morning that I'm not going to engage in a running commentary on these matters.
But you can't ignore it, Attorney General. I think it's come to a position where, when it's such public warfare, it can't be ignored by the chief.
That's your characterisation.
Well, it's a fact, isn't it? It's a fact. Public statements were made.
I'd
You
hardly
have to accept
characterise that as warfare.
It's been reported in newspapers now, and staff are leaking to those newspapers because they've got concerns about how matters are being presented before the court by the DPP.
Okay,
There's
then
clearly
you can take the DPP through this in fine detail later on this afternoon and examine all the statements and all of the issues that you wish to. But I've said, and I'm up to 6 or 7 times now, that I'm not going to engage in a running commentary on this issue.
So when a comment is made by your DPP that a particular judge failed, and I quote, to meet minimum standards of temperance and impartiality expected of a judicial officer, which is a very strong allegation to make against a judicial officer, you don't think that warrants your intervention to be across what's going on here and to actually perhaps seek an inquiry into what is going on in the DPP?
If you're referring to the matter that's before the Judicial Commission will examine that, and I don't intend to engage in a running commentary. No matter how many times you ask me the question or try and draw me out, you must understand that that is my answer.
Thanks.
Thank you. Attorney, could I just turn to your powers in relation to ex gratia payments? What's your understanding of how you administer that function and power that you have when the justice system has failed an individual?
My understanding is that there's a Premier's Memorandum that governs ex gratia payments.
And how does that, is that something that's available publicly?
I'd expect so, yeah.
Yeah.
Yes.
And how do you view that? Do you use that function in a proactive way?
In what sense?
Well, where you know that the system has wronged a person or a person has suffered at the hands of the system unfairly and wrongly, do you reach out and proactively offer that capacity?
Oh, no, I don't have... There's no one in government that sits around and monitors cases where there may have been injustice done to parties and then reaches out and suggests to them that they should apply for an ex gratia payment. No, there's no proactivity in that.
Thank you. Have you ever considered an ex gratia payment for the families of the victims of the Bowraville murders?
I'm not sure if they have applied for one or not. I have to take that on notice.
So are you suggesting you haven't? You've never considered that?
Have I proactively considered that?
No, have you... Sorry, we've moved on. Have you considered an ex gratia payment to the families of the victims of the Bowraville murders?
I'd have to take that on notice and see whether the Attorney General of the day, whether it was me or not, has. I don't know.
Thank you. Just in relation to the Kathleen Folbig matter, are you taking any steps in relation to that? I understand that that's not, you've made clear that's not a practice you would take, but is it a matter now where Ms Folbig would have to go through another incredibly lengthy process, or is this something that you're reaching out to her to help her in relation to the very obvious matter that's before the world at large?
I don't really like to sit in these forums, Ms Higginson, and discuss individual matters, but I can say that in relation to ex gratia payments, I don't take a proactive role, and I haven't in this instance either.
Okay, thanks, Attorney. Has there been any progress from when we last spoke on the post-conviction review process?
I did not. I spoke about that already. No.
I think you said words to the effect, and I could be wrong, and I don't want to verbal you, that you were getting your department to look into it and do work. I
said I was open to it. I said that on the day that I announced Ms Folbig's pardon in the press conference at which you were present. And I said on the last occasion we were here that it was something that I was open to, but that at this time I'd need to be persuaded that I needed to move on it, and at the moment it's not a priority. I haven't closed my mind to it, but the more I look into it, the less convinced I am that there's a pressing need for it at this time.
Okay, so nobody's doing any work internally to look at that need or that case that could be made, notwithstanding the representations that have been made to you that there is a case to have an improved system of post-conviction review.
My understanding is no.
Okay. Are you aware that that outside the ACT, that there are 28 cases nationwide where compensation's been awarded for wrongful convictions, and yet it is at the moment it's the ACT that has a system that
I was aware that there were a number of cases where compensation had been awarded, but there aren't. But I'm not sure where else that goes.
Okay.
2.5 minutes opposition.
Yeah, if I can just press a bit more on this. So, sorry, Attorney, are you suggesting that you don't think there is a case to improve our post-conviction review system at this point in time?
I'm not sure how I could improve upon the answer that I've just given you.
Yeah, I'm just trying to, that you said that you don't think there is a case at this point. I'm just trying to make that clear.
Yes.
Right.
I don't say there's no case. I just say I'm open to it. But the more that I look into it, the less convinced I am that there's a need for us to act on it now.
So can I just ask, what is that? What is that factor that's suggesting there isn't a need, particularly in the light of, say, the failings in the Kathleen Folbig matter? What are you suggesting?
Because I'd need to be convinced that the current regime under the Crimes Appeals and Review Act is so deficient that it doesn't fulfil its statutory objectives. I'm not sure that's the case. I think the Folbig case shows that it can, and it does.
Can I just interrupt there? Does the delay, you've heard the term justice delayed is justice denied, Attorney. Does that concern you? I don't need to stipulate here the length of time of the injustice that Ms. Folbig experienced, along with others before her. How do you override that factor?
I don't want to reopen the iterations and the mechanics of the Folbig case, but when you talk about delay, part of the delay was attended by the fact that the scientific evidence that played a major role in her exoneration didn't exist. I mean, Mr. Bathurst told me that even while he was conducting his inquiry, brand new, not formally known evidence was rolling
Attorney,
into his
it was
inquiry.
some 6 years from the point where the review, from the side, I suppose...
We could go around the block about
so
that.
Does the delay concern you with the archaic current system that we have with post-conviction reviews? Does the delay concern you, Attorney?
I'm not sure that...
and the accessibility?
I'm not sure that a better system presently exists.
Not the
Australia.
UK, not elsewhere across the world. You've looked at those systems?
Not in any great detail,
right.
but enough to have received advice that they're not working as they all were originally envisaged to work in other jurisdictions, and that there's quite some cost that is attended to them as well.
Is that advice available?
Do you want opposition?
Some of it is just conversations with departmental staff and other practitioners.
Thank you.
Thank you. Attorney General, you said in response to a question from Ms Higginson, I think it was in relation to the age of criminality, you made a comment that many of these young people are troubled or come from troubled and dysfunctional families. You obviously showed concern for these young people. I'm interested to know whether or not you've met with Minister Washington to discuss particularly things like early intervention to support young people or families.
Yes, yeah, the ministers, there's about 7 or 8 that loosely cover many of the issues that attend these sorts of issues.
And this is specific to youth crime?
Yeah, youth crime, homelessness, drug and alcohol, policing, all those sorts. There are a
Can I
number
ask,
of ministers.
Attorney General, the Minister for Homelessness and Minister for Youth announced last month a youth central agency that she'll be driving. Will that agency be responsible for youth crime?
I'm not sure. I'm not sure.
Were you consulted on the announcement?
In what sense, though?
She announced and she called it the Youth Central Agency. Everything to do with youth will be through that agency.
No, but I mean, what I'm trying to mean, when you say will it be responsible for youth crime, for what aspects of it?
Well, I'm looking to find out who is actually responsible for delivering outcomes for the government in addressing youth crime. We've got the Premier who's come out talking about a fact-finding blitz. All of these ministers are within your department. I'm looking to find out who actually in your government is in charge of addressing youth crime. We have families crying out for help. We have young people who are going in and out of the justice system. Somebody needs to take leadership, and I'm asking whether or not that's you.
Well, it's a number of ministers, and I hate that this expression "whole of government." It should, it's multifaceted, coordinated response. Perhaps is a better way to describe it, but. There are a number of us that have a responsibility for various aspects of it.
But who's driving it? Who is the leading minister? Who is actually driving it? Is the Premier now in charge?
Well, the Premier's always in charge, but there's an agreement amongst the relevant ministers that we need to do better and to come up with...
But who is ultimately responsible for ensuring these outcomes are delivered? Because the way it sounds is all of you are passing the buck to each other.
No, we're not. No, we're
Someone
no,
must be responsible.
We're not passing the buck. It's not being. There's not. The responsibility is not officially resting with one minister, but the department's doing work now, as I described
but
earlier.
ultimately, you are the chief law officer of this state.
Yeah, and so
the buck should stop with you.
So the response. No, the response has health responses in it as well. The Minister for Health and his department are preparing those responses. There are youth justice responses that Minister Dibb is looking at. There are out-of-home care responses that Minister Washington's looking at.
But who's in charge of bringing it all together and coming out
Well,
with the whole
all of
government?
us have agreed that DCJ should do some work to look at those responses.
So you're passing it on to somebody else, onto the department?
Oh, no,
All right,
don't be silly.
I think time for questions for this round is over. Have we got any questions from the government? No questions from the government?
Better not be.
All right, we'll take a break now and come back at 11:15. Thank you.
Thank you. There we go.
Well, we'll do it all in government time then, because I
You
think
want to do it at the end of government time or now? It's okay either way. It's okay either way.
We might be able to go home then.
Yes. I'm with that.
Okay. You might get all the answers to your questions and you can go home.
So, Mr. Chairman, sorry.
Yeah, please.
So a question was asked by Ms Higginson about how many young people are in custody. As at 28th of Feb 24, under 16 years there are 77 in detention. Under 14 years there are 12 in detention. Under 12 there are 0 in detention. Oh, see, you're right again. Total young people,
Order.
228 in detention.
No exaltation.
Ms Mahalik asked me, over the last 5 years, how many times did the DPP make public comments in response to a judgment? 2 media releases issued according to the Office of the DPP's website. You can explore that further. Ms Carter asked, have you issued any guidelines under the DPP Act? I think it was Section 25, wasn't it? No, haven't. So confirm that. When did you last consult or meet with the DPP under Section 25 of the DPP Act? Section 25 of the DPP Act provides for a specific avenue for the Director and the Attorney General to consult on matters with respect to the exercise of the Director's functions. Meetings with the Director may also occur, as they do with all other stakeholders outside the scope of this provision. I have regular meetings with the Director of Public Prosecutions, as I do with many other legal and other stakeholders. I last met with the Director of Public Prosecutions on the 31st of January. Ms Mahalik asked, in the last 5 years, how many cost certificates were awarded against the Office of the Director of Public Prosecution regarding sexual assaults. Financial year 23, there were 21 matters where costs were awarded. Year 22, there were 20. Financial year 21, there were 9 matters. Financial year 20, there were 32 matters. Financial year 19, there were 21 matters. Question, when a cost certificate is awarded, where in the budget does that come from? Answer, the budget for costs is from the consolidated fund. There is no formal process for notifying the Attorney General's office. The department administers the process. A question, what is the formal process for notifying your office? There is no. Answer, there is no formal process for notifying the Attorney General's office. The department administers the process. Do you need me to table those as well, or?
Please.
Yeah. Okay. And these costs, I'm advised, are not all sexual assault costs. They're global costs awarded generally.
Okay, we might start with the opposition questions then.
Thank you for those answers to questions. Can I just ask a follow-up question? So if the cost orders come out of the consolidated DCJ budget, does that impact other operations of the department? Perhaps you can take that on notice and tell me, because if it's, and also if we can...
I think the answer is that each year there's an anticipated allocation.
There is a budget.
Yeah. So it would only be if it exceeds the budget of costs, then it would impact on other operations.
And I think from having a look at those, you can see that over the, I think, 4 or 5 years that I've given you, they vary greatly. So some years will be unders and some will be overs.
And is it possible, you noted that they were cost orders generally, can you separate them out so we've got the sexual assault ones as a separate category?
We'll take that on notice.
If you could take that on notice, no, that'd be very helpful.
Yeah,
thank you very
sure.
much. Yeah, and also while we're revisiting, if I can take you back to the statement that was made on behalf of the Supreme Court in relation to the comments by your colleague, the Minister for Industrial Relations, and if I can quote, that statement reads in part, with respect to the Minister, there are a number of aspects of this statement relating to the Supreme Court that are not accurate and cannot go uncorrected as a matter of public record. Do you have any role, Attorney General, in correcting statements on the public record where there's errors made in relation to the Supreme Court?
But by errors made by whom?
Made by your colleague in the executive. If there's a member of the executive who makes criticisms of the Supreme Court which are found to be unfounded, do you have any role as the defender of the administration of justice in New South Wales? Do you have any role to speak publicly to correct the record?
Oh, that's a bit hypothetical.
It's not hypothetical, with respect, because,
because
the
you're putting it
Supreme
in-
Court
you-
needed to
no,
issue a
you're
statement
putting it-
only the 30th of
You're
November.
putting it in the context of the statement made by Minister Kotsis, and I've told you that I'm not going to engage in any polemics or discussion about that.
Is upholding respect for independence of the judiciary a matter of polemics?
I don't know that impugns or endangers the independence of the Supreme Court in any way. That is drawing the longest of
All right.
the longest bows.
Thank you for your view on that. And I just have one last question. The amount allocated for the establishment and running of the new industrial court, what impact will this have on the budgets of existing courts?
You have to wait until the budget comes out to see what that figure is.
Sorry, when this industrial court was planned, weren't impacts on other courts contemplated?
Well, you can talk to the Treasurer about budgetary impacts.
Minister, isn't it not your budget? Budget for your department?
It's the Treasurer's budget.
So you've got no oversight, no control over the budget for your department?
In what sense?
In the sense that you say, Minister, Treasurer, I need this much to run my department, I'm going to have this new court, I need an extra X, and he says yes or no?
No, the way the budget works is that
Thank you.
departments, if I can use that word, are allocated a budget for the yearly activities, and when a minister proposes either a variation of the budget by way of an over-expenditure of an existing budget, or whether they are aspect of the departmental budget, or where they want to introduce a new program, a new policy, NPPs they're called, new policy proposals, the minister goes to ERC and argues or puts their case for an additional expenditure. Otherwise, in the normal course of the budget being prepared, ministers propose budget bids to the Treasurer in loose terms and ask for the money.
And so the industrial court, that was pitched as an MPP?
I don't know if it was, or whether they're just preparing it in the normal course of the budget.
If you need to take it on notice, that's fine. I'm just interested in the impact of the industrial court on existing courts.
We'll take that on notice, and
Lovely.
so just
Thank you
give you
very
an
much.
accurate answer.
Thank you very much. Most people's experience of the administration of justice is through the local courts. I'm interested to know what the current wait times are.
Yes,
I can get you that. Mr. Tupol's got that at his
I can
fingertips.
help with that. I will be running, though, not off ROGS data, because the ROGS have not reported Ms McLaren-Jones since the last
Do you just want to
estimates.
explain what ROGS is?
Yeah, report on government services, which they publish cases pending. I provided those figures to the last estimate, so last reported 30th of June. So if I can run off for the local court, probably the best indicator is defending hearings, and as of December, end of December 2023, which is the most recent data I have, there were around 21,550 defended hearings pending in the local court.
And what's the average length of wait time for a domestic violence case?
I would need to take that on notice.
Attorney General, I put to you in relation to Waverley Court, which is in your electorate. Are you aware of the length of, first of all, how many cases are waiting at that court, and also the length of wait time for a matter to be heard?
It is my local court. It's in the electorate of Coogee, but that's neither here nor there. No, I'm not. I have to take that on notice.
Has anyone raised with you the wait times in relation to that court?
Specifically? No.
Do you have any wait times in relation to Bankstown Local Court?
No, I don't. I can get them. I just don't have them at my fingertips.
Would anyone at the table have those figures?
No, not today. Not with us.
I put to you that Waverley Court could potentially have a 12-month wait period for a matter to be heard. Are you aware of that?
If it's true, I'm not aware of it. No, I just told you that I wasn't aware of the wait times.
Is it a concern to you?
Of
The wait
course
times.
it's a concern.
And what can be done to address it?
Well, this has been a long-standing issue with the local court. It was exacerbated by COVID. I know that the Chief Magistrate and his deputies have worked very hard with their magistrates to get that list under control. I meet with the Chief Magistrate regularly regarding issues that impact the jurisdiction of the court and the ways the New South Wales government can support the operation of the local court. Since March 22, 2 magistrates have been appointed in the local court, first in September 22, specifically as a youth query court magistrate, then in November 23, specifically as a circle sentencing magistrate. And one of the things that's impacting on the local court is the significant increase in the number of sexual assault and domestic violence complaints. That's something that should concern all of us, and does impact on the work that the magistrates do. And I just want to take this opportunity to thank the magistrates who do a pretty thankless job, but do a good job in terms of managing the heavy workload that they have.
Which actually moves me to the next area, which is, I think they estimate around 40% of matters are relating to domestic and family violence.
And the same impact in the district court on sexual assault cases as well.
Have you had any discussions with the Minister for Women in relation to this particular issue, wait times, impact it's having on courts, and what were the outcome of those discussions?
I haven't had any. I haven't raised with the Minister for Women the wait times in court because it's not really a matter for her, but we have general discussions about domestic.
Has she raised it with you?
She may have in conversation, but not in any official way.
Have you considered establishing a domestic and family violence list?
We have had discussions about that over
Is that with the Minister or with?
Just loose conversations. There have been suggestions put to me that we should have a specialist domestic violence court. I've spoken to the Chief Magistrate about that. His view is that you should not do that. You should have, if you're going to move to any specialisation, you would have maybe a specialist domestic violence list. But there are moves within the local court to educate magistrates up on domestic violence issues, and so have them educated.
And what's your view in relation to a specific list?
A specific list?
Yeah.
I'd have to be guided by what the experts were on that, and the experts would be the magistrates themselves. If they thought that there were administrative arrangements we could make that were reasonably cost effective, that could assist them, we'd have a look at that. But at the moment, there's no moves to do that.
You indicated you've spoken to the Chief Justice,
The Chief Judge.
Chief Judge, sorry.
Chief Magistrate, sorry.
Yep. In relation to lists, have you spoke to any other magistrates? Because you said you'd be guided by.
Yeah, I've had some informal conversations with one of the deputy magistrates as well.
And what was the view? Is it to
well, we
support
didn't come to
or?
any conclusive view. We just discussed the possibility of it, and their views were that, like the Chief Magistrate, that if the government was of a mind to move in that direction, you wouldn't necessarily want to establish a specialist court, but you might want to have a specialist list within the court, and that's something that we'll look at.
So it is something that you're looking at?
Yeah. There's no formal work going on about that at the moment, but that's something that is always in consideration.
Okay. Attorney General, are you aware of the hearing delays pilot program that was run by the Coalition to address delays in court? And following the success of that program, the Coalition government at the time had pledged funding for additional 5 magistrates to address wait lists.
Can I just briefly return to the previous question? The question was, what am I doing about it? I should also say, in fairness to my department, that the department does have regular discussions with the courts about these things, and the department does have discussions with the courts about improving expertise in relation to domestic and family violence within the local court. So, sorry, what was the question?
Oh, in relation to the previous Coalition government committed funding for 5 additional magistrates to to address wait lists. I'm interested to know how many new magistrates have come on
Since when?
since you've come into government.
I'd have to take that on notice. I don't think we've brought any new magistrates on with a view to reducing the wait time specifically. Brought them on for specialist matters. So the note that Mr McKnight gave me said, following the interruptions to local court operations in 2020, the former government approved the staged appointment of 8 additional magistrates above the local court baseline. All 8 appointments have been made, the last of these occurring in March 2022, and the balance of the question I think I've just alluded to. Since March 22, 2 magistrates have been appointed in the local court, first in September 22, specifically as Youth Koori Court Magistrate, and then in November 23, specifically as a Circle Sentencing Magistrate. These additional appointments did not factor in the ongoing significant interruptions to court operations that occurred from June 2021 through to March 2022 due to the COVID-19 pandemic. And in relation to domestic violence, there are embedded specialist domestic violence practices in the local court, and the local court is currently trialling a domestic and family violence specialist list in several local court sites, and that's been led by Deputy Chief Magistrate Sharon Freund.
Okay. My colleague? Yeah.
Minister, how many prosecutions have there been under Section 93Z of the Crimes Act?
I don't have them with me unless someone wants to flick me a note. But there have been, I think the Premier gave answers to that question the other day, if I'm not mistaken, and I can get them for you.
Thank you. Has any court flagged any issues with the operation of 93Z in those
Has
prosecutions?
any court?
Yes.
No. Not to me, no.
And so what advice have you received from police that led you to seek changes to 93Z?
In terms of...
Well, you introduced changes into the amending legislation into the Parliament last year to amend 93Z.
Yeah,
I'm wondering...
I think I'll take you to my second reading speech.
Thank you, Minister. I'm aware of that, and I'm also aware that the Police Minister in budget estimates in relation to that section said there were and have been significant delays that were with the DPP. Are these delays the reason you sought to remove oversight of the DPP for prosecution of 93Z?
So, as I said, I explained all this in my second reading speech, and I said...
it's just a simple yes or no
the New South
question,
Wales
Minister.
Government considers that removing the requirement for the DPP approval to commence prosecutions under 93Z continues to strike the right balance. I went on to say removing the DPP approval requirement would also make this offence consistent with the overwhelming majority of other offences in New South Wales, including the offence of displaying Nazi symbols in Section 93ZA of the Crimes Act, which includes no such requirement, and other serious and complex offences like fraud.
Thank you for reading that back to us, Minister. It doesn't really address the question. Were you concerned, based on advice you had received, that the problem with prosecutions under 93Z was delay in the DPP's office?
I wouldn't put it that way. I think
Then what was the rationale for seeking change?
The concerns were that the procedure itself, which required the police to put the brief together, then send it to the DPP, have them consider it, and then send it back again, was an unnecessary potential delay.
So, in budget estimates, police have given evidence that there were no briefs of evidence prepared for the protests on October the 9th at the Opera House pursuant to 93Z because they were unable to identify any individuals who may have committed an offence under the Act. So this has nothing to do with the threshold test in 93Z. Why then are you reviewing the legislation when enforcement is the issue, not the legislation?
Well, the two concepts that you've just spoken about there are unrelated. One is about what I just call the potential administrative delay in sending the brief back and forth, and the other relates to the police acquiring the necessary evidence from the incident at the Opera House to commence a prosecution per se. They're not related issues.
So you seeking to amend 93Z had no relationship at all to your response as a government to the events on October the 9th at the Opera House?
Not in my mind, no, and
Okay,
I'm the one
thank
that
you.
brought the legislation.
That's very interesting. Thank you,
And
Minister.
if I had, I would have said so in the second reading speech.
Thank you. And I note that you've announced a further review of 93Z, and this was, you put out a media release on the 19th of January, and it noted that the review comes in the wake of concerns raised by some community groups about the effectiveness of Section 93Z. What concerns are these, Minister?
These are the concerns that those community groups expressed to the Premier.
And which community groups were they?
You'd have to ask the Premier that. I can try and get those on
It's
notice.
your media release, Minister.
I know that, but what happened was that while I was on leave over the Christmas break, the Premier met with some of these groups, and before, as I understand it, I want to verbal him, and arising from those concerns, he announced while I was on leave that it was going to be referred to the Law Reform Commission. So when I returned from leave, I accepted that instruction from the Premier to refer it, and I did.
Were you consulted at all, Minister?
I was on holidays.
We've heard earlier that the Honourable Penny Sharp, when she was quote unquote on actual leave, was still involved in meetings concerning her portfolio. There was no effort to reach out to you about an important matter like this?
If the Premier wants to meet with certain groups and issue a direction to his attorney off the back of those consultations to do something, then as the attorney, I comply with the directions of the Premier.
When did you return from leave?
I didn't get the exact date.
Had you returned from leave prior to the issuing of the press release?
I don't think so.
So a press release was issued in your name while you were on leave?
No, I issued a press release after I returned.
So you returned from leave and then you issued the press release about the review.
Yes.
I note that in November
That's
last
correct.
year,
Yep.
I moved
If I'm correct in respect of that, I'll correct the record, but that's my recollection. I wouldn't have issued a press release while I was not the Attorney General.
So I moved that the legislation 93Z should be referred to an upper house committee for review. Your government voted against this, but on the 19th of January, some 50 days later, your government announces a review of the legislation. What changed in 50 days?
The Premier had, as I just explained, a meeting with certain stakeholders who, when they spoke about the operations of 93Z.
And you can't tell us what these concerns were or who the stakeholders were that makes a total change in government policy in 50 days?
Did you ask the Premier these questions the other day?
With respect, Minister, it's your portfolio and the press release went out under your name.
That's right.
It would seem you would be the person to ask.
No, because I've just explained to you that the reason for the review came about because the Premier went with certain stakeholders, and when I returned from leave, the Premier directed me.
And the terms of reference of the review, Minister?
Yeah.
Did you settle those?
The department settled those.
The department or Mr Bathurst?
I looked at them and I approved them.
So the terms of reference would display the concerns that the community stakeholders have. Where can we see the terms of reference?
It should be on the website.
And they were settled before the review, or they were settled after the matter was sent for review?
When I refer the matter to the Law Reform Commission,
so they were settled at that time?
Either at the time or shortly thereafter. At the time. So I write a letter saying I refer, Mr Bathurst, I refer this matter to you and here are your terms of reference.
That's right.
Can we get copies of that?
They're on the website, but sure.
Can you direct us to it? That would be lovely.
Yep, no
Thank
worries.
you.
Thank you, Chair. Attorney, we heard evidence in an estimates inquiry at the end of last week that there actually is one child incarcerated at the moment who is at the age of 12. So that was evidence presented by Paul O'Reilly at the Youth Justice Budget Estimates hearing. So that may be a new figure. Just thought I'd make you aware of that. Thank you.
Okay, sure.
Just going back to, if I can...
So Mr McKnight's just suggested to me that the numbers can fluctuate on a daily basis.
They can. Just wanted to bring you back, just very briefly, Attorney, to the matter of Ms Folbig, and just want to know whether, and I know that you don't like commenting on individual cases, but this is a case that obviously the entire nation has been watching and has eyes on, and just want to know whether you would be taking some proactive steps to engage with Ms Folbig, or whether the full burden, once again, will be on her to try and access some justice from the state of New South Wales after her wrongful imprisonment?
I've already explained, Ms Higginson, that I do not take a proactive role in inviting people to apply for ex gratia payments.
Thank you. I understand
that applies in this instance as well.
So you won't be reaching out to Ms Volbig?
No, I won't.
And you'll wait for her and she'll have to carry that extra burden to be able to get on with her life?
Well, you can characterise it that way, but it's not...
How would you characterise it?
I don't need to characterise it. I've answered that Ms Volbig will need to avail herself of the avenues that are available to any and all citizens in New South Wales in her situation.
Thank you. I just want to ask you about your views in relation to civil suits that are brought against the police for misconduct. There's almost 500 civil suits against the police for misconduct in a year. Do you think that reflects that we've got a poor system happening in terms of accountability? I know this is a matter for the police, but in terms of our court system and the civil suits and you as Attorney General, do you think are you satisfied with that system that we have at the moment?
What system? You've asked me three different things.
That there is around 500 civil suits against the police for misconduct per year.
Yeah. Am I satisfied as to what?
That system of accountability, does that concern you? That there are individuals walking around having to engage in accountability for police misconduct through the civil court system?
Well, that's one avenue. The other avenue is that they can refer the police officers' conduct to the Law Enforcement Conduct Commission.
Certainly, but there's a... Yeah.
They can write to their local member, meet with their local member. There are various
Are you
avenues.
concerned that number? Do you know how many civil suits have there been commenced in the year so far since 1st of July?
Against police, no. The Attorney General of the day does not ordinarily get briefed in respect to those matters. The Minister of Police might, I'm not sure, but no.
And so what about, so I've heard from many members of the community that Crown solicitors acting for the police will consistently leverage these non-disclosure agreements in their settlement negotiations. Are you aware of that?
So I say that again?
That the Crown solicitors will leverage non-disclosure agreements in all of those police accountability civil suits.
I'm not sure. I'd have to take that on notice.
Well, if without being too hypothetical here, if that was the case and that is a practice, and it is the practice, do you think that's an appropriate practice, given we're talking about police accountability and where it intersects with the civil system?
Well, the concept of a full and final settlement usually is attended by some agreement as to the constraint of future action. So.
But what about this idea of non-disclosure? I'm just wondering whether, Attorney, you have any concern or it's a priority that at the moment the state is literally forking out hand over fist with police accountability with up to anywhere 500 civil suits. There's no disclosure around that and the costs of that, and that Crown Sols and prosecutors are engaging these non-disclosure orders consistently.
Yeah, you're asking me about something that I don't have any knowledge of, Ms Higginson, but I'm happy to take whatever question you want on notice.
Does it concern you? If that was the case, that we've got this large...
It's not prudent for me to say I don't have any knowledge of the matter, but I'm concerned about it. That doesn't make sense. So I've said I'll take it on notice.
Last year, a police officer drove, allegedly drunk, wrecked a police car and then committed insurance fraud to ostensibly cover it up. The magistrate who heard the case has suppressed that person's identity for 40 years. Does it concern you that we won't know the identity of a senior police officer?
I don't know the reasons why the magistrate has done that, so I don't know whether I should be concerned or not. There might be very good reasons. It might be that the police officer, I'm completely hypothesising here, was a member of a plainclothes or undercover squad, and the publication of his name might make him known to outlaw motorcycle gangs or something and endanger his life. In that instance, I wouldn't be concerned, but you're asking me to guess as to what might have happened there, and I don't know.
So 40 years doesn't concern you, given, I mean, what is there a comparison in terms of timeframes for suppression? I think the standard on secret federal cabinet documents is 20, 30 years max, 40 years.
These orders are made at the discretion of the judicial officer.
Thank you. I just want to turn quickly, if I can, to the coronial inquiry into the Black Summer fires, and whether you know and can tell the committee what are the total costs of the New South Wales coronial inquiry into the Black Summer fires, excluding the costs for legal representation of government agencies?
Oh God, we'd have to take that on notice.
Okay, thank you. Well, if you could, what I'm looking for there is the total costs incurred by the New South Wales Government in funding representation to the New South Wales Fire Service, National Parks and Wildlife Service, the Forestry Corporation, Fire and Rescue New South Wales, and any additional costs for other entities whose representation in the coronial was funded by New South Wales Government.
Sure.
Thank you. And during the inquiry, it's been stated throughout the hearings that in the case of many fires, the inquiry was limited to the cause and origin of fires, and that specific response and management issues in many fires would not be investigated. What was the extent, scope or ability of the New South Wales, was the extent limited by financial or budgetary constraints? Is that your understanding?
I don't know, but my understanding is that the coroner would have set the rules in terms of reference for that inquest, for that inquiry, and that's a matter for them.
And is there any relationship between how we fund those coronials and the exercise of those decisions on part of the coroner that you're aware of?
I'm not sure what you're getting at, Ms. Higginson.
Well, I'm trying to understand the relationship between the cost of that coronial and whether there were matters of whether the scope was limited due to the costs that were allocated to that coronial.
I think you'd probably be best get that answer if you wrote to the coroner. I don't know that I'm able to answer that. I hazard that the answer is absolutely not. That the coroner has a statutory responsibility to discharge his or her responsibilities in relation to the obligations under that Act, and that she wouldn't be constrained by costs to government in doing that.
So just in relation to that then, can you
But
also...
that's a matter that you should put to the coroner.
Thank you, will do. So can you also explain why you believed in the application by the Mount Wilson Rural Fire Service Backburn Survivors Group, can you explain why you determined they did not meet the special circumstances in their application for representation?
I'd have to go back and have a look at that brief. I received that brief quite some months ago. I can take that on notice.
Thank you. And in doing so, could you please provide an explanation as to why that request was delayed 9 weeks until basically the close date of the hearings? Why the delay in determining that application?
Yeah, happy to take that on notice.
Thank you. And also in that, if you could also answer, did the Attorney-General grant funding for any community group or community representatives at the coronial hearings, and how many, and what the total costs were?
Sure.
Thank you.
Thank you. Ms Mihaly?
Thank you, Mr Chair. Just, Attorney-General, just back on the Martinez case, I just want to ask your thoughts, and you may not respond, but your thoughts on the fact that the defendant in that case sought a subpoena under Section 222 of the Criminal Procedure Act to have particular information adduced in evidence, and that was that the complainant who brought on the sexual assault complaint against him, which the DPP then chose to prosecute, had 6 other complaints. For some reason, the DPP objected to that information becoming publicly available in that case. Are you familiar as to why that happened?
I certainly do not intend to go into discussion about any actions before any court. but I would hazard that the DPP would welcome that question this afternoon.
Yes, we'll be asking her in the afternoon. Okay, so I'm going to lead. The reason I'm asking you this is because, of course, some of that frustration was vented by the judge in his judgment, Newlands. I want to speak to you about why the DPP, of course, has now referred this judge to the Judicial Commission. What normally, what are the grounds normally to refer a judge to the Judicial Commission, as you understand them, Attorney
I'd
General?
have to go back and read the Act and read the rules.
But it's a pretty serious referral, right? I mean, ordinarily that could even lead to a judge being removed by Parliament, right?
Yeah, it's serious. Yes.
It's very serious. Okay.
Yes, it is.
So in this instance, if it ends up that the Judicial Commission, in fact, perhaps might say that the judge's comments were fair, and that they didn't warrant it, and that there aren't going to be any adverse findings from the Judicial Commission, would you, as the AG, commission an inquiry into DPP?
Oh, you're getting way ahead of yourself. There's no way I'm going anywhere near that with a barge pole. Sorry, it would absolutely be inappropriate of me to answer that question.
Okay. Do you agree then, Attorney General, that in considering a costs application in a criminal trial, that a judge must decide if there were reasonable grounds for the prosecution to commence proceedings?
Oh, I believe that's probably one of the considerations, yes.
Yep. Can you explain how a judge doing their job in deciding a cost application could be grounds for a complaint to the Judicial Commission?
No, I'm not going to entertain those musings today, Ms. Mahalik. I've made that pretty clear. Sorry.
So doesn't worry you at all that the DPP would do that and make a public announcement of it?
I've just told you I'm not going to entertain these musings today, Ms. Mahalik.
Okay. Well, you're the Chief Law Officer of the state, and I think people are within the legal fraternity do want to know your view on this.
There's a process that was put in place for occasions like this. Let the process take its course.
Well, when do we expect an outcome from the Judicial Commission?
I don't know.
Do they inform your office ordinarily prior to making their statements
I don't
public?
know what the formal processes would be. I assume that they would.
Well, can we get some advice
I'll
on
take
that?
that on notice. In any event, even if they don't formally notify me, I'll know within minutes anyway.
What, once it hits the media?
I would imagine so. Once it's made public, if they make it public.
Okay. How many have you had to deal with these sort of judicial complaints in your time? None.
I'd have to
so
have a look
far.
at that. I don't know. Don't know the answer to that.
Okay.
They're rare.
So, is
They're
there
rare.
any other referrals to the Judicial Commission in the last 9 months that you're aware of?
Of judges?
Yes, of judges.
I'd have to take that on notice.
Okay, if you can take that on notice, yeah. And by whom?
Yep,
If they're
sure.
an official position. Okay, that's all I have.
Yeah.
Oh, come on, we still
got some more?
Always.
Always, yeah. Okay.
Always more. Dr. Cohen, do you want to take? Yeah, good. Thank you.
Morning, Ms. Conn.
The Australian Medical Association has recently called on state and territory governments to ban conversion practices that intend to change, alter or suppress a person's sexual orientation or gender identity. They've stated that there is strong agreement among the medical profession in Australia that conversion practices have no medical benefit or scientific basis, and that there is evidence of significant harm resulting from such practices. There was bipartisan support for a ban before the election last year. When will we see legislation before the Parliament?
I've received a question in that regard already this morning, and I've said that sooner rather than later, but I can't give a specific time frame.
Okay. Are you able to outline what consultation process has been undertaken?
I can
for
take that on
delivering
notice
legislation?
because it's been substantial, but some of I'm not trying to dodge the question. There are some of the groups that have consulted with us who don't want their identities known, so I just have to be careful about what I say.
Thank you.
Well, yeah, I'll take that on notice.
I'll wait for that answer on notice and pass back to Ms. Higginson.
Thank you. Attorney, you come from the party of organised labour. What do you think the role of protest and demonstration really is in civil society?
For citizens to be able to express themselves freely in the community that they in fact own.
And so how do you reconcile that at the moment with your, your answers a bit earlier in relation to maintaining these anti-protest laws that you were very, very opposed to earlier on in periods of opposition, looking at the anti-protest law trajectory through the last 3 terms of Parliament. Are you interested or open to enshrining the right of civil society to protest, like in the ACT and Victoria?
I'm not sure there's a need, Ms Higginson. Freedom of assembly and speech are recognised by the New South Wales Government as important rights that are integral to a democratic system of government. All New South Wales citizens today enjoy a common law right to peaceful assembly, and this right is further protected by the implied freedom of political communication in the Australian Constitution.
So how do you reconcile this view? How do you actually reconcile this view with the fact that we've got laws currently sitting on the law books that nanas, and let's face it, they're nanas in our state, have gone to the Supreme Court and obtained a ruling that part of those laws that are currently on the books are unconstitutional. You've had advice not to challenge that finding. Will it be your intention to repeal that part of the anti-protest laws?
No.
No. So you're just going to leave them sitting there?
Yes. Well, there's a review there will be a review underway in April.
In April, that's right, which will take 6 months.
Statutory review, and it will look at the normal things that statutory reviews do, but there will be no move by this government to repeal these laws.
Hang on, so you're saying there's a review, but there'll be no... What if the review suggests you repeal these laws?
I don't think that's what the scope of the review is. The review sees whether the intent of the legislation has been met, and this is sort of a mechanical review, but I can tell you that there will be no repeal of these laws, because I don't want to see Harbour Bridge, the Harbour Tunnel blocked. I don't want to see Sydney shut down.
But Attorney, you said earlier...
Rebellion said that they wanted to do. I don't want to do that.
Thank you.
And these laws
can I just redirect you
that
here?
Sort of behaviour.
Can I just redirect you,
Sure.
please, Attorney? You said yourself that there are plenty of other ways of dealing with behaviour that may or may not be determined criminal, that are not these draconian, deliberate anti-protest measures that, let's face it, the Berejiklian and then the Perrottet government introduced, many of which you and your colleagues in New South Wales Labor are clearly on the record for saying that they are excessive, they're harsh, they're draconian, and they're unnecessary. They're anti-protest laws. And now you're suggesting that you're okay with those. And
no, you've asked me whether they'd be repealed.
I have.
That was the question. The answer is no, they won't be. I'm being completely honest with you.
Even though you know right now you've got sitting on New South Wales law books draconian laws that the Supreme Court has said are unconstitutional.
No, you've called them draconian. The Supreme Court has...
Okay, the Supreme Court called them chilling.
Impugned a very small aspect of them.
And so it's okay to have impugned laws sitting on our law books?
Well,
that are of a chilling effect?
Well, effectively, they're not on the law books, because if they're prosecuted now, you won't be found guilty.
Attorney, they're on the law books. If I Google them, simple Google, they're sitting there as a law, an impugned law. Will you repeal that at least?
That
Surely that's good government.
That aspect of what to do as a mechanical process with the words that sit on the statute book, in light of His Honour Justice Walton's judgment, will be dealt with by the statutory review.
Thank you. The Premier is widely reported as saying that the police have the powers to rip off balaclavas and expose people's faces. Do you agree that the police have the power to forcibly remove or, in his words, rip off face coverings?
No, I think Deputy Commissioner David Hudson gave evidence about this the other day in police estimates, and I'd need to have that evidence, that transcript before me before I requote what he said. But my understanding is that the police don't have the right to walk up and order someone's someone to remove a face covering, but they do have the right to ask a person to identify themselves, and if that requires the removal of a face covering, then they have the power to require the face covering to be removed for the purposes of identification.
In light of the fact the Premier has come out saying that police have the power to rip face coverings of people, have you met with the Premier? Are you intending to introduce legislation?
Well, they do have the right to rip them off in certain circumstances, which I've just described here, and I'm sure that's what the Premier was referring to.
But you're not sure. Have you met with the Premier about his comments?
No.
Did you provide the Premier with a briefing regarding the intervention of the NZYQ High Court case?
Did I provide him with a briefing? No, I didn't.
When asked in budget estimates, the Premier said he couldn't recall and had to take it on notice. So you're advising that you have not met with the Premier. Did you provide his office with any briefing in relation to the matter?
I didn't. I don't know if my staff spoke to his staff about that. I'd have to make inquiries about that, and I don't know what communications there may or may not have been between DCJ and the Cabinet Office, so I can take both those aspects on notice. But I didn't provide the Premier with a briefing on the NZYQ case.
Thank you.
Minister, the Police Minister was asked about the inadequacy of bail laws, which currently allow young offenders to be bailed out only to re-offend again. And she indicated that she had met with you about this issue. Do you recall that meeting?
What page of the transcripts were we on? Do you have someone bring them down? No. Okay.
Do you recall that meeting with the Police Minister?
Sorry, can you restate that question? I was looking for the transcript. I thought that
The Police Minister was asked about the inadequacy of bail laws, which currently allow young offenders to be bailed out only to re-offend again. And she said she had met with you about this issue. Do you recall the meeting?
We discuss the issues relating to youth and regional crime often, sometimes by ourselves, sometimes with staff, sometimes with the police. So there have been a number of occasions we've discussed all manner of aspects of youth crime and regional crime.
The Minister said, quote, "We have to somehow work on a strategy to stop kids re-offending. They're staying in the system for too long, as you have said, again and again and again, and then they're ending up obviously in jail," end quote. What are you doing about this?
I've been through all this morning. I refer you to my earlier answers.
Could you summarise what you're doing about this?
I've already explained to you that the Premier has tasked certain departments and my office with undertaking some work, and I indicated to you this morning that work will be forthcoming shortly. I don't really want to repeat myself again.
Okay. The Police Minister said that strengthening of bail laws is your responsibility. Are you looking into this?
And we're looking at a whole range of measures in relation to the issues that I've expressed this morning concern me, the Premier, the Minister for Police and the Government.
Does that include bail laws?
Yes.
Have you had meetings with the Police Minister regarding legislation to outlaw the Nazi salute and other symbols?
No, because those provisions are already on the statute books.
Have you been briefed by police on what is needed to enforce this legislation?
No.
Have you provided any information to the police or the Police Minister about the operation of these laws?
The discussions like that go on all the time between the police department and DCJ and amongst ministers themselves. But have I given a formal briefing to the police about these matters? Is that the question? No.
The Police Minister said that this is part of the review into Section 93Z, is that correct?
Well, that's part of the terms of reference into 93Z.
If I can just take you back
that wasn't
to
the question you asked me.
If I can take you back to your earlier evidence in relation to the terms of reference for 93Z, I think I recall you said that when the matter was referred for review, you sent it with the terms of reference attached.
I'd have to go back and have a look at that, but I just need to correct the record. The media release on the 19th of January was in the name of the Acting Attorney General, Ron Honig, and the Premier while I was on leave, and then when I came back, I referred it.
Yes, because the media release indicates that terms of reference for the review are currently being developed with Mr. Bathurst, so they would not have been available at the time the reference was made.
At the time, the media release on the 19th of January was issued. You're talking
And what
about.
was the delay between the media release of the review and the matter actually being referred for review?
Waiting for me to get back from holiday so I could.
No, sorry, what was the time period? Not the reason,
okay.
the time period.
I'll take that on notice.
Thank you very much. And is it usual for a matter to be sent to review and then the terms of review workshop with the person who will do the review?
I'm not sure that was the case. I'll take that
Well,
on
the
notice.
press release indicates that they are currently being developed with Mr. Bathurst,
Okay.
who was the person to whom it had been
The
referred
press
for
release was
review.
issued, as I understand it, by the Acting Attorney General, not me. So
No, I'm asking about general practice when a matter is referred for review. Is it normal practice that the person who will conduct the review actually also works up the terms of the review?
I'll have to take that on notice.
Thank you very much.
As of December last year, the youth detention population was 174, and this came out of evidence that was given during the Youth Justice budget estimates. Of those, 45 had been sentenced, but there was 129 being held on remand. When questioned, the Minister for Youth Justice said that it was your responsibility. My question is, why are there so many young people being held in...
What was my responsibility? What was the context of the question?
Young people in remand. So out of 174 young people who've been charged, 45 have been sentenced, 129 were being held in remand. When asked about why the number was so high, the Minister for Youth Justice said it was your responsibility.
Okay, I'd have to have a look at the transcript and see what the context of that discussion was. I still don't understand what's my responsibility.
The question was, and it's quote from the Shadow Minister, I'll move on to remand. As of December last year, the youth detention population, and I'm sure this has changed since then, was 174. Of those 174, 45 had been sentenced, but 129 were held on remand. Why are there so many young people held in remand waiting for their day in court? The Minister's response was, I think it comes to an issue of remand, and it's a decision that has been made obviously by the courts. That is something for the Attorney General. My question is, why are there so many young people waiting?
Yeah, they are very short remand periods, but okay, that goes to a whole range of inquiries about offending. The mechanical answer is that there are more people on remand because the police have arrested and brought more people before the courts. That's the mechanical answer. If you were asking me to go into the reasons for that,
yes.
Well, I'm not sure that I can. It could be the fact that the police have changed their operational capabilities and they're getting through more workload, or they're targeting offenders more effectively and
Have you looked
apprehending
at
them.
why there are so many waiting or in remand?
These are the subjects of quite some detailed studies by Boxar. It could well be that because economic times are tough, there are more people shoplifting and things like that, for example.
But I'm asking specifically
I'm
about these statistics which came from December.
Yeah.
I assume they're probably around the same now, maybe more. Have you actually looked at why there's so many young people in remand?
I'm just
Have
trying
you
to
met with the Minister for Justice?
I'm just trying
Have you
to
met with the Minister of Police? Have you looked at it?
just trying to answer that question now. There could be any number of reasons for them. For example, when Boxar statistics are released and figures show
Well, can
that...
I ask what you're doing about it? Maybe that's an easier question.
Haven't we just spent half the morning talking about this?
Yes, we seem to go around in circles.
So what am I doing about it? Well, the Premier has tasked, outside of the Premier's direction, this is something that I've told you, that the Department of Communities and Justice are doing some work for various ministers on looking at support services and diversionary measures. In addition to that, I'm not going to go into the detailed answer that I gave you before. You can go and have a look at that.
All right, Attorney General, I might move on to the fact that there's...
Don't interrupt me.
I've got limited
You've asked
time.
me a question.
I have limited time, and you have.
And in addition to that, I'll just quickly refer you to the work that the Premier has asked us to do, which we've spoken about.
And I'll, as I said, I'll move on to the next question. So 61.5% of young people are in custody are Indigenous. Now, when the Minister for Aboriginal Affairs was questioned in regards to this, he said, I know the Attorney General looks at these things more closely. Now, his interpretation would be that you are responsible for this working group that the Premier has tasked. Is that correct?
Which the one that I spoke to this morning?
No, well, yes. The one
Yes.
you've been referring to as the solution for everything to do with youth crime.
Yeah, no, that's been led by the Cabinet Office, coordinated by the Cabinet Office, and various ministers have been asked to make contributions to that
when
work.
Minister Harris was asked specifically about Indigenous young people and youth justice matters in relation to them, the response from the Minister was, I haven't received anything specifically, but there is a group of ministers with Minister Daley as the Attorney General. So his understanding is that you are responsible, but you're now saying the Premier is.
I'm not sure who you can glean from that answer that he said I was responsible, but I'm happy to say I'm one of the leads and that I'm fervent about it, and I do want to take a leading role. You bet, yes, 100%.
But you're passing on to somebody else.
But in respect of the work that the Premier announced last week, after he went to Moree, that's a different project altogether.
So there's two working groups now.
No, there's not two working groups. There's a group that the Premier put together last week to come up with some solutions after he went to Moree. But generally speaking, as I've explained to you now for about the 5th time this morning, there's about 7 or 8 ministers that have overlapping responsibilities for justice and youth justice, and we've asked the Department of Communities and Justice months ago to do some work to look at support services and diversionary measures for young people. I don't think that's terribly confusing.
Minister, the Minister for Indigenous Affairs has said that any new laws that would be needed to deal with the problem of child sexual abuse in Indigenous communities in country New South Wales are your responsibility. What steps are you taking?
You've conflated two issues there. One is whether there are any new laws are my responsibility, and what steps am I taking? I've answered
What
that
steps
question.
are you taking towards the development of any new laws?
I've just answered. I spent half the morning answering that question, and I've just answered it right then. So I rest
Minister,
on my answer.
other than talking about it with people, what concrete steps are you taking to address this real problem facing our children?
I've answered that so many times this morning, I can't begin to even count. We're almost up to double-digit figures now.
All right, well, we might move on, Attorney General. An election commitment made by the Labor Party in 2022 was to deliver an independent victims commissioner. What steps have you taken to
I've
implement
answered
this?
that question already. I think Ms Higginson might have asked me about that this morning. Already, I've answered it.
And what was I missed the answer.
I said that it was an election commitment, that we intend to honour all our election commitments, and that there's
Has it been budgeted for?
You'll have to wait to see what's in the budget. I said that it is something that we are working on in conjunction with the review of the Act.
If I might jump in, Minister, we don't need to know the amount. Will it be in the budget?
You have to wait to see what's in the budget.
Did you put in an NPP for this program to appear in the
I'll have to
budget?
take that on notice.
Thank you.
The Minister for Women has said that she's working with you regarding a New South Wales strategy for reducing elder abuse. What's your view on this?
On my view on what?
The strategy on elder abuse, the prevention of elder abuse.
Well, it's an important piece of work, and it'll be continued, but I'm not the lead minister for that.
But the Minister for Women said she's working with you on the New South Wales strategy to reduce elder abuse.
Yeah, and that'll be being worked on by the department, not directly with me. But the New South Wales government has, however, established a working party alongside community representatives to advise on the New South Wales Law Reform Commission's review of the Guardianship Act 1987. The Guardianship Review report made recommendations for review of the guardianship framework. We're also working with Commonwealth and other state and territory governments to implement the plan to respond to the abuse of older Australians, 2009 into 2023. and the Coalition of Attorneys General is considering proposals for reform of enduring powers of attorney laws, and the Commonwealth is leading this work, and SCAG will receive further information on these proposals.
Thank you. We also discussed in estimates the BA versus the King, I followed up with the Minister for Women, and she said, I'm aware that the Attorney General is working through that decision and the impacts that decision has had in relation to our laws. I wanted to know what has happened with that.
We discussed this at the last estimates, and I reported then that the government would have some legislation to bring before the Parliament to address the implications of BA.
Do you have a time frame for that?
No, I don't, but it's not something I want to have delayed. When it's ready, we'll bring it.
And
Because
are you in
it's- because
discussions with
it's an
the
important
Minister
issue.
for Women on that?
Yes. Well, am I? Well, we've had discussions, and the result of those discussions is that legislation's been prepared.
But you have no time frame?
No, but sooner rather than later, I hope.
Minister, you've conducted closed consultations about your conversion practices bill. Will you be holding public consultations before the bill is introduced?
No.
Why not?
Because, as I said earlier, I received advice from the department on consultation on various projects generally about the best way to go forward. My advice was that a closed consultation to I was almost about to say small targeted group was the best way to go, but I think that, correct me if I'm wrong, there are about 150 groups that ended up making a contribution to that. In addition to that, in the initial consultation phase, there were a number of groups, I can't tell you how many, who expressed that they were very, very happy to work with the government to consult with and craft the legislation, but that they would prefer that their identities were not made known. So that was one of the considerations as well. But there's been extensive consultation.
I understand that as a consideration for a private consultation phase, but why on something that impacts every member of the community, and which I think everybody in the community is really interested about? Why would you not have open public consultations about this important matter?
Can I just explain that?
No, with respect, Minister, I heard reasons for why you had chosen to initially begin with a private consultation. I'm asking now why there's no public consultation, and will there be a public exposure draft of the bill before it's presented to Parliament?
I've just explained to you why it was that we went for
initially
closed.
for a public,
not
for
initially,
a private,
initially and ongoing. I've explained that.
And I haven't heard an answer with respect, Minister, for why you wouldn't be opening this discussion to the whole community and providing an exposure. Will an exposure draft be provided before the bill is presented to Parliament?
I don't think that's the plan. I'll correct the record if I'm wrong, but I don't think that's the plan. I think
Is there
we'll
a
be bringing
reason why
legislation.
you're not circulating it broadly?
No, because we're satisfied that we've consulted with the groups that we needed to consult with. We're satisfied with the degree of consultation, the issues that were raised, and we are satisfied that it's been a very high quality and very productive discussion, and that the stakeholders that we've consulted with, which is very, very broad, I have to say, have really valued the in-earnest discussions that we've had with them.
And will your bill respect parents' rights so that parents are empowered to have important conversations with their children about their sexuality and not fear that they will be sent to prison for being a parent?
Yes, those rights will be protected.
Excellent, thank you. And
But you'll have to wait to see the bill.
I wait with bated breath, Minister.
Got a few bills there waiting.
Yes. In respect of the Equality Bill, will you be supporting that bill's attempt to legalise prostitution near schools and places of worship?
As I explained this morning, the government will announce its position on that bill and the various aspects of it in due course.
Do you have a time frame on that, Minister?
Sooner rather than later, but I can't put a time frame on it.
Thank you.
Again, that's a bit like the conversion practices bill. There's a lot of consultation happening behind the scenes. We are accepting a huge volume of submissions, and we're having a lot of meetings with stakeholders about that. And so we don't want to give a definitive timetable because it's the discussions and the outcome of those discussions that should drive the timetable, and not just have a tokenistic timetable per se that the discussions have to fit into. They have to have a life of their own, and we're very pleased with the consultations that we've had.
Thank you, Minister.
And I want to thank the Honourable, well, not the Honourable because in the lower, Alex Greenwich, a member for Sydney, for the cooperative way that he's engaged with us as well.
Thank you.
Been very, very respectful.
Attorney, can I just ask, you committed, I think, to a review of NCAT prior to the 2023 election. Is that still a review you're committed to?
I'd have to just go back and see what the terms of the review we promised. It wasn't a review of NCAT per se. I think it was a review of certain practices of NCAT, I think.
Yes.
It was a review of the role of NCAT in rental disputes.
Yes.
So there's an election commitment that complements a broader package of reforms being led by the Department of Customer Service that aim to make the rental system safer and fairer for tenants.
And so is that happening? Just
what's the latest on that? I think
It is happening. I think we would need on the specifics to take it on notice.
Yeah, I don't have the timetable for you.
If you could take it on notice, because there is great interest.
Sure is, and
if you could
we didn't make that commitment in vain. I intend to do it.
Yeah, so if you could confirm when the review will take place and that accessibility to renters remains the kind of within the scope of that review. I understand that's what you're articulating, but if you could confirm that.
Sure.
There's concern out
there.
there. There's concern about what's happening.
I think we haven't yet finalised the terms of reference, but we're not far off.
Thank you. Attorney, there was a poll, I think it was yesterday or the day before.
I knew someone would go here.
That said people are giving up on Labor.
Yeah.
One of the things that I think the manager of the poll said as the reasons is that Labor's just not performing, or it's going too slow, and people were expecting progress. What's your agenda? What are you doing as the principal legal officer of this state? And I know that your Labor profile, you boast about introducing some of the toughest laws in the country.
Do I? What profile are you reading now?
It's a profile. It was something that you'd put on your New South Wales Labor profile in the past. It's Labor New South Wales profile of you. Perhaps you want to change that. Maybe you want to change that now, Attorney, now that you're actually in office and the Attorney. But
you probably read the ALP website.
Literally says some of the toughest laws in the country, that's you. You introduce them. But I want to know, and I think all of New South Wales wants to know, Attorney, what is your agenda for the next 3 years? What is on your plate, what you want to do as the first principal law officer of New South Wales for all of us over the next 3 years?
Well, we've spoken about a whole raft of matters that I'm attending to at the moment, and I think it would be fair to say that one of the things that really drives me is something that we've spent most of the morning talking about, and that is to have the government play a really proactive role in addressing the causes of crime.
So,
hold on, you just asked me the most open-ended of questions.
Great, keep
that
going.
Gives me the enormous amount of liberty. If you want to ask me a question like that, let me have the time and don't interrupt me. Otherwise, interrupt me.
So let's do it. Right? The causes of crime, Attorney. What are you doing about it?
No, that wasn't the question. The question was, what are my goals for the balance of this term? And one of the things that I really want to do is to have governments of the day, whatever persuasion, do more about early intervention. I get to see juveniles and adults at the very end of the justice system. When they come to my court and go to annex jails, it's all over by then. What I want to see is governments pay attention to the causes of crime. There's no little kid that grows up and says, when I get older, I want to go to jail. They don't. So they go to jail because they're from dysfunctional families. They get sexually assaulted. I visited the Wallimer court early in my term and spoke to one of the youngsters who came before the court, then a bloke who was 21 years old, and he'd been to 5 foster homes in his life and had been sexually assaulted at every single one of them. It's no wonder he's in jail. So what I want to do is to have governments of all persuasions from time to time take seriously their responsibilities in addressing the causes of crime and making sure that all the pastoral care that should go to families goes to them, that kids are properly educated, that drug and alcohol problems are dealt with, and all these things that are driving youth crime in the bush now. And there is no easy fix to this. It won't be done in a year or 2 or 10. We've seen some projects like the Maranguka project in Burke. Sorry? Yeah, it's a great program, and it's been in operation now for 10 years, and the green shoots are just starting to appear. These are very slow moving programs, and so what you need to do is to start now and make sure that you invest in and conceive of programs that will survive the decades through changes of government, whatever they might look like. So that's the thing that really drives me.
Thank you. And so what are you doing? What's the Attorney-General's office actually doing?
Sue,
I understand they're the things.
I've told you this morning a number of times what we're doing. I don't want to just keep repeating myself. Well, I've asked the Department of Communities and Justice to work with other departments to look at the programs that we might bring to bear to support young people, to care for their parents, to provide for pastoral care for them.
So this is the work that you've instructed your department to do that you'll see in 12 months' time.
I don't know that I'll put a time frame on it.
Okay.
But we can't even talk about wanting to do these things if we don't know what they are, what form they will take, where they'll be built, how much money they will cost, the sorts of
so precisely
resources that need to bring.
So these are the things you've asked your department. Is that?
Yes,
I'm just trying to get an
stuff that they're
honest
working
view.
on. So we need a whole heap of psychiatrists and psychologists and counsellors on the ground in New South Wales. There's a shortage of them. Challenges like this, these are the things that we need to look at. This is what I've asked the department to look at. So the law and order stuff, the courts, DPP, that stuff largely takes care of itself. I have a supervisory role over all that, but what do I really want to do?
So you're not suggesting, so at the moment you're suggesting there's no need for reform in those sectors?
In what? No, I'm not suggesting that. I'm saying largely that they take care of themselves because the statutes guide my responsibilities. The hard part is the uncharted territory of bringing new resources and a new way of thinking and a new will to the causes of crime.
Thank you. So on that, at the moment, the Transforming Aboriginal Outcomes program that is working across agencies, and I will speak with Ms. Beattie later on and know that there's some fantastic work that is happening. What's your understanding of how that role works within your responsibilities?
All those issues overlap. What works for young black children works for young non-Aboriginal children as well.
And what's your understanding of the funding for the Transforming Aboriginal Outcomes program at the moment? Does that end in June?
I'd have to take that on notice.
Okay, if you could, because my understanding is the funding for that work ends in June, so I don't know whether
Sure, I'll take that on notice. But you asked me about my goals, so things like justice reinvestment. I mean, that's hope of the team, programs like that.
And have you got plans to be rolling these out throughout the whole state? Are there certain areas you're focused in terms of transforming outcomes for Aboriginal peoples in the justice system?
Yes, I noticed that the feds have funded justice reinvestment. We've also entered into a partnership with the Paul Ramsey Foundation to expand that out to additional sites. But what we want to do is to get an idea of what other programs like this government needs to invest in, and also I have to say to have NGOs coordinated better. So in the first couple of weeks that I was Attorney General, I went to Kempsey to talk to stakeholders out there in relation to youth crime and Aboriginal youth crime and social issues in particular. And one of the things that was brought home to me by the police and other stakeholders was that there's sometimes a myriad of NGOs on the ground who provide services to youth and Aboriginal youth and things like that, but no one really maps or coordinates their efforts or has an idea of the quantum of funding or the specific programs, and so they might be overlapping. They don't sometimes talk very well to each other. Sometimes they do, sometimes they don't, but there's no consistency. So that's another thing that we want to have a look at as well, and I think the Premier made some comments about that last week in respect of his visit to Moree and the efforts that he wants to bring to bear in that regard.
And so so does it concern, like at the moment, Attorney, it costs over $750,000 per child to keep them incarcerated. Like that's $750,000. Do you not think that that is literally, even a small part of that money could literally be reallocated instantly if you were to raise the age of criminal responsibility tomorrow, for example? That money could literally be provided in various NGOs' hands to do a better job than what police and corrections are currently able to do, when it's very clear, and you've admitted and everyone across the state is admitting, this is the system that's failing young people and the recidivism rate. Is there not just a straight out clear economic argument that that money should be better spent outside of the criminal justice system, and that's something you could do tomorrow, apparently?
We could save a bucket of money by not locking people up.
So
But I've said to you at the outset that community safety is our paramount concern, and if you've got kids that continually reoffend and are a danger to themselves and to the community, it just doesn't make any sense to keep leaving them on the street where they're in danger.
Yes, but it's making less sense to lock them up. 81% recidivism rate.
It makes better sense to have programs to divert them away from the justice system in the first place.
So for $750,000, we're looking at over $725,000 per year per kid. Do you not think that case is what's stopping us from literally putting that straight into diversionary programs?
One is long-term measures that governments can invest in and should invest in, and the other is what to do in immediate terms with the young offender that's in front of you. They're two different things. I think you're conflating them.
I don't think they're conflating at all. One is there's a deadlock, and I'm just not sure that you're providing any assurance here that you understand the deadlock of this continuing incarceration of young people, notwithstanding all of the evidence that it's failing, notwithstanding all of the unbelievable costs that it's costing us, and you don't actually have a kind of fulsome plan about how to get out of the deadlock.
That evidence says that there's a better way to deal with the young
Every other state is doing it, Attorney.
No,
every state now.
No, they're not.
Which one's not?
Queensland's not doing it.
Oh,
I think
Queensland.
Western Australia are equivocating now. All the evidence says there are better ways to deal with children outside of the criminal justice system. And so the next step in that quest is to find what are the better ways of dealing with them and to put them in place in New South Wales.
Will you still be taking advice from... Is WA still doing some of that work that was committed to under the former MAGs? The meetings of Attorney General before it became the SCAG. SCAG.
No, that work's finished, Mr McKnight informs me.
Okay, so did we take any advice from... Did that work get completed? Do you know?
Yes, the report was issued after the December...
That's
SCAG
right.
committee.
And so have you taken any advice from that report about what's required and how to do it, and what the ACT is doing around the wraparound services, or are we just starting from fresh with this new task force?
No, we're being informed by all of that work, and I'm keen to see what other states, what alternative pathways the other states put in place to deal with young offenders other than incarcerating them. I'm keen to see that, but as yet there's not too many examples on the ground in Australia about how to do it. There's one that I've become aware of in the Northern Territory. I think that the Salvation Army run, which I want to go and see as soon as I can. But there's not any great success, I don't think, across Australia in alternative treatments for young people in the criminal justice system. And until that work is ready, we wouldn't even begin contemplating raising the age.
And so, okay, so then just, I know this is going to feel like we're really over-labouring, but I just don't...
years. Years and years.
So years and years. We're just
Yes.
going to keep failing, using the current system for years and years and years.
Well, it'll take years before we've got an alternative pathway up. Yeah, I'm not. I could fluff around here and pretend we're working
So
on
what
it
if-
and not
what
give them
if-
any time frame. But I don't want to leave you or any member of the public in any illusion that there's a quick fix to these problems. There's not. They're deep-seated problems that have been decades and decades and decades in the making.
So, Attorney, how do you reconcile this opinion? How do you reconcile your view with the Attorney General's view from those other states who have made the decision to raise the age and those that have got on with it?
They can make the decision to raise the age. As I've said, that's the easy part. The hard part is what you do with what's the alternative regime, and I'm keen to see what they're doing.
So,
And you can't
Attorney, what
compare-
about...
You can't compare a jurisdiction like New South Wales and the ACT. From here to Moree, you could drive across the ACT 3 times. The geographical distance imposes limits and challenges for New South Wales that small jurisdictions like the ACT don't have.
So, okay, so we're not going to raise the age. So you're saying then, so just so that we're clear, and I know this is going back to my colleague's point, but we really aren't clear. So at the moment, you're part of what the Premier announced, which is some kind of task force with the various departments, and you're all looking at ways to deal with young, vulnerable people who are committing crimes or at risk of committing crimes, and that's going to take years and years.
No.
No?
The work that the Premier has tasked us to do will come to fruition shortly. But in the longer term, we need to look at a whole range of programs and investment right across New South Wales for the future.
So it's
and that work predated the work that I'd asked, and other ministers had agreed and asked DCJ and other departments to do, predated the Premier's announcement last week about the work that he's asked the Cabinet Office and other ministers to do, arising from his visit to Moree.
Okay, and so this will be, as a result of that, this work is aimed at diverting young people from police contact or from the system or from incarceration? What's the kind of terms?
The Premier's work you're talking about?
Yeah.
Well, I'll just have to refer you to the statements that the Premier's made and I've already read into that Hansard this morning. I don't want to go back over old ground.
Okay, and so that is just basically those statements made to the media?
Yes.
Okay, and so all right, and so where's the accountability? How do we find, obviously we're here now, and how do we find the sort of terms, how do we measure the success of what the Premier's announced to the media, of what we're going to be doing to further this state in terms of outcomes for young people at risk?
How do you measure success? I suppose there are various ways.
If we don't know what we're doing, if it's not clear what we're doing, or we've just got those comments
you'll
from
have to see,
the Premier.
You'll have to wait and see what we announce.
Wait and see. Okay.
Yes.
All right, we'll do that then. We'll wait and see. So is it your desire to just see less numbers at some point of young people?
That's a cracking indicator of how many people are getting into trouble, fewer people being arrested by the police, fewer people being incarcerated, fewer people being prosecuted. Yeah, I really want those numbers to drop, and we've got responsibilities under the Closing the Gap agreements, for example, in respect of those. But there are other measures as well. I mean, happy, functional families that are raising well-adjusted children and things like that, they're measures too. They're hard to measure, but those sorts of things result in citizens leading happy, successful lives and staying out of the criminal justice system.
Thank you. I think we've got time for the
Opposition?
Yeah.
Okay. Minister, you discussed before the, as I think you put it, the broad but closed consultation in relation to the Conversion Practices Bill. How many women's groups were included in that consultation?
I'll take that on notice.
Okay, and if certain community groups wish to be part of that consultation, were they all able to be part of that consultation and have their voices heard?
No, not every group. No.
Why is that? Why were certain groups excluded?
I've explained.
Minister, with respect,
why we went
you
through.
haven't explained why certain groups would be excluded from having their views heard on an important matter of public policy.
I've explained that already this morning. I'm not going back over old ground.
Could you explain why, for example, an advocacy group such as Women's Forum Australia was not permitted to be part of the consultation?
I just told you I'll take on notice that
Okay,
whether the women's groups were involved in that.
And the equality legislation, very encouraged by your, I think, a beautiful statement of the nature of democracy, really, where you're talking about the broad consultation that is occurring, and I can certainly confirm it's occurring in our inboxes and in our meetings as well. Does this ongoing consultation mean that this bill won't be coming on for debate in March?
I don't know what the timetable is for that bill being brought on. You'll have to wait and see. I think I've made that clear this morning.
I think we're waiting to see a lot of things, Minister, with respect. Okay, perhaps I can go to another matter.
I do have to remind you, it's not a government bill. This seems to be causing some angst in the community about the government's equality bill. It's not the government's equality bill. It's Mr. Greenwich's bill. It's not mine, and it's not the Premier's, and it's not the government's. It's a private member's bill.
Which, as I understand it, is due to lapse this month if it's not debated, unless, of course, the government agrees to an extension of time.
We'll wait and see.
Do you intend to agree to an extension of time?
Well, I've just said we'll wait and see.
For whom are we waiting to make these decisions?
For Mr. Greenwich. It's his bill.
Thank you.
It's in a queue to be debated before the Parliament. Private member's bill in the lower house go into a chronological queue. But we are working cooperatively and productively with Mr. Greenwich to manage some of the issues that have arisen in the consultation. And it's a matter for Parliament, not for me or the government, as to whether there's an extension. We might have a view on that, but if there's going to be an extension, it'll be put to a vote on the floor of the Legislative Assembly where all members can have their say.
On another matter, have judicial salaries been frozen as part of your 2-year pay cap?
Yes.
And when did you discuss this with the heads of each jurisdiction?
I didn't.
So how were they informed of this change?
I'm not sure how they were informed. I'd have to go back and have a look.
Is that a respectful way to deal with the judiciary?
Well, the government made a decision as part of its budgetary processes to embark upon savings measures, and the top echelon, if I can put it that way, of public servants' salaries were frozen for 2 years, including mine and everyone sitting around this table.
If you were a union official, would you be happy if an employer told their employees to read about changes to pay and conditions in the newspaper or on X?
I've never been a union official, so I don't know.
As can you perhaps put yourself in the position of a union official? I'm sure that you have many colleagues who are in that
No,
position.
I could put myself in the position of Mike Baird, who made the same decision a few years ago to cap everyone's salaries at 2.5%, which caused enormous damage to the public sector in New South Wales, and on top of that sacked about 30,000 people. So you're not really coming to this argument with clean hands, Ms Higginson.
I'm asking about
Did you just say Ms
communication.
Higginson? Did you just say Ms Higginson? Sorry,
Sorry,
you're
Ms.
talking
Hyde.
to Ms Carter.
Deepest apologies, Ms Carter, sorry.
It's okay. Just pull you up there.
Thank you. I'm sure the Hansard would have caught that one anyway.
I'm sure they would.
Attorney, are federal judges also the subject of a wages cap?
I don't think so. No.
So does it concern you then that we might be missing out on judicial talent in New South Wales if there's a wages cap in New South Wales but not for federal appointments?
If you have a look at the people that I've appointed since I've been the Attorney General, I think it'd be pretty hard, with all modesty, to argue that we're missing out on talent going to the bench.
I have the deepest respect for the judiciary, and I invite you to express that respect as well by defending them publicly.
I talk to the members of the judiciary all the time. They know how much I respect them.
Attorney General, in response to a supplementary question at last budget estimates, you were asked for a jurisdiction that had similar programs to the drug diversion programs here in New South Wales. The example provided was the Police Drug Diversion Initiative in South Australia. Yet South Australia currently has a higher level of prosecutions for drug-related offences in New South Wales. Would you say this is a good example of successful justice reform?
I'd have to go back and have a look at what the question was and what the answer was, but if you're asking me about whether the drug diversion scheme that we introduced, that was a policy of the former government that began last week or the week before, is a good policy, yes it is, and I think we've discussed this at length at the last estimates.
Also, South Australia has a higher number of drug-related hospital admissions per capita than New South Wales. Given that this is a shared justice and health initiative, does the lack of positive health outcomes in a similar jurisdiction concern you?
I'm not sure I'm in a position as I sit here to compare the different schemes, but the whole rationale for the program is to make sure that people steer clear of the criminal justice system and are diverted into treatment. And treatment, if it works, means that they won't end up in hospital. So it's a good scheme.
Minister, Attorney General, previously you gave quite a lengthy response about and almost a frustration at the lack of support that is available, particularly to young people, to divert them away from crime and various other things. You also referred to the Marinuka program, which was a joint agency, health, DCJ, police, led by the ministers at the time, quite successful. My question to you is, are you frustrated with some of your colleagues and their lack of focus on the importance of early intervention?
Absolutely not. What I am focused on is that in 2024, at 5 p.m. in Moree, the only government agency that's working on the ground there is the police. And I think that governments of all persuasions should have done better by this day and age to have had services on the ground to deal with young people who are breaking the law.
And did you raise that with your colleagues?
I've raised it with many people. I have raised it with colleagues. We all agree with that. And we do want to thank the police for the incredible work they do. I've been a Minister for Police. I know how hard they work. It's lamentable that we're about 3,000 officers down, and I was alarmed to see the Premier give evidence in estimates the other day that in the last 4 years, something like 2,000 constables and 750 sergeants have left the police force. So that's lamentable as well. I'm not frustrated at my colleagues. I'm frustrated at the former government for having not progressed this at all. But, you know, state and federal governments of both persuasions, of all persuasions over the last 50 years haven't done a very good job. And I know it's slow going, and it will be slow going, but this government intends to make a start. Just want to
Okay, thank you.
emphasise that there's no quick fix. You don't measure success in this regard, in months, it's years, but we want to make a start.
Thank you. Unfortunately, questions of the Minister are now over. I know you've taken a lot of questions on notice. The Secretariat will be in contact with you. In relation to return, you have some answers? Or
What am I?
More?
Which ones? Oh, the lot. Oh, they look a lot like the ones you handed me. I might just take a minute to read these questions that we took on notice into the Hansard, Mr. Chair. So Ms. Higginson requested clarification around the number of people in detention. What I said earlier is that as at 28 February, the following number of young people were in youth detention. Under 16 years, 77 in detention. Under 14 years, 12 in detention. Let me read that again for Hansard because I stuttered. Under 14 years, 12 in detention. Under 12 years, 0 in detention. Young people, 228 in detention. To clarify, there are no young people under 12 years in detention. At that time, as at the 28th of February, there was one 12-year-old in detention. Ms. Boyd asked me the question to the effect, in the last budget estimates, you commented every local court location either has a safe room or safe waiting arrangements for persons who experience domestic and family violence. What's been done to ensure there is a safe waiting room / arrangement within the court? Answer. All courts have either a safe room or safe waiting arrangements, either inside the courthouse or off-site at the police station. 5 court locations are too small to include a dedicated safe room, and heritage requirements prevent construction. Ms. Carter asked what would be the impact of the industrial court on the budget and existing courts. Was the industrial court pitched as an MPP? Answer. The government is exploring options that would manage costs while also ensuring that the standard of new facilities meets operational requirements. This includes consideration of funding arrangements. Ms. McLaren-Jones asked what is the domestic violence waiting time in courts? Answer. Boxar data shows the median number of days from arrest to finalisation for local court appearances involving a DV charge finalised in 2023 was 155 days. Ms. McLaren-Jones also asked how many cases are waiting at Waverley Court and what is the wait time? What is the wait time at Bankstown Local Court? Answer. As at January 2024, the delay at Bankstown is 20.5 weeks and Waverley is 25.9 weeks. This is the time between listing for hearing and the hearing taking place. In relation to conversion practices, Ms. Carter and Ms. Conn asked me a question regarding conversion practices. The conversion practices bill / reforms, what consultation process has been undertaken? My answer is, on 22 May 2023, the Department of Communities and Justice and Ministry of Health established the LGBTQ+ conversion practices ban working group. The working group includes representatives from the Cabinet Office, the Department of Education, Multicultural New South Wales and Anti-Discrimination New South Wales. Almost 150 organisations were engaged in the consultation work that took place between 31 July and 25 August 2023. The confidentiality of the process sought to facilitate frank discussion and contributions from stakeholders to inform the government's development of legislation. A large number and a wide range of stakeholders were invited to sector-specific roundtables which took place across August 2023. Stakeholders include members of the health, education, legal and government sectors, faith and multicultural organisations and LGBTQ+ community advocacy organisations. The issue of Martinez and the complaint to the Judicial Commission, Ms. Mihalik asked me what are the grounds for referring a judge to the Judicial Commission. The answer is Section 15 of the Judicial Officers Act 1986 provides that any person may complain to the Commission about a matter that concerns or may concern the ability or behaviour of a judicial officer. Additionally, per the Judicial Commission website, the Judicial Officers Act 1986 provides a means for people to complain about the ability or behaviour of judicial officers, but not their decisions, and to have those complaints examined by an independent body. The Judicial Commission can only examine complaints about the ability or behaviour of a judicial officer. Common causes of complaint to the Judicial Commission about the ability or behaviour of judicial officers that may have affected the performance of judicial or official duties include failure to give a fair hearing, bias, incompetence, inappropriate comments or questions, collusion, discourtesy or unreasonable delay. And further, the Minister for Police's office has advised the New South Wales Police Force is 1,500 officers under strength, not 3,000.
Yeah.
That concludes my questions on notice.
Okay.
on leave. Yeah.
That's all your questions on notice.
Thank you.
Okay.
Can I thank the committee members
Thank you.
for their courtesy this morning? For a good hearing, I think. Thank you.
Okay, we'll call an end to it now and start again at 2 o'clock. Thank you.
Thank you.
Okay, we might go back on the air. Thank you. Just before we start, I've just got a little script to read. The committee has resolved to expunge the name and other identifying sensitive information of an individual identified in relation to a district court matter during the morning session of this hearing. The committee has resolved that this individual's name be expunged from the transcript of evidence and the recording, that media not report on the comments made, and for members of the public not to repeat them. Any act or contravention of the committee's resolution may not be covered by parliamentary privilege, may constitute an unauthorised disclosure and therefore represent a potential contempt of Parliament. Okay, we'll proceed. Opposition questions?
Okay. Thank you. Ms Dowling, it's going to be hard to see you, isn't it? I'm interested in 93Z, and I'm wondering if you can tell me how many briefs of evidence you've received from police for prosecutions under 93Z.
Yes, since its introduction, the ODPP has received 13 briefs.
Mm-hmm. And how many of those have you chosen to authorise for prosecution?
In 11 of those matters, a recommendation to lay charges was made.
So you said yes to 11?
We advised police on the laying of charges.
Okay.
In 11 matters.
And they proceeded to court?
Excuse me for a moment, I'll just... 2 matters were returned to police. 11 matters were dealt with by my office.
Mm-hmm. So the 2 that were returned to police, what was the reason for returning them to police?
That's privileged.
Okay.
And, I would rather not answer
No,
that
that's
question.
fine. No, that's fine, yeah.
Thank you.
And the 11 that were dealt with by your office, they were dealt with as in authorised to proceed?
That's right.
Okay, and you don't know the disposition of them after that?
2 of them have proceeded summarily and resulted in convictions in the local court.
Mm-hmm.
Both of those matters are subject to appeal. One has been overturned on a conviction appeal unrelated to, for a fairly technical reason. The other one is listed for a conviction appeal on the 28th of March.
Okay, and the other 9, you understand, are still in the system awaiting trial
I will have
somewhere?
to, yes, I'll have to take that on notice.
If you
but I
could,
should be
I'd
able
be
to
very grateful.
respond to that this afternoon.
Yeah, no, look, I'd be very grateful. No, that would be very helpful. Because I'm just really trying to get a picture of what's happening with 93Z and how it's working, because you'd be aware that the police minister in estimates testimony said, and I quote, "There were and have been significant delays that were with the DPP." Do you understand that?
It may be helpful for me to explain the process
Thank you.
that happens between police and my office. So when police want advice on whether a charge should be laid or whether there is a sufficiency of evidence, the brief of evidence is forwarded to my office. It's then allocated to a solicitor. And the whole of the brief is considered in giving that advice on whether the test for prosecution, which is in the prosecution guidelines, that is, are there reasonable prospects of conviction and is the prosecution in the public interest? Advice is given on both of those aspects of the prosecution test, and the matter is then sent, that advice is provided to the police. Necessarily, given the volume of work that my office undertakes, that process takes some time. It's often the case that other charges have already been laid in relation to the same conduct, and they can be laid by police without that need for a sanction or advice. So I assume that that's what the Deputy Commissioner is referring to when he was talking about delay. There is a delay in the process, and that's the normal delay that inheres in the provision of proper legal advice based on the whole of the brief of evidence.
And can you give us some sort of rough estimate of what sort of time delay we're looking at?
We have a protocol for the provision of advice, and it depends on the complexity of the particular brief. I have to check the actual timeframes in that, but I'll revert to you shortly.
Yeah, no, I'd be grateful. Thank you very much. And from I think you said the consideration of 13 briefs, did you identify any issues with the operation of the provision itself that caused you concern or that you flagged as difficulties or?
No, each matter is considered on its own merits and by reference to the terms of the section. The broader operation of the provision is a matter which I understand is the current subject of review by the New South Wales Law Reform Commission, but it doesn't arise in a case-by-case analysis that we undertake.
And are you aware of any adverse comments that may have been made by judges in relation to the two prosecutions under 93Z where they found difficulties with the threshold test or the operation of the section?
I'm not aware of that.
Right. Okay. So the only difficulty with 93Z that comes out of your office's experience would be the perceived difficulty with the police in terms of the delay that this adds to the process?
I don't see any difficulty from my office's perspective, but I understand the frustrations of the police.
Yeah, okay. And in terms of any delay that's experienced by the police, is that an issue that could be addressed by additional resourcing for your office?
Well, the issue's gone away now because the sanction of the director is no longer required, so those charges can be laid by police at the police station.
If the section was still as it was, is that an issue that could be dealt with by additional resourcing for your office?
In terms of the length of time taken to provide advice, I will never say no to more funds for my office. I'm sure everything could be done faster with more lawyers.
Yeah, no, thank you. Because I'm sure that if the police are experiencing delays in this, there would be other issues as well, because I imagine you must have a considerable amount of work.
We handle 18,000 matters a year. The volume of work that my office and my lawyers handle is extraordinary, and giving proper considered advice in complex issues such as the operation of 93Z, which is a relatively complex criminal provision, that takes time.
Oh no, I'm very sympathetic, and it's, you know, good legal advice takes consideration and time. Absolutely. No. Can I take you now to the judgment in Crown and DS, which was a judgment from Judge Wass in September 2022. Are you familiar with that judgment?
I am.
And the judge made some observations in relation to a sexual assault case. She referred to the prosecution guidelines, and I'm quoting from her now when she said that the prosecution guidelines have said that differ in my view, the test to prosecute failed on each of those important indicia, and she went on to say this is a troubling matter. The bringing and continuation of unmeritorious cases in abrogation of the prosecutor's responsibilities imposes a burden not only on the criminal justice system but on all of those involved in it. So what's the process in your office? This judgment is handed down, then is it, because of the comments, is it automatically brought to your attention, or is there a review process at all? How does it work?
Every solicitor with carriage of a particular matter has an obligation to bring a matter to my attention if it has controversial comments in it, or if that solicitor forms the view that there is that consideration should be given to a Crown appeal. I'm sure you are aware that there is a lot of law from the High Court to the effect that Crown appeals should be brought only in on the rare occasion, and they should be brought for the purpose of elucidating or clarifying the law. So a high degree of restraint is required on the part of the Crown, and that is something that is always at the front of my mind when considering whether to appeal. The process of finding a bill, to use the old parlance in our office, has changed since 2018, when the early appropriate guilty plea scheme was introduced. And in very sort of broad brush, a broad brush explanation.
Sorry, I'm not trying to interrupt you. I'm just conscious we have limited time, and I value the broad description, but I guess I'm really looking at the review process and the mechanisms.
What I was wanting to explain to you is that there are points in time in the life of a particular matter in the ODPP at which these decisions to prosecute are overtly considered, but they are also considered.
Sorry, I'm not traversing the decision to prosecute.
You want
I'm traversing
to know about
what are the internal processes when So the solicitor comes and brings this to your attention, or to an intermediary?
So depending on the level of solicitor who has the handling of it, a report will be done. A second report will be done by that person's more senior solicitor.
Do you remember in this case, did it go to a superior or did it come straight to you?
I'd have to check back on that.
A couple of years ago, yes.
Then it comes to what's called within our office directors' chambers, which is comprised of myself and my 3 deputy directors, who are all senior counsel, and we have 7 extremely able solicitors who are working with us.
And what do you do
section.
then? What's the review process?
One of those solicitors will do also a report, and then a decision will be made whether to appeal or not. And that decision's made by a
Sorry,
deputy director.
I'm not talking about appeal. There's a criticism here of the way that your office has worked.
Thank you, I
What is
apologise.
the internal process in terms of, okay, did we do a good job? Does a staff member need more support? Does somebody need more training? What's that how do you respond as a management pathway, I suppose, to quite a significant critique of work that comes from the office?
There are a number of different responses that
and in this case, what responses were there?
Criticism, I'd have to
if you
that
could
on
take that,
notice.
yes, thank you. And
there's a register that's kept of judicial criticisms, and the individual practitioners who are involved in that decision. An analysis is done on the papers, they are counselled. We reassure ourselves that they understand what went wrong in this particular matter. A decision may be made that there is a broader training and development deficit that needs to be addressed, in which case that'll be developed. It may be as simple as an all-staff email, it may be training at one of our internal conferences, it may be having an external practitioner.
And can you tell me what was the outcome of this judgment? Was there training at an internal conference? Was there an all-staff memo? Was it an individual staff issue?
I'll have to take that on notice in relation to this particular one, but I can indicate that it is my position and that of the Solicitor of Public Prosecutions and the Senior Crown Prosecutor that there is no systemic problem with the way in which...
I'm not asking you, I'm just trying to step through and look at the evidence piece by piece. In this matter, was there costs awarded against the DPP?
Costs are not awarded against the DPP. Okay. A cost certificate is issued in accordance with the Costs in Criminal Cases Act. And
was a cost certificate issued in this case?
My understanding is it was, yes.
Was the cost judgment reported?
I don't know.
Are you able to provide us with a copy of the cost judgment?
Yes, yes.
Thank you, that would be great. And I also understand there's reports of
I'm sorry to interrupt you. The cost judgment is the judgment to which you are referring.
Oh, okay. So
that's
thank you.
The Queen and DS 2022 New South Wales District Court 441.
Thank you. And are you aware of a judgment of Judge Lerv, I believe, in 2023?
I am.
I couldn't locate that. Is that a reported or an unreported judgment?
I don't know if it's on case law in New South Wales, but...
are you able to provide me with a copy of that and any judgment in relation to a cost certificate that was made?
If this is... Do you know the name of the case to which you are referring?
No. I was presuming because I understand that there was also, perhaps it's in your Register of Judicial Criticism, I think you said it was called. I presume it would be recorded in there and you could identify it from there?
I'm assuming that you're referring to a decision called the Queen and Cowled.
I just have the name of the judge.
Yes, this is a decision of Judge Lerv.
If I could be given a copy of that, thank you.
Just if I can cut to the chase, if you're referring to the judgments, the judgments of the judges that have been referred to in the media, then that is the decision.
Yes, that is, yeah. Thank you. And was there a cost certificate awarded in that case?
There was, yeah.
And were similar criticisms made in relation to prosecutions by Judge Lerv in that case?
No, I don't accept that, and I refer you to paragraph 84.
Well, I'd love to see it when it's available. I don't have it, so perhaps we can have that on notice.
It is somewhat difficult to have this discussion if you don't have the judgment.
No, which is why I asked if there could be a copy.
Available.
That would be great. Thank you. And so. You're aware that this matter has been ventilated in the press, And I'm wondering, are you able to review your Register of Judicial Criticism, is that what it's called, and identify if there are any other matters where there have been similar issues raised by judges
I'm
in
not aware
relation?
of any other matters.
Are you able to review that register and check for us?
I don't need to, because I am familiar with what's in that document.
Good.
And I am not aware of any other. May I make one point in relation to these 4 judgments? I have not received any complaint of this kind directly from any of these judges or from the Chief Judge of the District Court about these particular
Can I ask you
criticisms.
about that? Do you commonly receive complaints directly from judges?
I do.
In what circumstances?
They often call me up and will say, I have a concern about a matter that has resolved, or never a current matter, or about the way in which something happened.
So you said you haven't received anything directly in relation to sexual assault matters. What matters have you received complaints from judges about?
I'd have to take that on notice.
Sorry, this was something you just raised?
Yes, but there could be complaints, and I mean, I don't have...
Yeah, if you can take it on
well,
notice...
I'm trying to answer your question.
I'm sorry, you just said you can't answer the question because you need to take it on notice.
And I'm elaborating on my answer, if you
Thank
let
you.
me
Well, I'm
please
very
finish.
conscious that we have very little time, so if you could take it on notice, and if you could provide a list of all the matters which judges have raised with you as criticisms of the operation and the prosecution, I would be very grateful for that list. Can I take you to the judgment in Crown and Martinez in December 2023? And I think you're familiar with that matter as well.
Mm-hmm.
And Judge Newlands, I note, said in that case, most importantly, I do wish to record that I am left with a deep level of concern that there is some sort of unwritten policy or expectation in place in the Office of the Director of Public Prosecutions of this state to the effect that if any person alleges that they have been the subject of some sort of sexual assault, then that case is prosecuted without a sensible and rational interrogation of that complainant, so as to at least be satisfied that they have a reasonable basis for making that allegation, which would include to at least being satisfied that the complainant has a correct understanding of the legal definition of sexual assault or sexual intercourse without consent. That's a very strong statement from a judge. What was the process initiated in your office in response to that statement?
Was to have a close examination of the whole of the trial, including the brief, and to consider whether there was any justification for that remark, which there isn't.
So was there any action, any management action flowing from that in terms of an education program, an all-staff email, counselling of a particular staff member who was involved?
I am hesitant to say too much about this particular matter for obvious reasons.
Sorry, what reasons are they?
I think that you know what reasons they
I
are.
don't, which is why I'm asking you.
It is the subject of a complaint to the Judicial Commission.
Okay, but does that mean that you can't tell us what management decisions you took in your office in response to this comment by the judge?
Well, the response that I took was to consider the judge's comments, which I think are completely unwarranted and misguided. So that being the case, I of course, leaving aside the obiter dicta remarks in this judgment, which were very offensive to the integrity of the 480 solicitors in my office and the 110 Crown prosecutors, in addition to myself. I also, of course, considered whether the prosecution guidelines were fit for purpose.
So you considered the judgment. There was nothing in terms of staff training. There was nothing in terms of an individual staff member. The consideration went to the fitness of the prosecution guidelines themselves.
I haven't finished my answer.
What? That's what I'm asking you that question. Was that the response?
That's not. So I have my team and I read the entire transcript and looked at the circumstances of that prosecution, that particular prosecution, because of course...
And was there staff counselling as a result?
I'm still speaking, Ms. Harder.
I'm asking you to get to the point with
Well, I'm
respect.
sorry, I'm trying to do my best. view taken within my office is that those comments were unjustified and that there was nothing about
You've said
this
that.
prosecution.
What flowed from it? Can I ask specific questions? Was there staff training instituted as a result of this judgment?
There's constant staff training.
Was there staff training instituted which flowed from this judgment?
There was the routine and constant staff training on the
So
application
nothing
of the
specifically in relation to
prosecution
this
guidelines.
judgment. Was there an all-staff email which flowed from this judgment?
I believe there was an all-staff email rejecting the damaging comments of the judge.
Could you provide a copy of that for us, please?
In due course.
Thank you very much.
Take that on
Was
notice.
there counselling of an individual staff member as a result of this judgment?
I will also have to take that on notice.
Great, thank you. And you said you also then reviewed the prosecution guidelines as a result of this judgment?
Correct.
And what was the result of that consideration?
My view and that of the rest of my team is that the prosecution guidelines are fit for purpose and appropriately set out the test for prosecuting in New South Wales.
And there was a cost certificate in this matter?
Yes.
Thank you. Thank you.
Thank you. I think this might be either for Mr. Tibble or Mr. Knight, but I just want to go back to what the Minister was telling us all about in relation to the Premier's announcement or the Premier's comments in Moree, and in particular, what are the details of the work that the department and under his command and control, responsibility, what work you're actually doing to lead to the outcomes that the Premier has instructed that is happening?
So I think, as the Attorney-General indicated this morning, we're working across government closely with the Cabinet Office on a range of options for government to consider. I think the Attorney said this morning that everything was being considered. So that's the work that we're undertaking at the moment.
So, yeah, can you just help me understand what does that
Can
actually
I just
mean?
supplement
Yes,
that
please,
for a
Mr.
moment,
Tibble.
Mr.
Thank you.
And what Mr. McKnight said is absolutely the case. I would add separately, I am working closely with my colleague, the Secretary of the Department of the Premier's Department. We've also been touching base with Capo about some of those challenges and the nuances of dealing with the challenges within the context of closing the gap targets and the partnership that we are keen to develop. So there is that work. There is then a broader context around that, recognising that there are a number of stakeholders that legitimately should be part of an engagement process. But the work quite genuinely is still very much still in developmental stage.
And so do you anticipate then, and in that development stage, I'm just really trying to understand what the heck we are doing and what we're going to do. And I understand that it sounds very much like there's a lot of goodwill. That's what it sounds like. And I think people are really glad to hear that. But how will it actually start to walk out from, say, the Attorney-General's office, from your office as the Secretary, from Ms Beattie's input and role? What will we see in terms of, say, for example, let's just move from the northwest, let's go to the Northern Rivers, for example, one region. Are we looking at how we will get the input from that region about what's happening? And I'm talking about young people here, I'm talking about people under the age of 18, young people, and their intersection with the criminal justice system, or before that, their vulnerabilities. And I understand we're trying to take a whole of government approach to it, but what is likely to play out in the next couple of months that is any different to what was happening last month, in terms of understanding what it is we're going to try to do to improve things. I'm still not exactly sure what we're trying to improve yet. The Minister indicated that figures of young people intersecting with the criminal justice system would be one outcome, but and happy families was going to be another outcome. But what are we actually doing to protect those young people? And my interest, as you know, is the ones that are under the age of 14 and under, that are going to keep banging up against the criminal justice system.
I think there are two processes underway that I think the attorney was alluding to this morning. The one process is some work that we're doing in the immediate term, coordinated by the Cabinet Office, around some acute issues of regional crime involving young people. And the other process is the process that we are leading out of DCJ to look at alternatives to the criminal justice system for those children in that age range, the 10 to 14 age range, who are presenting with harmful behaviours and are currently coming into the criminal justice system. That second piece of work is longer term, obviously, and is involving a whole range of departments, including health, education, regional New South Wales, the Advocate for Children and Young People. The list is quite long, and is really looking at the alternatives that the AG was talking about this morning in terms of the way in which we might respond to the behaviours that they are presenting.
And so, thank you, this is very helpful. So with that work, are we looking at, so we're focusing on diversions and early detection, is that what I'm hearing? Is that the sort, or?
Well, so the work doesn't assume that the minimum age of criminal responsibility will be raised. The AG set out the government's policy on that this morning.
So are we still looking then at police being one of the very early indicators of when a young person comes on the radar in terms of the?
Yeah. So I think Ms. Higginson, you referred this morning to the report that SCAG released that had, I think, three main aspects to it when it was talking about the kinds of principles that should apply to harmful behaviours that young people are exhibiting. So there's a set of principles around first response, where young people present in a kind of acute situation. They're found committing a crime, for example. The second set of situations is a longer term response, where it's identified that young people need not just an initial response, but a longer term therapeutic response. And the third aspect are the kinds of services that need to be in place to support victims of that activity, because it's harmful activity that's happening, and there needs to be some response to that. It is inevitable, I think, that those harmful behaviours are often going to come to police attention in the first instance. Police are, as you'd be aware, the 24/7 service that's out there in the community, and are often the people that first see harmful behaviours of whenever it's presented. So whatever response we have needs to take account of that reality on the ground for police. Does that make sense?
Yeah,
to you?
absolutely. And so at the moment then, so what will be the system of this work? Like are you going to just be engaging with existing youth services, or it sounds like you've got good people lined up doing the work, and the youth advocate and DCJ, etc. But what about sort of further into the community? What will be the process? Like,
So this is really an initial piece of work looking at what's out there. We've looked at what's out there, and we're now beginning to think about, well, what could be needed and where those gaps
so where is the work that has collated what's out there?
So that work is underway.
Okay.
Yeah.
So we're still.
So we're in a situation where we're really doing work about the issues and what kinds of services might be needed.
Ms. Higginson, part of the challenge I'm having responding to this today is, in all honesty, both pieces of work, these issues in their current iteration are very contemporary, and I acknowledge that they're in reality not contemporary, but the profile of the issues now and in this permutation are very recent. This work is in a very early stage, so it's difficult to you may perceive that we're holding back. We're actually genuinely in the early stages, and one of the things I will say about it is, with the best will in the world and with all the complexity and the history, clearly some different things need to be done.
Yeah.
Can I just clarify as well that these are two different pieces of
Yes.
the acute piece and the longer term.
And so with the acute piece, so the acute piece is what the Premier kind of announced that is happening, and we've got. Are we actually referring to it as a task force, or as like I'm serious? Like how? So, for example, if I want to make inquiries on behalf of my constituents in 1 month's time, how do I communicate and ask for details on what's? So, if literally, dear Minister, I am inquiring about what would I refer to it as, or will that become known?
Look, I would describe the work that's going on as a piece of interagency cooperative work that's being coordinated by the Cabinet Office. I think that's how the Attorney referred to it this morning.
So it's interagency cooperative work that relates to young people and crime. Is that how we would, or is it brought? I'm so sorry. I can see the look on your face, and I feel like I'm making an absolute fool of myself. I'm honestly just trying to understand a bit better. Ms. Campbell,
I'm just going to add to this. This is not to do with that particular question, but in terms of what we're currently doing in this space. So you may recall we talked about justice reinvestment earlier today. On the 22nd of January, we announced 7.5 million, so there's now a justice reinvestment grants program, and that will prioritise 3-year proposals led by Aboriginal and Torres Strait Islander community-controlled organisations to help develop local solutions to curb the high rates of not just adults but young people in contact with police, courts and
Ms.
prison.
Campbell, so how much was that?
7.5 million.
7.5. And is that, at the moment, is there any place consideration for that, or is
Not
that
at this
across
stage. It's
anywhere?
across the state.
Okay, great, thank you. And so then the work that this the acute work that is happening, that will assess what's already in the pipeline, such as projects like what Ms. Campbell identified?
At this point, Ms. Higginson, I'm afraid these are questions that will need to be put to ministers. This is work that's being done in order to inform ministers and to allow them to make policy decisions. So you're leading me into territory I can't go into.
I appreciate that. And so then in your capacity, in that law reform kind of capacity that you have, would you likely, for this kind of work, be suggesting ways for broad community input and feed in about and taking a place-based approach to some of the issues that are being identified as the problems?
I'm not quite sure what you're asking me, Ms. Higginson. Would we provide fulsome policy advice that canvasses all the options and issues that are out there? Absolutely.
Yeah.
I'm not sure I can go much further than
And
that.
I think one of the parts of the question I think I'm asking is the recognition, and I think I'm probably crossing over in estimates here, and some of the things I think Ms. Beattie and others have spoken about in terms of place-based, presents very distinct issues that we're dealing with.
Indeed, and there's a broad range of work going on across government in a place-based context, in a service delivery context, in a law reform context, all designed to make the criminal justice system and social policy services as a whole better. That would be a very broad question about government policy overall. I think. I think as the attorney said this morning, everything is on the table. Everything is being considered, all options.
And okay, thank you. Can I just ask of you, Ms. Dowling, are you aware of the issue of police prosecutions? And I realise that I'm talking about police prosecutions, I'll get there in a sec, to your officer's role, but where allegations are made of a domestic violence nature, and then they're retracted, and then police are laying charges against the person who's made the retraction on the basis of the retraction only, and have police and police prosecutors and crime managers asked your office at all for any advice in relation to those kind of matters?
As you know, my office is responsible for prosecuting indictable offences to the District Court and the Supreme Court. In some circumstances, the ODPP has entered into agreements with other agencies to take over and prosecute certain summary offences in the local court or the children's court. That does not currently include prosecution of persons who are accused of making false allegations in domestic violence matters. My office and I recognise that there are complex public policy issues involved in the investigation and prosecution of domestic violence offences. It's my evidence to this committee that these are matters for police to grapple with, because they are the ones on the ground doing that investigating, and any questions of how the police deal with those types of prosecutions and the laying of those charges really should be directed to the police minister or the police commissioner. At the moment, there is no proposal on foot within my office or elsewhere, as far as I am aware, to refer any particular category of offences to the ODPP for prosecution, other than those that are currently contained in the relevant MOU between the Commissioner of Police and myself.
Okay, so there's no contact has been made for advice or assistance from police or crime managers at this point?
I will have to take that question on notice. I'm personally not aware of any particular request for advice in a particular matter, but I can make that inquiry for you.
Thank you. And the reason, the reason I raise it is I have put this question to the Police Minister and to, Deputy Commissioners and the Commissioner, and they express real concern that could be happening, and there was some evidence given that there is a process of reviewing those cases and looking at those cases, it would concern me if they weren't seeking advice from the Office of Public Prosecutions. That's all.
Sure.
Yeah.
The majority of those matters, in my understanding, are summary matters, and in the normal course would be likely to be dealt with by police. I'm not saying that they may not be referred to for advice in particular cases, but I'll see if I can find that information.
Thank you. And Does your office receive many requests or any requests for advice in summary matters from police?
Yes.
Is that common?
Yes.
And are they, are they matters where, would they be matters that involve domestic violence?
They run the entire criminal calendar. They may be novel matters or evidentiary issues, and would include domestic violence matters in particular instances.
Thank you. I was just going to ask, I've only got a minute, so I feel like I won't do much justice, but perhaps Miss Beattie, if you could assist me in understanding, are you part of this new work in relation to what we've been talking about with young people? Is that something that's come your way yet? I realise it's very early.
Yeah, I think it is indeed early. I think they're at the scoping phase of this work. However, in terms of the work that Transforming Aboriginal Outcomes does with my good colleagues over here, we do work with health. We do currently also meet with education colleagues, even in the early childhood space, to talk about the ACFCs is a good example where we are working with education in that space. So we currently do work across government on issues that relate to First Nations people and closing the gap. Aboriginal Affairs do a great job, as you know, of pulling those strings together and indeed making sure government talks to each other about closing the gap. So as to the matter you were speaking about just then, I'm not sure of what it's called or what it looks like at this point, but I can say in my day job and in my team's day's jobs, they work across government to work with First Nations people and to hear the voices of community. It would be silly for us to work in silos. You can't behave like that. So the current work does look like that, but I don't know what this work is because it hasn't been fully scoped from what I'm hearing.
Thank you. It's over to you guys.
Over in your position.
Yes, thank you. So, Ms. Dowling, I think we were talking about the decision in Martinez, which was handed down on the 5th of December last year. And then as part, you had considered that response in the office. And then 10 days later, I understand you issue a press release criticising the judgment and in which you flag that you intend to make a complaint to the Judicial Commission. What was the grounds? Has this complaint been made?
Yes.
And what were the grounds of the complaint?
I don't propose to discuss the complaint because it is sub judice.
Is the Judicial Commission a court, Ms. Dowling? It's an executive administrative body, isn't it?
It is.
So
however,
are matters before it's sub judice then, if it's not a court?
I do not consider it to be appropriate to ventilate the details of that complaint in a public forum such as this because it is for consideration by the Judicial
Why
Commission.
then did you choose to put out a public press release indicating that you were making that complaint?
There's a difference between the making of the complaint and the content of the complaint.
Is it commonplace for people to issue public statements that they're about to make complaints to the Judicial Commission?
I don't know. I can't answer that.
In your experience over the last 5 years, how many times would you have seen a press release of somebody indicating they're about to complain about a judge to the Judicial Commission?
As I said, I can't answer that question.
Okay. In my experience, I can say this is my first time I've come across this, actually. And you said that you had conversations with judges. What other means were at your disposal to discuss issues that you thought arose from this judgment?
As you know, an appeal lies from the orders of the court, not from the reasons of the court.
Mm-hmm. So appeal is one avenue. What other avenues did you have?
I'm just saying an appeal.
Well, no, okay, we're taking appeal off the table.
An appeal didn't lie.
Yes, so what other avenues did you have at your disposal?
Well, I considered that this was the appropriate one.
What other avenues did you consider before you chose to put this press release out?
I considered that this was the appropriate course.
Thank you. But what other avenues did you consider? Surely you didn't just go, oh, judgment, think press release, what other avenues did you consider?
Well, I'm aware of the provisions of the Judicial Officers Act. I'm aware also...
Thank you. What other avenues did you consider?
I considered that this was the appropriate
What
one.
other... With
I'm
respect
sorry,
to not
I can't-
answering the question,
I
the
can't
question
take this
is,
any further.
what other avenues did you consider
I-
before issuing a press release about a complaint to the Judicial Commission about a judge?
I felt that this was the appropriate one, and this is the
After
one that
considering what other avenues?
Obviously, I considered the obvious one of an appeal, which wasn't available.
Which, yes, and you didn't consider... Did you consider discussing matters with the head of the jurisdiction?
Yes.
Did you consider discussing matters with the Attorney-General?
Yes.
And you ruled that out because?
I didn't say I ruled those out.
But you chose this path?
I did.
Okay. And why did you choose to make it public?
Because of the public nature of the criticism of my office and the very, very damaging effect that had on the lawyers of the ODPP who are diligently applying the prosecution guidelines and are acting ethically in the service of the state of New South Wales.
So you thought the way to deal with damaging publicity was to attract more publicity?
No, I felt that it was necessary for me to stand up for my staff.
How does making a complaint about a judge stand up for your staff?
I'm sorry, I'm making a complaint about the conduct of the judge, and we've already been through that. And I issued a media statement in response to a lot of media interest directed to my office to make it clear that I categorically rejected the suggestions made by the judge, which of course had not been made in any other forum with me about prosecution practices generally, and issued a media statement to that effect.
And you indicated your concerns that the judge misapprehended the operations of the ODPP and presumably the DPP Act.
Yes.
And then I think we come to the matter of Smith in February this year, and Judge Whitford, who seemed to have similar issues with a matter that was before him. And was that matter also the subject of a cost certificate?
I think one is, a cost application is being made, is my understanding.
Okay.
But
And
it's not yet been-
is that listed yet? Or?
I don't think so. It is a cost judgment. Yes, I'm sorry, withdraw that. It is a cost judgment in the Judge Whitford matter.
Great. Would we be able to get copies of all of those judgments?
Sure.
And would it be possible also to get a list of all matters in which cost certificates have been awarded in sexual assault cases over, let's say, the last 5 years?
Certainly.
Thank you. That would be very helpful. Thank you very much. And in Smith, the Judge Whitford indicates that he raised concerns while the case was still on foot. He raised concerns with the solicitor advocate. Was that brought to your attention or to the attention of anybody in the office at the time that these matters were raised?
Not that I'm aware of.
Okay. And is it in your experience normal that a judge would question why a prosecution had been brought while the matter's running?
No, unusual. Could I just also inform you of a matter about that, an aspect of that trial that you may not be aware of, which is...
This really isn't a matter of trials. This is not an avenue to relitigate the trials. What we're trying to look at here is the response to these criticisms, and whether there are steps in place that are appropriate to respond to these criticisms.
Thank you. May I address that point? So there are two issues that are coming up in relation to these judgments. They are the substantive question about whether the prosecution guidelines are being applied in a particular case. And then there is the manner of the criticism or the suggestion that there is an unwritten policy at play, and the manner in which those assertions
excuse
are
me,
made.
Ms Dowling, I see that criticism made in the Smith case. Was that also a feature of the Was judgment, the Lerv judgment, and the Newlands judgment?
Yes, the Newlands judgment.
Okay,
not
so,
the
so
Lerv
only
judgment.
only in the Newlands and the the Martinez and the Smith judgments, talking about concern about secret policies operating. I think is it Judge Whitford called it an opaque and secret policy in the bringing of cases. Mm-hmm.
Yes.
Yes.
And it is that
and
aspect.
And your management response to that, because that's a fairly significant criticism. Your management response to that was what?
I know because I
your management response.
Yes, well,
what discussions were had with the solicitors?
Let me answer your question, because these
about
are
management response. Yes, please.
These are complex, difficult issues that you are asking me about, and you need to let me finish my answer. I know that there are no secret policies because I am in chambers and myself and my deputies are making these decisions. So the suggestion that there are, secret policies or opaque policies is completely preposterous. However, it is, in the face of judicial criticism, it is always appropriate to self-examine and to consider whether we are doing things properly and whether we can do things better. And to that end, I have directed that an audit of all matters that have been currently committed for trial, be conducted by senior experienced prosecutors, Crown prosecutors, and solicitor advocates, help assisting them to make sure that every brief that is going to trial now in every sexual assault matter in the state satisfies the tests in the prosecution guidelines. So we're doing an audit.
That direction was given after the most recent of those 5 cases.
That's right.
Great. And any other management response? Is there staff training that's occurring?
There's a reminder, the general reminder that the only policy is the prosecution guideline policy.
Yes. And all staff email, I understand from the press, has been issued.
That's right.
Does it concern you that your all staff emails end up in the daily newspapers?
It is a big organisation, and there is a high degree of public interest in the
what
activities of my agency.
What does that suggest about office morale?
I don't think it suggests anything.
What, you think it's perfectly normal that all staff emails are leaked to newspapers?
I think that's the experience of many offices of directors of public prosecutions across Australia and the common law world.
And you would then understand that not all of your staff agree with your statement about the prosecution guidelines being adhered to, and that there are no secret and opaque policies. And I quote from one staff member who has been quoted in the Australian on the 4th of March, who said the issue was systemic and young prosecutors were often pressured to press on with rape cases even when they knew they had no hope. The staff member said, quote, at a guess, at least 80% of cases proceed, even if there are issues with the complainant's credibility or even if the complainant is ambivalent about giving evidence, end quote. What do you say to that statement from someone in your office?
I reject that statement, and I would also like to tell you what the Crown Prosecutors of New South Wales have yesterday issued a statement saying they overwhelmingly reject the assertions attributed to an unnamed employee, including that pressure is placed on solicitors to progress unviable allegations. The Crown Prosecutors express their confidence in the ODPP as a highly professional prosecution agency and its solicitors as highly skilled and professional lawyers. A similar statement has just been issued by the Solicitor for Public Prosecutions, who leads the team of 480 solicitors, who equally reject that assertion.
In Martinez, how long did the accused spend behind bars?
I believe the judgment says that he was remanded for 8 months.
And if we even concede there may be one grain of truth in this statement about 80% of cases proceeding even if there are issues with the complainant's credibility, what sort of personal cost does that place on a complainant who goes through that process and then finds that they do not receive the outcome that they wanted? What sort of personal cost is involved with the accused in those cases?
Well, I reject entirely that there is any grain of truth in the premise that you put to me.
Let's just hypothesise for a moment, assuming there could be, because certainly there are a number of judges who've suggested that this may be the case, hypothesising what is the human impact on the complainant, what is the human impact on the accused in the case of Mr Martinez on remand for 8 months?
The impact of litigation is significant on everybody concerned.
And in cases which may not have met the standards of the prosecution guidelines, what impact then?
Well, I don't accept that there are those prosecutions.
And what impact is there on the valuable resource, which is court time, of bringing matters that may proceed even if there are issues with credibility or if the complainant is ambivalent about giving evidence? What's the impact on court time?
Well, as I said, I don't accept that that is...
What is the
the
impact
case.
on court time of matters proceeding if they are not properly founded?
I don't propose to answer a hypothetical where I have already disagreed the base proposition.
So do you believe that there are any issues which require a management response in your office in relation to decisions about how the prosecution guidelines are exercised or the decision to bring cases?
That's the subject of the current audit.
So therefore the audit has been called because you do believe that there are management issues in your office about the way the prosecution guidelines work?
No, the audit has been called in order to investigate this issue.
And why did it take until the 5th case for you to trigger that response?
Because I don't accept that there is a failure of the application of the guidelines.
So you're doing an audit for a problem you don't believe exists?
I'm doing an audit in response to, as a prudent manager would do, to satisfy myself that there is not a problem, and if I do find that there is a problem, then to fix it.
And would a prudent manager have acted earlier?
I don't think so.
You don't think so?
I don't accept that.
All right. And would a prudent manager have issued a public statement advising they were bringing a complaint about a judge to the Judicial Commission?
Yes, I think so.
And in respect of that claim, so if the particular judge is referred to the Conduct Division, that then will become very public. What happens to a claim to the Judicial Commission if essentially nothing to see here and the claim is dismissed? What public statements are made then?
You would have to ask the Judicial Commission.
Will you be making a public statement to advise the same public who saw your press release if that claim is dismissed?
I'll have to consider that at the time.
Are there any reasons why you would not do that, given the public nature of your claims about the judge?
As I said, I'll consider that at the appropriate time.
So you are not committing to publicly stating the outcome if the outcome is in favour of Judge Newlands?
I'll consider it at the time.
Right. Thank you, Ms. Daley.
Thank you very much. I might actually move on to courthouses. Has or is the government intended to close any courthouses either this year, the 23-24 period, or planning for 24-25?
No, not to my knowledge.
Mm-hmm. What are the government's plans regarding courthouses presently not being used in Cogra, North Sydney and Balmain?
Subject to any elaboration by my colleagues, I would need to take that on notice.
Are there any plans to expand Tweed Heads Courthouse?
To expand it? Not to my knowledge. No, not
okay.
of which I have knowledge.
And also, just wanted to get an update on the South West Sydney Legal Precinct. If a site's been selected and where the plans are up to?
Other than what is on the public record, there is there is nothing additional that I can add.
Okay. I might move to just on coercive control. So it was covered off site this morning. Just to confirm whether or not the new coercive control laws will come into effect on 1 July.
Yes, they will.
Also,
noting that the offence of domestic abuse came in, if I got the right term, on the 1st of February.
Yeah. And my question relates now to, and we had some discussion this morning about workloads and wait times in courts. I'm interested to know if there's any work that's been done, if there'll be any additional burden to local courts in hearing cases with the new laws coming in.
In my discussions with the task force would lead me to the view that the focus which we're doing in expounding and explaining the law of coercive control and the July 1 commencement, as well as the training that we're doing throughout with stakeholders and throughout the criminal justice, with other criminal justice agencies, is that the focus is on getting it right. I would imagine that it's not anticipated that there will be a significant number of matters that in the establishment phase and first couple of years that come forward. I'm not expecting there to be a large flow of matters. It's an important law, it's a symbolic law, and there will be matters we would anticipate which are prosecuted, but in terms of impact on court waiting times and impact and resources of courts, we do not expect that to bring particular pressure.
Have any contingency been put in place for additional resources in the event that there is a uptake in matters?
The implementation work of the monitoring role of the task force will look very closely at specific matters and the work and matters arising from the implementation of the legislation, but it will be restricted to that work, as well as, of course, and within that, the review process each year.
Just one quick one.
Yeah, you carry on.
Has the task force, or is the task force intending to do a review of resourcing workload 6 or 12 months in?
I believe that that falls within the brief of the task force.
Okay,
yeah,
thank you.
Absolutely.
Thank you. Can I just ask about the ex gratia payments when the minister makes a determination to make one? What sort of... Are you within the department responsible... Who in the department, is responsible for assisting the minister in making that decision?
So if an ex gratia payment is to be considered by the Attorney General, and noting that ministers generally can authorise ex gratia payments, but if it comes within the Attorney General's area, my legal team will advise on it, and they may seek advice from the Crown solicitors as well in that process.
Okay, so it's only when an application by somebody is made that it's relevant to the Attorney General, and then you would look at it and you would get advice and provide that advice.
Yeah, ex gratia payments are made when someone comes to government and says, as a result of government action, I have suffered a detriment, and you ought to recognise that by making a payment to me ex gratia. So it's a payment that is not founded in law. If there's a legal remedy, then the person would go to the courts for that. It's as it says, an act of grace.
And so when so if you were, or one of the members of your staff were responsible for looking into something for the Attorney General, what would that, what would assist them in providing that advice? Would they be looking at previous ex gratia payments, the terms? Are there any internal working documents that would assist in providing the advice?
Yeah, that's a good question, and I think it goes to the nature of the payments that are made as acts of grace. So each application is very much considered on its own merits, and the case that the person puts to the minister justifying that payment is very closely considered. We're really looking for, as I say, acts of government that have caused detriment, and that detriment, there's some moral obligation to do right by the person.
And so how do we grapple internally when we're assisting the Attorney General? How do we grapple with, say, my version of what would be gracious and somebody else's version of what would be gracious, and where it's very, very clear? I'm not actually trying to be funny here, but no, I know you don't think I am, but in terms of where it's very, very clear, say, that the state has wronged somebody, and that's because the system has just, they're the settings, it didn't work, and somebody's really suffered in the hands of the state.
Yeah.
So then how do we, where does the ultimate discretion kind of get weighted and measured, and how we get through the system?
Yeah. I guess the question we ask for me, the question that we ask ourselves in looking at these is, what is the right thing to do? It really is that basic, what should happen in this case? What is the right thing to do in this case? And each case will be very different. The concept of ex gratia payments covers a wide range of situations. So we can't reduce it to a set of guidelines. We can't reduce it to a set of legal-like principles. The question is, what is the right thing?
And then, so do you think it would, not suggesting to reduce anything, but do you think it would be beneficial at all to have some sort of stipulated objective criteria that we can kind of look through?
The thing about act of grace payments is that they are designed to cover those situations which are not contemplated by the law, not contemplated by legal rights, but are really designed to allow us to make payments when it's the right thing to do, and apply. It has to respond very flexibly to a range of situations. So I don't think that that trying to reduce the concept of act of grace payments to a set of guidelines is a thing that you could easily do.
No, I'm not suggesting it would be easy. Yeah.
But I think the mechanism is designed to be flexible and to allow government to do right by the people coming to it.
And so how many ex gratia payments have been made under the Attorney General since March last year?
I would have to take that on notice.
Thank you.
It does happen, and it happens in a range of different kinds of circumstances. So let me take that on notice and give you a bit of commentary and some numbers.
Thank you. I'd be very grateful. I feel like it's a bit of a a mystery zone, and yet it seems like it's such an important element of the act of justice on part of the state, because it's I think what the common understanding is that when all avenues have been exhausted, when all things have been done, yet somebody has been failed by us, then this is the mechanism to try and do something, even though we obviously can't ever properly compensate somebody from the wrongful actions of the state or the harmful actions of the state, but it's a measure.
I think that's a reasonable characterisation. The only thing I would take issue with in that is this concept of wrongful actions of the state. It is not always the case that the state has done wrong in ex gratia payments. Sometimes it is just there's been an administrative oversight, or
I'd call that a wrong. If I was the victim of that administrative oversight, I'd call it a wrong.
But not an intentional wrong. Some human error has occurred that has arisen in the context of the operations of government. It isn't always the case that the government has done wrong. It's just that something has occurred, and in the circumstances, to do right by the person, we make an ex gratia payment. So that's how I would characterise it. It isn't necessary to point to wrongdoing in order to justify ex gratia payments.
Thank you. That's very, very helpful. Thank you. As I said, it feels like it's this mystery zone, and so it's very helpful to have some more understanding. I was just wondering, and I know this, so this obviously is an element that comes under corrective services, but something that somebody has raised with me is Balunda, the facility in the Northern Rivers that is, I think, essentially a diversionary project. It's are you aware of that? Is that on your radar?
I have some knowledge of it. I'm not sure I'll be able to answer your question.
Yeah, no, look, it's my understanding, and the only reason I'm raising it here now is some optimistic lens, is my understanding of the program, and somebody raised it with me literally in my home zone last week, is that it is described as an innovative residential diversionary program for male offenders over the age of 18. And I'm just curious whether this is precisely the sort of thing you're looking at in terms of the young offenders and juveniles, because the Minister mentioned earlier something towards the effect of we need to look at whether we have to build things or whether we have to... and that kind of struck me a bit like, hang on, we've got correctional centres, we've got facilities. I don't know what he's referring to, but it sounds like all things are in the scope.
Yeah, but Balunda, as I understand it, is a corrections program.
It is.
And I'm not sure I would want young people put into the corrections system. Apart from that, as I say, all options are being considered, including therapeutic options. Yeah.
In terms of program design and any takeouts of that might be applicable to, say, youth justice. Thank you for the tip. We will have a look at it, bearing in mind that, as you I think know, Ms. Ickinson, there is a real challenge at the moment in the youth justice system around remand.
Yes.
For obvious reasons, that our overall numbers, notwithstanding what I acknowledge as a very high proportion of Aboriginal offenders, which is a real challenge. The real issue is what we do with those kids who are on remand.
I mean, the concern is, I think we've still got one more minutes. Yeah, I'll just go 5 more. I think one of the, it's really confronting trying to grapple with a government policy that says we're not looking at raising the age. And I'll throw this in, and I don't expect you to comment, so please don't, when the frustration of the evidence suggests that perhaps it would be really beneficial to do that. But when the Attorney General said earlier whether we have to build things, I just am very concerned about what that meant in terms of, but that said, that's why I turned to the Balanda, because if what you're being charged with the responsibility of doing is looking at all of the options to try and to improve youth justice outcomes and youth wellness outcomes, but we are contemplating building more facilities or something, then it was just a real concern. But Bandalung, literally somebody who works in youth justice and youth crime in the Northern Rivers, came to me last Friday and suggested that that facility should become something that is focused on young people, because apparently the success, anecdotally, the success there is that it is a really tremendous program. And yeah, the focus on First Nations young people. So am I kind of seeing heads nod? Is that's in the scope to look at how we would get lessons well learnt? And
oh, absolutely. We draw on lessons from everywhere that we can. So yes, I mean, I think the challenge when you're thinking about ways in which you might respond to young people who are presenting harmful behaviours as an alternative to the criminal justice system is thinking about ways in which you might work with those young people that doesn't replicate the criminal justice system. So we have a criminal justice system. If that's appropriate, then that's what should be used. So if that's not, if we want different ways of working with young people, then we really do have to think about, well, what's different in the system? What will make a difference? How can we work with young people in a new way that is more effective and deals with both their offending behaviour but also the underlying issues that they present with? Because we know, as you know, the young people who come into particularly the pointy end of the criminal justice system have high levels of victimisation, high levels of drug and alcohol issues, high levels of mental health issues, high levels of cognitive impairment. And if we are really to work with those young people effectively, we need to be working in those spaces to make a difference in their lives in ways that are innovative and different from the criminal justice
And so is
system.
there anything already in front of you that is something that you can point to and say, hey, this is something that we really need to be focusing more on? I know Ms Campbell was saying about the Justice Reinvest program, and clearly that's something, if we've determined to spend another 7.5 mil, which is probably an underspend all things considered, but yeah, if that's, so clearly there's good indications that that should continue. Are there any other programs specifically focused on young people that you think would be high on the list initially?
Look, just sitting here, I wouldn't identify a particular program. I imagine you discussed at length these kinds of issues in the Youth Justice hearing with my colleague Mr. O'Reilly, who's very articulate about the kinds of things that Youth Justice are doing for young people in the therapeutic space. If we were working particularly with Aboriginal young people, you talked to my colleague Ms Beattie over here about ways in which we might empower Aboriginal controlled organisations to work more effectively with young people. I think what I'm talking about here is a kind of strategic stance that we might take to try and move all of our systems in the right direction.
And so, Ms Beattie, do you think that at this point the empowerment, and I know we spoke the other day in one of the estimates about the Productivity Commission's findings that the primary failure of why the Closing the Gap outcomes improving at the moment is because we haven't yet quite handed power to First Nations people to take control of their own outcomes and their own lives. Do you see that in this space, with the justice space and the young people, the success will come through more support, resource and power to ACOs?
I think, yes, and thank you for the question. In the last budget estimates, in Minister Washington's budget estimates, I referred to the Productivity Commission report that was recently released, in which it talked deeply about self-determination for First Nations people. It talked about working with ACOs, funding ACOs, long-term funding for programs. It also talked about Indigenous data sovereignty and Indigenous data governance, and all of that, as you quite rightly outlined are about self-determination and sharing power, if not returning power, to First Nations people, to make decisions about their own communities and their own people and their own lives. So I am very hopeful, listening to the Attorney General this morning, and again couching that I'm new to this space, going on to 8 weeks now. But what I see is a coalition of the willing. What I am delighted to see, and I mean earnestly, is my colleagues around me, such as Mr. McKnight, such as Ms. Campbell, who truly want to listen to areas like transforming Aboriginal outcomes when we say things like, how do we do things in co-design or co-creation as opposed to consultation? Mr. Tidball and I have spoken about how we reframe the relationship or how we add the ability for First Nations voices, and he's indeed committed to working in a different way, as he mentioned in previous budget estimates, with our national partnership partners, so ABSEC and ALS. And I do see a shift, I don't know what was before me, I can't speak to that, but I do generally see a shift in perhaps the movement towards understanding Aboriginal ways of knowing, doing and being. And that can only happen through First Nations people being at the table, through whether it's ABSEC, ALS, my good partners in CAPO, it's Aboriginal people in government speaking up and saying, do we know what's happening in that community? Have we actually listened? And I think lastly, to add to the scope of what we might be doing, obviously through people like the young people's advocates, hopefully we'll ask young people what they want. It'd be lovely for particularly Aboriginal young people to decide their own aspirations. Because it's been a while since I was young, so I wouldn't know.
Feels like all of us in the room, it's a long time ago, and combined it's even longer. Okay, someone looks pretty young. I was just wondering then, Mr. McKnight, is there work happening within AGs, or is it Minister Div alone to look at the young offenders legislation, or is that something that you would look at as well in terms of reviewing that?
So the Young Offenders Act.
Yeah.
So just to correct your reference, you talked about AGs. We're very much the Department of Communities and Justice,
yes.
and I just wanted to correct you there because that link between the what was the old community side and the justice side of the department and us coming together, I think is a real opportunity for working together on common issues that we are beginning to exploit considerably, and it's really important to us to have that identity as a department. So that was a bit of an aside to your question.
No, it's really good because it's hard to know.
Yes.
Even as close as I am, but it's hard to know what is, what you're all doing, what you're all up to.
Can I just add one comment, if I may, quickly, and that is the importance of, you're absolutely right in what you say, Paul, and the reason for that is the artery that runs, and you people have heard me say this so many times, but the compelling realisation I've come to is the artery that runs right through DCJ is the impact of trauma.
Yeah.
From early intervention, child protection, out-of-home care, youth justice, and the final basin is the adult prison system. If you have the levers and common oversight of programs and a group of people working together who are focused on targets and innovating together, that's when you can hopefully try and move some of those numbers. But we are talking about the same people, and I'm sure, I know you know it, and I know the committee knows it, but it is a real life cycle thing.
So just on, sorry, just get the one answer.
Keep going. Okay.
Just on the Young Offenders Act, though. Sorry,
so
I didn't quite.
The Young Offenders Act has been under review. That review was conducted by the Department of Communities and Justice, including my team and the Youth Justice team, with police.
Yep.
And that review remains under government consideration.
Okay, and have you been given any timeline indication? Is there a desired timeframe to do it soon, or it's not high
So
priority?
the review itself is under consideration by government.
All right, thank you. You guys go for it.
Yeah.
Thank you.
I might just cover off a bit on legal aid officers. And I was just interested to know if there's any plans for any new legal aid officers to be opened or this financial year or next.
I can take that, answer that question. We don't have any current firm plans on foot to open any new offices. However, we are aware that there are big service gaps in parts of the state that we are looking at ways to try to fill. But we don't have any firm plans to open an office in any new location at this point.
And where are those service gaps?
The far south coast is an area that we've identified as being one where there are service gaps. There are other places in the state as well, around the far north coast as well. In that Tweed area, there's very high demand. In northwest New South Wales, there's considerable service gaps there as well. So those are three areas that we're aware that we need to focus on if we can.
And is that data information that you gather on an annual basis?
We're always looking at the data. We've got various sources that we can look at, including the data that we get from Law Access New South Wales, which is our telephone contact centre, and seeing where the calls are coming from. We also talk to our partners in other parts of the legal assistance sector. We have a good sense of where legal services are located and who's going where, and therefore we can see where the demand is that we could look to try to meet in a more fulsome way.
Is it possible to provide to the committee a breakdown of the demand for those areas at a certain time? So 31st of December, what that demand is?
Can I have a look at trying to provide that information to the committee? Yeah, sure.
And you said the far south coast. I assume the north coast, one of the issues is obviously with the floods. But what are the challenges, or are there any trends that you've identified with some of those other areas like the far south coast that are impacting on demand?
I think if you look at where legal services are located down the far south coast, we have a legal aid office in Nowra, and then we don't have any other legal aid office until one at Wagga Wagga, but nothing really then to the border, and so you could see that's quite a large part of the state. So if we were able to open an office somewhere on the south coast, we would certainly be interested in doing that, but at this point in time it would obviously be subject to a number of different considerations.
The other thing was just, are there any plans to close any offices either this financial year or next? No. Or are there any plans for reduced staff at any of the offices either this financial year or next?
To reduce staff? Not that I'm aware of, no.
Just in relation to rural and regional areas, and obviously you touched on with the north and the south and out west, is there a higher demand for legal aid practitioners in the regions, and what challenges are there, particularly around funding? Because National Legal Aid has obviously come out saying in their report that it is underfunding, but how are you finding that impacting on those regions?
There is, over time, certainly, and the Law Society has also been doing some work on this, a reduction in the availability of private practitioners in regional New South Wales. And we're aware that there is a supply issue, and that supply issue is concentrated in different areas of the state, and I'm very happy to provide the committee with more detail on that. But we certainly are seeing that there is a supply and a market failure issue in some areas of the state, and we're very conscious of that, and doing what we can and working with the Law Society in order to alleviate that, because without those private practitioners it's very difficult for us to cover the entire state.
So what work is being done, if any, in relation to trying to recruit private practitioners?
We offer all sorts of things. We offer training, we offer support and mentoring if they would be interested in that. We try to make it as easy as possible to do business with Legal Aid New South Wales, and done a lot of things over the last few years to make it easier to transact with us, so that it is a more appealing prospect to work under a grant of legal aid. We're looking at different ways in which we can attract the private profession, also by talking about the kind of work that we do that is rewarding work, and work that we hope private practitioners would find fulfilling and want to do.
Do you find that, like I'll use the far south coast as an example, the challenges of having the office in Nowra but not anything close to your Badella or Bega, does that have an impact on the recruitment and
of private practitioners? I think what we see is that in that far south coast, it is getting more difficult to attract private practitioners to do legal aid work, and that is why we are looking at that area quite specifically to see what we can do to supplement the failure, or not the failure, but the challenges that we have in attracting private practitioners. And that might be opening an office, but no firm decision has been made at this point.
And what are the reasons for, I suppose, or what are the challenges to recruiting them?
To recruiting private practitioners? Well, the national legal aid work at a Commonwealth level certainly pointed to the fees that we are allowed to, or that we can pay private practitioners based on our ability to pay private practitioners, and I think that is the same in the state jurisdiction as well.
Okay.
All right, we might take a break there and come back in 15 minutes. Thank you.
Thank you.
back on the air, please. Are the opposition ready to ask questions, or
Me or you?
I have another cup of tea? I've got one.
Yeah, it's a good content.
Oh, you may as well jump on this. I finished legal aid. Okay, all right.
This is a hacket. You can't buy hackets.
Ready when you are.
Please,
Okay.
please.
Welcome back. I have some questions about the consultation in relation to the Conversion Practices Bill, I think it is. Is that you, Mr McKnight, or is that you, Mr Tidwell?
Mr. McKnight.
It is.
Great.
It is me.
Thank you. In fact,
I think we had a conversation about this last time.
we certainly
With
did,
Carter.
and in fact,
Yeah.
I had some follow-up questions from
Fantastic.
the questions on notice, because now let me find the right pieces of paper. There's way too many of them. I noticed that you gave me some general information about who was involved in the consultation process. I don't see women's groups there. How many women's groups were involved?
Women's groups were certainly involved in the process.
As a percentage of the numbers of people who were consulted? You'd understand it's important to me to know that number, and important to 50% of the population.
Indeed, and there would have been a variety of women involved in
perhaps,
giving
Mr
their
McKnight, you
views.
could take on notice the
Sure.
percentage of women's groups, that is specifically women's groups, not women who happen to be there in another capacity, but women's
perhaps
groups
you-
who were part of the consultation.
Do you have a particular definition of women's groups in this context?
I'm
Ms.
happy for you
Carter?
to apply a broad definition in terms of a group of women who congregate together for the welfare and betterment of women.
Great. I will do what I can.
Thank you very much. I'm happy to have discussions with you about that definition if it proves difficult to identify. And I'm wondering too, you identify broadly academics, including in medicine.
Yes.
Were there any practicing doctors who were involved in the consultation?
I don't have a list of
Okay.
the doctors that were involved in the consultation, but I imagine there were practicing medical
perhaps,
doctors
Perhaps
involved.
you could take that on notice, and perhaps a
Happy
list
to
of.
do that.
So, how many people were consulted in total?
In total, almost 150 organisations.
Almost 150. Well, perhaps you could
involved.
let me know how many doctors and what specialties, how many paediatricians, how many psychiatrists, how many geriatricians, how many of all the different specialties?
Indeed, I'm happy to take on notice what I can provide you in that area.
Sorry, when you say what you can provide me, you don't have a full list of everybody who was consulted?
Not in front of me.
No, I understand, but when you say you're happy to provide me with what you can, I wondered whether you may have problems providing some of that detail on notice. I just wanted to clarify that now. See,
Sure.
in my head, you have in your office a complete list of the close to 150 people or groups who were consulted.
Organisations. So
you
that's
can just
organisations.
so you can just pick from that according to the categories. Am I wrong with that?
I think we can probably do something along those lines. We'll
Thank you.
see what we
So
can
you'll be
provide.
able to give me a list of doctors and
I'm
specialties.
taking your question on notice, Ms. Carter.
But you'll be able to fulfil it?
I'll do my best.
Will you send a photo of your office? Sorry.
Oh, I'd love it. Let's
No,
have a
no,
tour.
no.
Let's have a view. And psychologists.
Indeed.
Yes. And particular specialties in which they may happen to practice?
Indeed.
Great, thank you very much. And I noticed that you said in your answers to questions on notice that that as the process was confidential, the identity of specific stakeholder participants is not being disclosed.
Yes.
I've spoken to some stakeholders that, based on our conversations, I would have expected to be there. In fact, we had a particular conversation in relation to specialist ministries in faith communities who work with people who are LGBTIQ, and you said you expected that they had been included. When I spoke to some of them, I don't mean a comprehensive list of them, none of them have been included. So I wonder, could you also provide me with a list of specialist groups in faith communities who work with the LGBTIQ community?
So I think, as I said, I won't be able to provide you with a list of people
Well, perhaps you could
consulted.
provide me with the number of specialist groups within faith communities who work with the LGBTIQ community?
I will see what we can provide you in terms of the number of LGBTIQ faith groups.
Okay, and I'm struggling with, I suppose, the nature of a closed consultation about a matter of great public importance.
Indeed.
And I'm struggling with how a list could be constructed that claims to consult broadly, but would exclude a faith group works with LGBTIQ people in the biggest faith group in New South Wales.
I'm not sure what you're referring to.
Well,
Ms.
I'm
Carter,
referring
but
to
I
Courage,
can
which is a
tell
group
you-
in the Catholic Church, which I believe is the biggest faith community in New South Wales. They work exclusively with LGBTIQ people. And when I spoke to them, assuming they'd know about the consultation, they said, "Oh no, we weren't invited. We had nothing to do with this." And that's like, so how can you have a consultation when you're excluding groups within the largest faith community in New South Wales, which work exclusively with LGBTIQ people?
So the group that were consulted in this matter were first identified by the working group that was led by DCJ and Health.
And
they
then
put
was there a
together
more open
a
call
list
to
of-
check any holes in that
They
group?
put together a list of
Mhm.
people to consult,
Yep.
and those who were consulted then suggested further groups to include on that list, and those groups were included. So that is how we came to the list of people
Isn't
to
this,
whom
Mr.
we sent
McKnight,
the paper.
exactly the problem that we often have, and exactly why we need to adopt more inclusive practices in this place? That when we start with the group of people who always talk about things and they go, well, maybe this person, maybe that person, we inadvertently, unconsciously exclude people who actually would have had a valuable input into this process. And that is one of my concerns, and we touched on this last time, about this being a closed consultation for a very broad issue that affects everybody in the community.
I think you canvassed that question with the attorney this morning at some length.
And
Ms.
I wanted
Carter.
to do it in more detail with you because we have limited time with the attorney, and I'd be interested to when I went out and engaged with some of these stakeholders and they didn't know about it, it caused me greater concern. And if the process that leads to the drafting of the bill is flawed, can we have confidence that the bill is really one that will speak to the whole community?
I feel, Ms. Carter, that the 150 organisations that provided input into this bill consisted of the breadth of views in the community on this question. There were academics, there were cold organisations, education groups, faith groups,
But not a
including all
faith
the
group
major-
that represents the largest faith group, as I've said before, that works with the LGBTI community. They weren't there, and neither was Encourage. They were not represented either, according
So
to their representatives.
The major faith groups in the faith community, including all the major denominations.
But the
their
specialist
voices were-
ministries who deal with LGBTIQ people who would understand the intersection of those issues were not there. And look, and I'm only raising this because this is the bit I know. These are the groups that I can see I would have expected to be in the consultation. I would have expected to have a seat at those round tables, and they were not there. And so then I start thinking, who else wasn't there? And I raise issues about this process because we have seen it in this place before, where we don't consult broadly enough, and we, I'm sure entirely inadvertently, exclude people, and that then risks it being quite a flawed process. In terms of LGBTIQ groups, were groups like the LGB Alliance Australia included?
I don't have that list in front of me.
Okay, perhaps you could check that.
But I'm confident that a broad range of LGBTQ.
Well, I
plus
understand from their
advocacy
representatives who've been
groups
to
were
see me and a
included.
number of other people that they were not included in the consultation. And
As
I
I
understand
said-
from a number of women's groups who actually made submissions and sought to have their voices heard, that they were told their voices were not welcome. And as a woman, I find that very distressing to hear that certain women's voices are being excluded from this discussion.
I'm unclear of the situation you referred to. I mean, there were 150, just under, organisations who made submissions.
I'm aware of the number. We've discussed the quantum. I'm going not to the quantum but to the representative quality. And if within a very small time, with a very small sample space, I can identify people who actively asked to be involved in the consultation and were told no seat at the table for you, and if there are also people who were not asked, who are clearly the people that are going to be most interested in this legislation, and nobody reached out to them, and then I'm told this morning, no, the only consultation will be private. We won't have a public consultation about this. Certainly, if you wanted a private consultation, step one, and then open it up more broadly for more input. What is the reasoning to exclude people from having their views heard about this very important matter?
The consultation, at risk of repeating myself.
Well, I'd ask you not to. I'd ask you to answer the question. Why would people's voices be excluded from being heard in it's a matter of interest to the whole community?
So the consultation process, I think, reached a large number of organisations identified as having a very diverse range of views in the community. The sensitivity of the consultation issues determined that the consultation would be confidential and that we would not identify the list of consultees.
Mr McKnight, I accept all that, but with respect, it's not going to my question. Stage one, I mean, we've heard today about the extent of the work that's being done on very important matters to do with child safety and with juvenile crime and the really complex issues, and I think it was described as the first step is a scoping strategy and then it moves out from there. So if we see the closed consultation as the scoping stage, is there going to be a broader consultation where other voices can be heard? And can I suggest that with legislation of this kind, it's even more important because, as I understand the legislation, and I haven't seen a draft of it and I have no idea what's in it other than bits and pieces that one hears, and they're never to be trusted. As I understand the intent of the legislation, it's really, yes, there will be, I presume, criminal penalties, there may be civil remedies, I'm not aware, but I feel, or my understanding is that this legislation is as much as anything designed to drive social change and to educate about attitudes. And if you're not bringing the whole community with a very public process along with you in this, how can you expect that aspect of the legislation to actually succeed?
The legislation will, in due course, implement government election commitment. The department's role, of course, is to support the further development of that policy and to implement the government's policy in that regard, and that's what we've been doing in this
So
context.
can I take you to that statement that you've just made in relation to implementing government election policy? And I apologise, I wasn't prepared for this question, so I don't have the exact quote in front of me, but I recall that Mr Minns in the election campaign drew a clear distinction between the Victorian model that he said would not be followed and that a unique New South Wales approach to this issue would be developed. So can you provide some assurance to us that in fact is the election promise that is being fulfilled and that the New South Wales model is not based on the Victorian model in any way?
You're asking me now to canvass government policy.
I'm asking a follow-up question to the statement you made, Mr McKnight.
Indeed. The attorney, I think, gave a fairly fulsome answer this morning about the status of this work.
We perhaps have a different definition of the word fulsome. I'm asking you for an answer now.
I think I'd refer to the attorney's statements this morning.
Well, could you perhaps summarise that for me? Because with respect, I found it difficult to get a clear understanding of exactly what work was being done by the attorney this morning.
I think I'll leave the attorney's words to stand for
Well,
themselves.
could you perhaps repeat them for me so that I'm aware of exactly to what you're referring? Because it was quite a long session this morning. I'd love to know exactly what you're referring to, Mr. McKnight.
I think I'll leave that to the lovely people at Hansard.
Well, sorry, what did you must have had some statement in your mind, sir, when you said that. So what was the statement you had in your mind? The statement that the attorney had made that you wished to associate yourself with?
I think the attorney gave quite a good answer about where this work was up to and what the government's
he didn't address the
was.
specific question that you raised of consistency with the election promises, and that's the question that I'm asking you.
I'm not going to comment on the policy, Ms. Carter.
Can you tell me whether, because I understand from the consultation paper that as well as looking at conversion practices with LGB people, it also looks at gender dysphoria, transsexuality. Can you confirm that the legislation also looks at that?
I think the government's policy is announced that's in scope.
Okay. And will there be an affirmative model required, or will the watch and wait model also be available?
I can't answer these questions, Ms. Carter. You're asking me for
I'm asking you for
material
information about a matter
policy.
of great public importance, is what I'm asking you.
Indeed, and they're questions that should have been put to the attorney this morning.
Thank you. All right. Well, thank you very much for your time.
Thank you. Could I get an update on the Justice Reinvestment projects in Nowra and Kempsey?
Yes. I'll just find out for you. Got it here, Ms. McLaren-Jones.
Thank you.
So, recruitment of the Justice Reinvestment staff in Kempsey and Nowra. We've finalised the program logic and the theory of change for Nowra and Kempsey. The development of Justice Reinvestment circuit breakers in Nowra and Kempsey, establishment of local governance arrangements in Nowra and Kempsey, development of Justice Reinvestment implementation plans, and establishment of an outcomes framework. I'll just see if I've got any more concrete detail. I can maybe provide the rest of the update on notice.
Yep, that's fine. I might go to the Parramatta Justice Precinct. At the last estimates, supplementary question were advised that it was in the planning stage. I just wanted to find out if there was any further update or a date for completion.
I would love to have that in my head, Ms. McLaren-Jones. I don't. Can I please take that on notice?
Yep, that's fine. Has there been any increase in the trustee and guardians fees and charges in the 2023-24? Are there any plans for 24-25?
I should be able to take that. Yes, so just by way of context, proposed changes to regulated fees by tag charged to customers were made in 2021. They related to fees that had not changed since 2016, and the revenue from these changes was intended to strengthen TAG's capacity to provide better outcomes for customers by enabling it to manage the growth in demand and complexity of the services it provides. The first changes to fees, which impacted clauses 11 and 28 of the regulation, commenced in January 2022. These included changes to fees for drafting of wills, powers of attorney and enduring guardian appointments and managing customer investments. Wills, power of attorney and enduring guardianship document preparation fees increased by 5% for straightforward new requests and 7% for complex new requests from 1 September 2023. These new fees are less than the maximum fee set out in the current regulation.
Okay, thank you. Sue, did you want to jump? I've got 30 seconds.
Yeah, I'm happy to. Thank you. The bell will go, but we'll just ignore it. It's that thing, isn't it?
It's easier than starting a new
yeah,
area.
Yeah, and the bell rings, and I think we all just go, oh no, it's someone else's turn. Yeah. Could I just ask, and I'm not sure who would know, about the NCAT review and the rents that with in relation to the rental tenancies. Is that, from what I gathered this morning, it might be you, Mr. Diath, but can I get an indication? I think the Minister might have taken some things on notice, but has anything started? Is there work happening, or I have no visibility of it? Are you able to give me some?
I think the Secretary's going to take that.
Okay. Did you want to?
No, I'm very happy to.
So look, this is dangerous because you may know something I don't know. I know that there is. Look, my evidence would be very totally consistent with the attorneys of this morning in that there is certainly an intention to proceed with that review, but it is work yet to be finally scoped and critically, can I say, worked through with NCAT and the President of NCAT. It's in order that it is carefully scoped with her in consultation and that it is yet to proceed and to my knowledge to be scoped, but it is certainly intended that it will proceed.
Okay, so it's fair to say not yet, but it's on the...
Not yet, but happening.
Yeah, okay, thank you. In relation to, just wondering in relation to the funding or the allocation for the New South Wales Land and Environment Court, and is that something that, are you hearing anything around the allocation for that jurisdiction, that it's coping within its current fiscal allocations, or that it's under pressure from the allocations, or is the department satisfied that things are plodding along fine?
I for my part would never say that any jurisdiction has the resources that it would ideally.
Because of course you'd have
request.
the Chief Judge of any jurisdiction on your back saying it's not enough, we don't have enough.
But I certainly would acknowledge that in the case of the Land and Environment Court, in terms of the planning priorities of the state and movements in other areas of what I would characterise as public policy, that there are impacts that can flow into that jurisdiction.
Yes.
I meet very regularly with Justice Preston, Chief Judge, and also recently sat on a selection committee for commissioners, and that gives you a real sense of the pipeline when you sit there for a couple of days doing that. Can I say there are pressure points in a lot of places. They cannot be addressed quickly, but there is an awareness that the needs of that jurisdiction will grow, and that's probably all I should say at this juncture.
Okay, so that is, so suffice to say, it is on the radar that we've got a large body of government policy that is going to have a massive impact.
And that it is an unusually sensitive jurisdiction to other systemic changes outside of the court, if that makes sense.
Yes, okay, that's good to know, because it's, obviously a jurisdiction I've worked in, and I just, cognizant working at this end of it, thinking, oh goodness gracious, there's serious impacts that are likely to eventuate in the coming period. Thank you. Also, just looking at I asked some questions, and I know they were taken on notice, just about the bushfire coronial that took place. I'm just curious as to some of the decisions that the attorney made. Are you in any position to provide? I'm happy for you to confer on this. Is it better to just leave those questions on notice?
Can I just confer with Mr.
Of course.
A moment? Ms. Higginson, I have a clear recollection of it. I'm nervous that the font of all wisdom in these matters doesn't remember it quite as in the I took an interest in it because I knew it was a matter of it would be a matter of concern. I think the smart thing for me to do is to take it on notice.
On notice, and I've got a couple of extra questions. Would you prefer me to put those now on notice or as supplementary questions?
If you want them on the record, of course, that's respected. But very happy to. I will need to take this on notice to give you an accurate and complete
I think
response.
I did put on notice. I did put questions, but I didn't quite get to the last two. There was just two further questions to be taken on notice then. And one of those is communities are one of the major stakeholders affected by bushfire disasters. Will the Attorney-General establish a funding scheme to provide legal representation opportunities for community interests during coronial or other related inquiries into bushfires? And obviously this is in anticipation of our future. And then finally, is the Attorney-General confident that the New South Wales coronial inquiry into the 2019 and 2020 bushfires will serve the interests of the community? So they were, they're specific questions from, and particularly developed in consultation with directly affected participants in the coronial and people who lost a lot during that period. So thank you.
I appreciate it.
I'm happy to hand back to you guys. Thank you.
Thank you. I just have a couple of things to follow up. Actually, before I do that, I might just in relation to the number of district court judges, because we covered off local magistrates this morning, if there's been any change in numbers for 23, 24, or any plan changes for 24, 25,
For the district court.
and also for the children's court magistrates.
If Mr. Daley wishes to gazump me, he's most welcome to.
Turning as quickly as I can.
Ms McLaren-Jones, while they're looking for that, I just thought I'd correct what I said earlier in terms of the Kempsey and Nowra. I actually gave you the milestones for 23-24, not where it's currently up to. So there have been a few delays in the implementation, partly because of some of that funding went across to Just Reinvest New South Wales.
Yep.
And the CEO resigned recently. There's now a new CEO, so it's now back on track. So they're currently doing the recruitment of the staff in both those locations. They're finalising the program logic, and consultation has commenced in those two communities.
Oh, great. Thank you.
In relation to the district court,
Yep.
your question is about caseload or judges?
Judges, numbers.
Yeah, so the increase there would be commencing 23-24, funding of $13.57 million over the next 4 financial years is provided for the appointment of 3 ongoing additional district court judges to support the expansion of the child sexual offences evidence program. And the 2 judges have recently been appointed, and a 3rd judge is yet to be appointed. Judge Brady will commenced appointment on 9 February, and Judge Barrow on the 12th of February.
And in relation to the children's court magistrate, has been an increase, or will there be one for 24-25?
I can't speak prospectively in terms of an increase. I probably should take that on notice. Not that I recall, and it's not in my notes.
No, that's fine. And also, have there been any changes to Supreme Court judges or any planned?
You're talking about resources?
Yes.
No check.
Not to know.
The other thing is in relation to promoting Sydney as a destination for international arbitration. Is there any work being done in that?
Look, I have had some... So I should declare I have form when it comes to Sydney as an arbitral venue. So for my part as Secretary, I have been engaging with some of the leaders in that space. There's no advice that I've advanced upwards, but I am in discussion about tighter coordination, and also looking at a range of things, including changing geopolitics, changes in the regions, and look, there's a dialogue in which I'm engaged. It's not something that I have formally progressed at this stage, but I appreciate the importance both to the esteem of our very, very capable local profession, which is respected throughout the world and offers a lot to this region, and clearly recognising that there also is a benefit to the Sydney economy, the New South Wales economy, but it's work that I do intend to take forward to government in due course.
Just got a couple more. In the last supplementary questions in relation to the Victims' Right and Support Act review, indicated that it was underway. Is there a time frame for, I suppose, completion of that review?
No.
Okay. Is there a reason why there's no time frame?
I want to say no.
Only because usually you have an end date at some stage.
Look, there was
Will it be done in this term of government?
There was some consultation I think kicked off in 2022, and a range of submissions were made. In that context, those submissions continue to be considered, and the options continue to be considered by government. It's a complex review.
Okay. We might come back to that another time. Just two other questions before I hand over. Just following on from discussions, the last estimates in relation to the impact of the ACT's changes around their drug laws and driving, and the impact it's having on the border community, as in the Monero area and Queanbeyan. But I'm interested to know, because it was stated the last in supplementary questions that a communication strategy would be implemented to educate New South Wales residents, particularly about the ACT drug laws. Has that been done?
Yes. So I think the question last time was in the context of the implementation of the New South Wales early drug diversion initiative, which is now started, as you know. In the context of that, there are communications in the sense of websites for DCJ, for health, St Vincent's have all been updated, and there is some social media occurring in relation to that, including, as I understand it, some social media that has some geotagging to target residents in those border areas. Yeah.
So is it, but there's nothing specific about the changes, the drug law changes that occurred in the ACT, because at the time we were hearing reports that they were expecting an increase in potential road fatalities.
road fatalities.
We're not expecting any road fatality.
Well, you would
issues.
recall the evidence that was given by the police commissioner last time, who was very concerned because, from memory, something like 80% of road fatalities in the ACT are drug related, and there were concerns about what was happening in the border areas around the ACT and the extent to which, because it's a fairly porous border, as you know, and the communication strategy that we understood was to make sure that the residents of the New South Wales areas surrounding the ACT were aware of the different laws for drugs in the ACT as to New South Wales, and we were looking for an update on that communication strategy.
I'm not aware of the police commissioner's evidence in that regard. I apologise. As I recall it, the questions put to us about that were in my understanding, the potential for confusion for ACT residents and New South Wales residents as to the different laws in place once once our drug diversion program had commenced. So
and we
it
were
may
told
be that
there'd be a
we've-
communication strategy to
Indeed.
resolve that confusion.
Indeed, and so
Yeah.
I've outlined the communication activity that we're proposing in that area.
Sorry, is there specific information for the border communities about the
We're
differences
targeting-
between the ACT and New South Wales?
So our communication strategy is very much about clarifying the New South Wales laws for New South Wales residents.
But not distinguishing them from the ACT laws?
Well, clearly our laws are not ACT laws.
But clearly if you live in Queanbeyan, it's useful to have an understanding of both if they are different.
Sure. I'm sure the residents of Queanbeyan are conscious of the border. But yes, the broad answer is yes. We are clarifying the application of our laws.
Sorry, can I just clarify? Are you clarifying the New South Wales laws, or are you also drawing attention to the way in which they differ from the ACT laws?
I might take the detail of
Thank you.
those communications on notice, perhaps.
Thank you.
And also the cost of the communications campaign.
I will take that on notice. I'm not sure we'll be able to identify a cost, but I'll do what I can. Yeah.
Can I inquire why you wouldn't be able to identify costs for a specific communications project?
Maybe we can. I'll
Okay.
clarify that on notice.
I hope you can. It's government money being spent, so yeah.
It may not.
Okay, thank you.
I'm done.
Okay, I have some questions perhaps for Mr. Tidwell. I'm not sure. Oh, sorry, Sue, were you?
No,
Oh,
you
sorry,
go.
sorry. In relation to experience and operation of 91Q of the Crimes Act, would that be you, or who would I address those
It's
to?
going to be, I'm relieved to advise it's going to be Mr. Knight.
Could you remind me what 91Q is?
It's commonly called the revenge porn sections.
Oh, okay.
And
Yes, yes.
I'm interested really, and I want to put on record that my interest existed prior to the arrival of Ms. Swift on our shores. But there is an emerging problem identified in a number of areas, and particularly targeting young women.
Yes.
Image-based assault, I believe it's been called. Essentially, look, people have always been able to take a photo and alter it. It used to be the scissors and the magazine, but now, of course, there are very sophisticated methods that are available. And if I can, in 30 seconds on the internet, find 2 different ways, believe you me, other people can find a lot more. And I'm just interested whether anybody has looked at whether, 91Q I meant to say, whether 91Q is broad enough to capture those using AI to alter images, and also whether anybody has looked at the adequacy of these provisions to prosecute anybody distributing images made using these AI programs.
That's a really interesting question. I will have to take it on notice.
Yeah, certainly.
Those issues have not come directly to my attention so far, but
Yeah.
that isn't to say that we haven't been doing some work in this space.
Yeah, I believe that one of the barriers to prosecution under that provision may actually be reporting, and I wonder whether this is in a long line of areas where the person who has been harmed feels embarrassed, ashamed, isn't clear of what the reporting lines are, and I wonder whether any work that you investigate could be ways of ensuring those harmed that they're not the ones at fault,
Yes.
and that there are remedies available for them, and they are doing the right thing by bringing these things to the attention of relevant authorities, and they will
Yes.
be heard and listened to.
I think that's a really constructive thought. I mean, some of that is for the police and police practice.
Absolutely.
But these are issues also that I think we take very seriously in a broader context of combating sexual assault and sexual crimes. There is a comprehensive government strategy around sexual assault and to take a strategic approach to these issues. That sits in Ms Campbell's area. She might be able to give you a bit of detail.
Yeah, so under the New South Wales Domestic and Family Violence Plan, which is 2022 to 27, there is there's a number of actions, obviously, in that plan, but one of them is the development of resources to assist parents and caregivers in having conversations with children and young people about in-person and online sexual violence, respectful relationships, coercive control, consent, and pornography.
What's being done in the area of pornography? Because that is a major driver of violence against women.
I'm happy to take that on notice,
Thank
but
you.
I know there is quite a little bit of work going on that. And
Yes.
I think your comment around AI and those sorts of things is a real issue in this space that we're really examining more closely at the moment.
Great, thank you. I'd love to be updated on that. Thank you.
Could I just ask one, a very broad and slightly open question to Dr. Cocaine? I just wondered if you could assist the committee by telling us how you think your office and commission is tracking and what are some of the key immediate priorities that you're focused on at the moment.
Thank you very much, Ms Higginson. I would say we're a work in progress. This is a brand new government modality. We're only the second jurisdiction in the world with this kind of function. Soon to have a federal commissioner as well, which will also change the space we operate in. The legislation is being brought to life thanks to hard work of my team of about 12 and the considerable support of the department that backstops us administratively. Our priorities at the moment are set out in our strategic plan that was published in June of last year. So they're 5: building prevention capacity, enabling remedy, fostering responsible business practices, changing the narrative, and fostering a community of purpose. So in each of those areas we're now developing project work. For example, in building prevention capacity, we're beginning to look at the ways that frontline government agencies provide training and support to frontline workers. We have a new project called It's Healthy to Fight Modern Slavery that's working with healthcare providers, both public and private, in that space. Around fostering responsible business practices, the legislation, the Modern Slavery Act of 2018, gives me a monitoring role in relation to over 400 public entities, all New South Wales government agencies, all local councils, 10 universities, state-owned corporations, a number of others. They have now existing mandatory modern slavery due diligence and reporting obligations. So we've just worked with them for the last year and a bit to develop a 200-page guidance document and a public spreadsheet that allows them to understand which categories of goods that they're procuring may be high risk, and then the guidance sets out the detailed steps that they should take in order to meet their statutory obligations of reasonable steps. And then also sets out various reporting obligations. We have work emerging around renewable energy value chains. The Act gives me a power to develop codes of practice. So I'm developing a code of practice with the Clean Energy Council, again to provide comfort and assurance to actors in the market to know what does good due diligence look like, how do we manage risks along those value chains. We're also developing a community of purpose, as I said, so working with the sector and in particular trying to centre the voices of people with lived experience. So we have an incredible lived experience practice lead in my team who's an employee of the department, someone with lived experience. We have an advisory panel of about 29 people, of whom 20% have declared lived experience. There may be others who do or do not have declared lived experience. And we're working with all of them to try and bring their voices into the policy development and programming space. We have a policy role, so over the last year we've developed 10 different legislative and departmental inquiry submissions, 2 annual reports and the strategic plan. We've undertaken 7 regional visits around the state to date. We think it's very important that I'm the New South Wales Anti-Slavery Commissioner, not the Sydney Anti-Slavery Commissioner, and risks look very different in different parts of the state, different communities. There are different vulnerabilities, which means people are being exploited in different ways. I think for me an overarching priority, Ms Higginson, is to think about how we improve reporting, something that's come up in the discussions today in a number of contexts. We believe there may be as many as 16,400 people in New South Wales who've suffered modern slavery, but on average the Australian Federal Police, which is the main reporting channel, gets about 100 reports from New South Wales each year. So this suggests to us that between 80 and 98% of cases are simply not being reported. And there's a variety of reasons for that. One is simply people are not comfortable to come forward. They fear retaliation. These are people who are being treated as if they're owned by another person. That's the golden thread in a way in modern slavery offences. So they really face a hard time coming forward. And then when they do come forward, they may not be understood or believed. We may be missing cases that are presenting, but people are not self-identifying as victims of modern slavery. They're presenting as victims of domestic family violence, workplace exploitation, domestic abuse, those kinds of things. So this comes back to the point that we need to train up frontline workers, and we see a good initial response from police, from healthcare, from other actors to lean in on that issue, but there's a lot of work ahead. So as I said, very much still a work in progress.
Is there any relationship, it's always tricky, you don't want to ask the wrong question, do you see any need, I'm getting to a human rights perspective here, the fact at the moment New South Wales doesn't have a human rights legislation in a sort of single place, whereas states like Queensland and Victoria do. Is there anything that has come up through your work that would suggest that that is something that could be beneficial to your work? Obviously, in addition to the Modern Slavery Act and your office is.
Yes. We try to include a human rights perspective in all of our work and our policy analysis. There is a human right to be free from modern slavery. That's a right incumbent on Australia. As you say, we have a federal system, so there's complexity in how that translates to our jurisdiction, but that's a right that exists for people in this country. The right to be free from slavery is one of the 3 rights in international law that are applicable at all times in all places. There is no derogation from that right whatsoever. But I think the second part of the question is about operational response. So what we see at the state level is that state governments control a number of the services and activities and assets that people need access to when they're trying to exit and recover from modern slavery. So that's things like access to housing, access to healthcare, legal aid, other forms of support. A human rights perspective can be helpful, for example, in the housing context, to think about when it is that people should have a right to access crisis transitional housing. But I think it's also fair to acknowledge that it only gets us so far. To state that there is a right doesn't tell us how we can realise that right. So we have an important conversation going on now with Homes New South Wales to think about, for example, how we can achieve anti-slavery objectives through all of the important work that they're developing.
Fantastic. And so is there any, in terms of you were suggesting that there aren't many other commissions or offices elsewhere where, and the lived experience is clearly something that is instrumental in feeding your programs. Where else have you had to look and access for best practice and the things that you've managed to develop, some of the things are, incredibly impressive. So where have they come from mostly?
Thank you for that positive reflection. We look a lot to our international partners. I'm very fortunate to have spent a large part of the last 2 decades living and working in the United States, which has quite advanced programming in this area and quite active involvement of people with lived experience. There was a visit recently by the US ambassador to counter trafficking in persons. We engaged with her. We helped a number of people with lived experience, including First Nations people with lived experience of practices that today would be called modern slavery, engage with her to understand also what's going on in the United States. There's some important activity in the United Kingdom as well, a number of a very active civil society in the United Kingdom. That's the other jurisdiction where there has been an independent anti-slavery commissioner. So I'm in close touch with the incumbents and know several of the former anti-slavery commissioners. So I think the other thing I would say is that we look adjacent. So there's a lot of work in the domestic, family and sexual violence space where we can learn a lot from the ways that they engage with people with lived experience. I have regular interactions with Commissioner Cronin at the federal level and with Hannah Tonkin, Dr. Hannah Tonkin, the Women's Safety Commissioner in New South Wales, to discuss how there are intersections between the work that we're all doing and how we can support each other.
Thank you very much. Do you have
I just have probably two questions following up Dr. Cockayne, and perhaps this is the start of a conversation, I understand. So, as I understand it, you're focusing on modern slavery in the supply chain?
It's one of our areas of focus, yes.
And if the product, for want of a better word, is suspected to be a product of slavery overseas, that's of concern?
Yes.
So, and you've identified the difficulties with reporting. I've been made aware of, I don't want to overstate it, possibly something in the region of 5 to 10 cases a year where people travel from New South Wales overseas and receive organ transplants. They've, at least on one occasion, as I understand it, been able to book in for a heart transplant in 2 weeks' time. And there are well-founded concerns, as far as I've been able to establish, that those providing the organs are not doing so freely. Is it possible to establish some sort of reporting mechanism so that health practitioners who come into, I mean, there's no point explanting the organ, but so that health practitioners who come into contact with those people are able to perhaps report to your office, and then we could look at how these supply chains are being advertised in New South Wales. Is that something that you could be working with?
Yes, so they can report to our office at any time.
Great.
There's, depending on the exact scenario that you're outlining, it's possible that there's a violation of the Human Tissues Act in New South Wales,
right.
Which is listed as one of the modern slavery offences in Schedule 2 of the Modern Slavery Act.
Yes.
Now, the Act gives me quite considerable discretion about what to do with information I receive, so I may or may not choose in any given circumstance to pass that on to police. There might be good reasons not to.
Yes.
I don't, however, have investigative power of my own in specific cases, but on general issues, the legislation says I can certainly consider it and then report to Parliament. So there's a number of things we could potentially do to support people in that circumstance, and I'd welcome any approach.
Great, thank you. I may be in touch if that's okay.
Please do.
Thank you very much.
Thank you.
All right, I think we've come to the end of our questioning today. The government are indicating they have no questions. So thank you all.
Can I just
Yes.
interpose? I have the answer to a question I took on notice earlier about 91Q, and I'm pointed by colleagues to 91N, which describes the coverage of that section as including an intimate image that has been altered to appear to show a person's private parts or a person engaged in a private act. So there's an extended definition for that section that allows.
Look, that was my reading of it, but it's lovely to have that confirmation. So my understanding is it would extend.
The information come from the DPP, so I think it's particularly
great,
authoritative.
Great, thank you.
I also have a response to a question on notice in relation to the referral of 93Z matters from police. In relation to the balance of the 9 matters that we spoke about, police were given advice as to sufficiency in those 9 matters. No charges under 93Z have been laid by police in respect of those matters. We don't have data going to the time between receipt of those briefs and advice to police. It depends on the complexity of the individual matter. However, the new MOU that was executed last year stipulates a time frame of between 2 to 6 months to provide advice, depending on the complexity of the brief.
Great, thank you.
All right. Is that dealing with all notices? All matters taken on?
No, there was some more.
There were more?
Yeah.
Okay. Well, I'm told there are more questions taken on notice. You'll be contacted by the Secretariat for responses in due course. Thank you very much for coming today.
Thank you all.
Thank you very
All the
much.
best. Thank you.